Any other public comment?
I'm going to read what I have typed up here as well.
Could you introduce yourself,
Your name,
sir?
please?
Yeah. My name is Dr. Brian Patterson, and I live at 11 Giffords Point here in Raymond. Okay. For the past 3 years, we have lived next door to a short-term rental. Most visitors stay for 1 week at a time, but there are times when the house is only rented for a weekend. And throughout these years, we've experienced a myriad of issues that have affected our quality of life. First, for context, please understand something about me and my family. Like you, we try to be good neighbors to everyone. Some of our neighbors are actually here tonight. Good to see you. And as good neighbors, you try and grit your teeth in order to preserve relationships, right? And we've extended this grace to the rental owner next door. But to be transparent, we've grown weary of the repeated issues associated with the short-term rental. Here's just a short list of what my family, which consists of my wife and 4 kids under the age of 7, have experienced. Repeated trespassing on our property. Using our driveway as a turnaround, despite the posted no trespassing signs on multiple trees. It's excessively loud and vulgar music. Vulgar language being used amongst the guests. Tenants traveling at excessively high speeds. An exorbitant number of guests parking on our property or the leading road due to limited on-site parking at the short-term rental. There was one event that had so many guests that I'm not sure if an ambulance could have navigated past the vehicles. Tenants mistaking our house as their rental property, even trying to enter into our home at 1 a.m. in the morning. Has anyone here experienced someone trying to enter into your home at 1 a.m. in the morning? Again, I have a wife and I have 4 children under the age of 7. Tree companies and docking companies being allowed to access my property because it was more convenient for them to access where they were trying to go on the next door neighbor's property. So last week, I decided to write Town Manager Willard regarding our most recent issue. And again, thank you for getting back to me so quickly. But in your email correspondence, you mentioned that Raymond does not have a local police department. And you said, quote, "This makes direct municipal intervention resulting in immediate relief problematic." And I agree. I also received an email from Sheriff Kevin Joyce who said, quote, "It is becoming a common issue everywhere." So, I've done my part as a homeowner and Raymond resident. I've done exactly what the town manager suggested. I've approached the owner on more occasions than I have fingers on my hand. Would you have me direct all future issues with the police directly? Even the sheriff himself has admitted that this has become an issue. I chose to move to Raymond with my family instead of anywhere else in the country when I graduated. And I absolutely love this town, and I love my quality of life here. And I wouldn't live anywhere else. But I've grown weary of the repeated issues. And I look forward to hearing how this is going to be resolved in the future.
Thank you. Any more public comment?
If I may?
Yep.
We do have an address, Facebook address, and I will try to get the documents that we handed to you tonight up on there within a couple of days so that other people can see what we're proposing. Thank you.
Okay. Any other public comment? Anyone on Zoom?
No other hands raised.
Okay.
Sorry, I just wanted to say to Gracie Leavitt,
Love it.
Levitt, I'm
Yeah.
sorry, that I have a trans son, and I'm with you all the way on that, and hopefully in the summertime when we're up, my kids who are very active in GSA can get together with you, and you could work on something together. Thank you.
Okay. Thank you. All right, we're gonna move on to selectmen comment. Anything, Lonnie? All
No,
set?
No, I do.
I'm all set.
I know we're not talking back and forth. I know
Correct.
that. I'm talking to you. But I am hearing more and more, and I know this was brought up to us months ago about the short-term rentals. And now that other towns are actually getting more active in it, and doing things. And we don't have a police department. I'm not talking to them, I'm talking to you. And, but I think it's especially, I'm very anxious to read more information about it. And maybe what we can do is, I would suggest maybe having a workshop at some point, that the board can discuss more once we read more and learn more and find out more options. So that's my comment.
Okay. Anybody else?
Oh, thank you to Rita, and thank you to Shep. Rita retired, Shep retired, and welcome Kathy Goslin. Yes.
Ditto on that. That's great.
Yeah.
Them.
Yeah.
Now I'm done.
All right. Town manager's report.
Thank you. So last meeting I told you about the sidewalk project being completed. If you haven't been down there lately, the grass is in, it looks great. We're getting a lot of positive comment, not 100% comment because nothing's 100%, but the comments that are negative are small things that have to do with construction details like mailbox placement and so forth. We're getting such positive comment, and I think it's such a significant issue for the community that we are considering, that is myself and the Public Works Director, in trying to find a way to extend the sidewalk along Main Street and to promote additional pedestrian access opportunities. It's being used, it's being appreciated, and so once again, thanks to the Public Works Department, thanks of course to our friends at the Maine Department of Transportation for their half. It came out great. So if you haven't seen it, check it out. On another thing that's related to, I guess, quality of life, and I guess to me it's an essential thing, and Kevin Woodbury could talk to you for hours about it, and that's the whole issue of broadband and the lack thereof in this community and surrounding communities. So finally, at long last, and we got two Gracie Levitts, but it's Peter Levitt who always is asking me about updates. So Peter and you all, we finally have the RFP back to the committee that is studying this on a regional basis with GPCOG, pretty much all of our neighboring communities. Now the solution won't be the same for every community because everybody looks at it differently, but we're looking at doing it, in our view, the right way, and that also is probably the most expensive way, but so we'll have information, and that's fiber to every home. We'll be having information for you hopefully very shortly. I don't know if it'll be by next meeting, but they've, I guess, discarded one proposal. They're going to be looking at a couple, three, and as I say, custom tailored by town. Then comes how do you pay? That'll be part of what the proposals address. So that's, I think, some level of good news and progress, finally. The library department transition has gone really, really smoothly. The trustees have morphed, or are in the process of transitioning, morphing into a Friends group. So they're looking for interested people who want to serve on the Friends group. For people who don't know, the Raymond Village Library was a private nonprofit. Now it's a town department as of our last election. And so as a part of that, Allison has become a department head, and we've had positive, great interaction with her. She attended her first department head meeting last week, and she sent you all a report, I think. And so if you have any suggestions or changes you'd like to make, then we can certainly make those. But I think as a start, it's a good report. It's the report that she made to the trustees when she was reporting to them. The $205,533.84 RVL funds were transferred to the town at the end of August for library use. So one more. So in Cumberland County is also doing some study work, and that's on the long-standing, I mean really long-standing issue of can we collaborate as public safety departments for efficiency, service improvements, and cost savings. And so they're using some ARPA money. I think I've told you about that. And that RFP is now out, and the proposals are back, expected back shortly. And so we'll see what it is that we might be able to do. And the proposals are not coming from Maine, because this doesn't happen in Maine. It's very common in the Midwest and in the West, but also somewhat in the Southeast. And so I think many of the consultants are not from New England, and so we'll see what they come back with. And I'm really excited about it because, as Angus King said years ago, does every town need a ladder truck? We don't. Can we work together? We should. There are lots of opportunities, and as I think I pointed out at other meetings, in places where they do this, the response times, the rates that people survive, catastrophic injuries and other health events are greatly improved. It only makes sense. We are fighting one another, trying to find people to work for us, and so that's an ongoing problem. And so let's work together and try to standardize some of our process procedures and utilize our assets together as we make our way on these emergency calls from the origin to the hospitals. So that's coming.
Okay.
Well, thanks to Cumberland County. That's something we don't say very often.
New dates, the
Oh,
dates
no,
of
oh,
the
yes,
next meeting?
dates. Yeah, okay. Confirmed dates, October 11th, November 15th. And then we have the reminder of upcoming holiday schedule, Monday, October 10th, Columbus Day.
Okay.
That's it.
Anything else? Want to thank everyone for coming out tonight. We will definitely take it under consideration to decide how we're going to move forward. Thank you. Can I have a motion to go into executive session?
So moved.
Well, you got to read it
I
out.
make a
Move to
motion
go
to,
into pursuant to 1 MSRA, or MRSA 405-6E, code enforcement violation with Mr.
second.
Second. All in favor?
He's already on the.
Okay, can I have a motion to come out of executive
Move
session?
to come out of executive session.
Have a second? Second. All in favor?
Move to adjourn.
Second? All in favor? Thank you very much.
So welcome to the September 26, 2022 Zoning Board of Appeals special meeting of the town of Raymond. The Zoning Board of Appeals will come to order. The board does have a quorum. I am now going to do a roll call. I'll start with myself, David Murch.
Greg Dean.
Tom Hennessy.
Fred Miller.
Pete Lockwood.
This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all of the exhibits that are presented. Please notify the chair if you're unable to see or hear. The board works from a published agenda and will be considering tonight's items in the following order. Call to order. Number 2, old business, specifically deliberations on the following matters tabled on August 30th, 2022, administrative appeal, re-notice of violation issued 3/10/2022, applicant Gregory P. Braun, Esquire, on behalf of Big Lake Marine. And we will have public hearings on the following matters tabled on August 30, 2022, administrative appeal, re-notice of violation issued 1/28/2022, applicant Lita E. Bratchen. On behalf of Management Controls LLC, and the administrative appeal, re-notice of violation issue 3/10/2022, applicant Gregory P. Braun, Esquire, on behalf of Big Lake Marine. Both of those are for location 28 Whitetail Lane. And then we will have adjournment. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or state law. After the board decides on the merits of each application, it will prepare a written notice of decision. Because the notice of decision may substantially affect any appeals rights and Also, as a matter of courtesy, the board asks that those attending the meeting with regards to a specific application not leave until the board has completed its discussion. Generally speaking, appeals from adverse decisions must be filed with the Superior Court as otherwise provided by law within 45 days of this board's decision. Also, to be certain that you preserve your individual rights to file any such appeal, you must be certain that the board's record evidences your appearances this evening in opposition and the basis for your opposition. All persons speaking, including representatives of the applicant and members of the public, are asked to state their name, their address, and affiliation with the application, either being for, opposed, or neutral. All persons speaking shall address all remarks or questions to the chair. This meeting is not over until the board has formally adjourned. Any discussions not included on the meeting agenda or accepted by the board is to be held until after adjournment or conducted outside of the meeting. So as we've gone through our call to order, we are now moving on to old business. And again, deliberations on the following matters tabled on August 30th, 2022, an administrative appeal, read a notice of violation issued on 3/10/2022. Applicant Gregory Pigron Esquire on behalf of Big Lake Marine LLC, Robert Durant, member and manager. Location 18 Fernwood Road. Description administrative appeal from notice of violation. So Attorney Wagner, you have been assisting our board with these matters. If you would sort of further assist by kind of taking us through these next steps.
Sure. Good evening, everyone. Just a quick heads up, I'm working on a laptop remotely, so I don't have my normal size screen, so I'm actually going to be switching through. So if you're used to me being able to read your facial expressions to respond, you'll just have to shout if it looks like I'm not looking at you, because I'm probably not. So with that, the remaining item of business for this appeal, the 18 for Fernwood for Big Lake Marine, at the last meeting, members Murch, Lockwood, and Miller opened and closed the public hearing and reached a tentative decision to deny the appeal in part and grant the appeal in part. And I have prepared a written decision summarizing the findings and conclusions that the board made, and I circulated that earlier today. So my recommendation is that for this, for reviewing this and voting on it to issue the final decision on this appeal, we keep it to just members Murch, Lockwood, and Miller. Is everybody on the board okay with that?
Yes.
Yes.
Okay.
I just have one question, Attorney Wagner. Do you want us to catch any typos or?
Sure. Yeah. Please go ahead.
Nothing of big content, just.
No, understood. I was under the gun on that one, so I apologize. And I certainly appreciate you flagging those, and I'll, as we have before, make any changes and circulate that around tomorrow so it could be signed.
Stephen, if it's merely typos, I can fix those tomorrow for you and have them come in.
I appreciate
substance, then it's to you.
I appreciate that.
Of course.
So have the members had a chance to read the draft decision?
I did review it. It had one correction that I believe needs to be made. It was for item 6, whether violation 7 should be vacated. That was a 2-2-1-0 decision. This specifically, it was talking about the clearing and removal of vegetation under 3 inches within 100 feet of normal high water line. That was the one where I didn't believe that the town had provided enough evidence that the appellant had cleared the vegetation. So that was the dissenting.
Yeah. Did I accurately capture the vote on the next item, number 7, where I have it as a 2-1-0?
Yes, that one is correct.
Okay, so both of those were 210.
Outside of that, I didn't notice anything else.
Any further comments or corrections from the members?
I have nothing.
Yeah, Steve, if you could just kind of, in item number 7, violation 8, if you could just take a quick look at the second to last paragraph where it says, a minority of the board finds that the town did not submit sufficient evidence to show it was BLM that was responsible for obtaining the permits. I was just wondering why it was worded that way instead of a majority of the board did think, I'm just curious the way that the vote went.
Sure. The intent was to just reflect the views of Chairman Murch and his reasoning, but I agree. I could state it in the from the perspective of the majority and reword it.
I'm fine. I just wanted to make sure I ended it.
John, did you have something with this? Just from the typos perspective?
There was, I'm trying to find it. There's one or two that deal with the vegetation. And I thought when I read this the first time through, the word violation was there where vegetation belonged in the paragraph.
Okay, I will make a note to run through that. Appreciate you flagging.
Oh, yeah, I see that as well, Tom.
Stephen, would you like me to just fix those 2 minor things tomorrow?
No, I'll run through it. Sam,
Okay.
I appreciate that though.
Of course.
So if there's nothing further, then I would suggest a motion to pass the decision as written, subject to those modifications.
So moved. Have a second.
Second.
Any further discussion? All those in favor? David Birch, yes.
Miller, yes.
Yes.
All those opposed? All those abstaining? Great.
Yeah, we'll mark you as abstention, sure.
That's it.
Okay. So that's everything on that matter. So I turn it back to you, Mr. Chair.
Take over. So moving on, public hearings on the following matters on August 30, 2022. Administrative appeal, notice violation issued on 28/2022. We also have a follow-up administrative appeal of notice violation issued 3/10/2022. Both of these were tabled. So I need a motion to take these both off of the table.
So moved.
Seconds.
Second.
For the conversation, all those in favor of taking these off the table, David Rich, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Miller, yes.
Reed Lockwood, yes.
So the first one we will address is the administrative appeal for notice of violation issued 1/28/2022. Baby Garage and Esquire on behalf of Management Controls LLC, location 28 Whitetail Lane, description administrative appeal from notice of violation. So again, Attorney Wagner, you've been great to assist us as we go through these. Can sort of lead us again through the process. Should we take?
Sure, thank you, Chairman Murch. So we'll follow the same process that we have on the prior appeals. So this is a de novo hearing. The board can accept must accept new evidence. The applicant has the burden. You undertake your own independent investigation of the evidence and law. And I suggest that we take the issues step by step as raised in the written notice of appeal and as framed by the attorneys, and I'll guide you through that. We've already established a quorum and we're back to the full membership here. And I'll represent that you have jurisdiction for this, and the appeal has been timely filed, and the applicant has standing. I assume the board agrees with that. Seeing yes.
Good.
Okay, so as we have before, if anybody has a conflict of interest or bias they would like to discuss or raise, or any objections based on conflict of interest or bias, those should be discussed now.
Nothing.
Okay, and the record will note the prior conflict that was raised previously. So as before, the sequence of presentations will begin with the appellant without interruption, followed by questions by the board for the appellant, and then questions by the town and other parties for the appellant's witnesses. And then we'll turn it over to the town and follow that same order. So with that, Mr. Chair, I recommend you pass it over to Attorney Rachin.
So, Attorney Rachin, it is our pleasure to hear what you have to say.
Great, thank you. Good evening, everyone, Mr. Chairman, members of the board, fellow council. As you know, my name is Leah Rachin, and I am here on behalf of Management Control. Just as a threshold logistic issue, I just wanted to make sure it's been written in all of the decisions, and I think that all of the parties, council, agree that the record for one case is the record for all. And so to that end, I did submit earlier today, just so that we have everything consolidated into one repository of information, the record of all of those documents that at least from my clients have been submitted in the prior appeals, and also those that I will be relying upon today. So I just wanted to make sure first and foremost that folks received those, and that those are, you know, I understand perhaps that as we go through that there may be some objections to that, but they'll be handled as we go. But I did want to confirm that everyone received those records, or documents, I should say.
I did, yes.
Just to clarify, this is the you're referencing the DWM law share link that was shared?
Correct.
Yeah.
Yep. And that's more for the purposes of Sandy, actually, to keep the record. I didn't add anything to what was already before the board, but I also included those things that I will be discussing today. But when I'm screen sharing, I will have those documents also readily available so that I can walk the board members through as I go. Okay. All right then. So turning to the merits, obviously this is not the first time that we have met. You've heard lots of testimony, you have heard lots of argument, you've reviewed lots of documents. But I think it's really critical to emphasize before we get into the meat and potatoes of what we're doing tonight is that we're dealing with Whitetail. And Whitetail is a very different property than Fernwood. And so I would ask of you to keep that firmly in mind. As far as the differences, and I think actually those differences are well reflected in the document submitted by the code enforcement officer himself, that the bottom line is that the original state of this property and all of those before pictures, you will see that this property already had extensive riprap on it. And so this, as I said, it's a different property, different considerations. The other thing that I think is very critical to bear in mind is that, again, the code officers before pictures very much demonstrated there was an existing beach on this property. Another piece that is different from Fernwood is that only a portion of the shorefront here on the Whitetail property was impacted, and less than 100 feet of that shoreline was affected. whereby there was actually a permit by rule that was sought for that portion of less than 100 feet. There's another small stretch, and we'll be talking about this as I go through, but that there was existing riprap, and all that was done essentially was to add some riprap on top of the existing riprap, which in essence is really maintenance of the existing riprap. And finally, it's also important to note that a very large portion of the property and the shoreline was not disturbed at all. So again, different property, different factors, and I would just ask that you be mindful of those things. Excuse me. And so, as is the case with our prior appeals, I just want to talk about there's some themes here at play, and I'll round those out a little bit more fully, but just to set the stage. The first, of course, is that this notice of violation was issued to the wrong person. We've talked about that before, and I'll get into it a little bit more. The second, of course, is the duplication of the various violations, and it's our submission that it really is just a blatant overreach and an attempt to increase fines, both collectively as to the number of parties who are being tagged for the same violation, and also even within the violation itself, you'll see that there are numerous violations that are actually related to the same exact activity and the same exact provision of the shoreline zoning ordinance, which is purported to be violated, is cited for multiple violations. And so I know you've heard this before, but I just wanted to reiterate that this is clearly a tremendous amount of duplication that is unnecessary here. The next piece, and we'll get into this more as I examine the witnesses here, is that the evidence simply does not support a conclusion that a number of the alleged violations actually occurred. And we'll get into that as we move through. Another thing to keep in mind is that the notices of violation, all of them here, that's just a characteristic of any notice of violation. In addition to outlining what the alleged violations are themselves, another critical component of that is to talk about the corrective measures or corrective actions that will be required. And it's important to understand here that almost immediately when my client became aware that there was a violation, they reached out to the DEP, to the town, talked about how, okay, we need to remedy this, and in fact, hired an expert to do that, who submitted several after-the-fact permits to rectify. Again, we're not admitting that there were in fact violations, but in order to work with the town and to make sure that we were addressing concerns, did that. For whatever reason, the town found that particular expert's submissions to be unacceptable, not in any way conceding to the fact that that's the case. Again, in an effort to satisfy the town that we were taking all necessary steps to have a property that was in compliance, retained another engineering firm to submit an application for the restoration work, for various after-the-fact permits. Again, that was rejected. So we have been trying at every turn to meet the town's expectations, and at every turn we have been rebuffed. And so I just wanted to make sure that that was also clear for context. So back to the argument of the wrong person, okay? I'm going to bring up, am I able to, can you allow me to screen share, please? Can I do that?
Chair's perspective, yes. You are.
Okay.
You can certainly do that.
And are you able to see these submissions here?
Yes.
Okay. And so right here, I just wanted to focus in on this. The document you've seen before, but it bears emphasis that this, as you will see, is the contract between Big Lake Marine and my client Management Controls, and this is with respect to the White Trail property. As you can see, the very first entry, the very first requirement of this contract that is that Big Lake Marine will obtain all necessary permitting from the town and DEP. That was an extremely important criteria for my client. It was clearly specified right up front. It was the primary obligation. And as we know, unfortunately, we're here, that was not met. And it's also critical to understand that my client reached out to who they thought was the premier shoreline contractor in the area. And here, are you able to see my screen here? I just want to make sure you can see that this is an excerpt from Big Lake Marine's website. You can see that? Yes, okay. And so clearly, what we do, Big Lake has become the premier waterfront service company and offers a variety of services. So relying on a contractor who's the premier waterfront service company, and again, the first thing of what they do, permitting services, state and local. So again, just to emphasize that my client reasonably relied on the contractor to, in fact, secure these permits. Excuse me. So the second argument that we have talked about before, but I also want to make sure that we talk about it again, is the duplicative nature of the various violations. I'm going to stop sharing my screen for a moment. As with the Fernwood property, the NOVs relating to whitetail are replete with examples of overreach and duplication. And when, as I said, look at both collectively and individually, that it's very clear that, the town is attempting to get fines for, to exponentially increase the amount of fines that they could get by essentially duplicating, duplicating violations that in fact really should be consolidated. And we've talked about this before. I'm going to say it again. Why does this matter? It's really important to understand that we're not here simply just to parse an NOV. The reason why we're here is because the stakes are very high. As you are maybe well aware, the town is threatening fines in excess of, at this point, I think it's $2 million. And according to the town, those are accruing every single day. We disagree with that, but yet that's the town's position. And so, that's why we're here. We want to basically make clear that this attempt to artificially inflate both the number of violations and the extent of these violations, and especially by refusing to even entertain our after the fact permits, which were the very requirement of the corrective action, is just really problematic and very much unfair. And so that's the context in which we're dealing with these issues. And I want to make sure that everybody's aware of that. And so I can go through at this point, and actually I think for purposes, I may just hold this off to our summation as to the consolidation and what the request is there for consolidation. That probably is the most efficient way of going. But the third thing that we want to talk about is, as I said, the fact that some of these alleged, in fact, many of these alleged violations are not, in fact, violations, and the evidence will show that, hopefully, and then we submit it will throughout these proceedings. And so what I'd like to do is actually call the first witness to go on and basically put on evidence as to why the notices of the violation and the alleged violations simply are not substantiated.
Sure, that would be fine from the chair.
Okay. And so in that regard, I'd like to actually call Alex Soroy as our first witness.
Yep.
May I proceed?
My perspective, yes.
Thank you. And so, Alex, can I call you Alex? I know we've been doing this quite a bit. Are we there yet?
Sure
can I call you Alex?
Yeah.
Okay.
I think so, yeah.
Okay. Thanks. And we know you are the code enforcement officer.
Yep.
And I think we did talk a little bit about your educational background, but just refresh our memory if you would.
Yeah, I'm a state certified code enforcement officer.
And as far as your undergrad background, can you discuss that?
I have a bachelor's in communications.
And do you have any degrees or certificates in environmental engineering?
I do not have a degree in any type of environmental engineering, just through the state certification process.
Okay. And how about, same question for, what about surveying?
Same answer. I don't have any degrees or anything in surveying.
And what about geology?
Nope.
And civil engineering?
Nope.
Okay. And so can you tell us a bit about when you actually first became aware of the work that was happening at the Whitetail property?
Yeah, October 14th, 2021.
And how did you become aware of that?
We received multiple emails, the first of which from Alexis Savavalos from DEP and the second from the Deputy Fire Chief.
Okay. And what was the concern of the fire chief? I'm not sure we've heard about that before.
Yeah, they actually drove by the property on the fireboat later on in the afternoon.
And from a fire safety or emergency services perspective, is that something that they were concerned about, or was more just a heads up this is happening?
Yeah, I think they noticed it, and it was clearly something that didn't seem right in their eyes.
Okay. So you noted, I think you said you got some emails on the 14th of October. When did you actually attend at the property?
I believe, without having it in front of me, the dates in front of me, I believe it was October 26th.
Okay. And who was there with you?
We met with DEP, both Jeff Kalinich and Alexis Savavalos. We also met with, at the same time, Rob Durant and Nathan Whalen from the Portland Water District. I believe that was everyone.
Got it. Okay. And so when you did go on site, what equipment did you bring with you, if any?
Equipment, I think I probably just had my phones. That was probably it.
Okay. And have you ever obtained a survey for this property, the town?
I'm in receipt of a survey of this property, which was given to us by either the property owner or his engineer.
Okay. And are you referring perhaps to I'm just going to bring it up. I'm going to share my screen if I can. You able to see it?
Yeah.
Just so we're talking about the same thing. Is this the survey that you're referring to?
I believe so.
Okay, I'll make it smaller. And in fact, it's not just a survey, but this actually indicates that it was approved by the town's planning board as a subdivision plan. Do you agree with that? I'm looking, scrolling up here. There's a signature
that's
block.
the subdivision plan. Yep.
Yeah. And so it's both a survey. Can we agree that it's both a survey and the subdivision, an approved subdivision plan?
It does appear to be, without reading all the notes, but it looks as though it is.
Okay. All right. Thanks.
There's also a more recent one that I've seen since that shows the shorefront prior to the work that's been completed, and then it also shows a shoreline after the work that was completed.
Okay. All right. So when you were at the property that day on October 26th, I think you said, with all those folks from DEP and Durant and his representative, did you actually consult a survey of the property that day? Did you have a survey with you?
No, we didn't. I didn't have that. Then the survey I just mentioned, the subdivision plan we had on the file, but the survey that showed the normal high water mark prior to work and after work, I think I was just given that like 3 or 4 months ago.
Okay, thank you. And then when you were actually drafting your notice of violation, did you have that survey plan, the 2007 plan with you?
Yes, yeah. We did review that before issuing the NOV.
Okay. All right. And when you actually were preparing to go to the site, did you do any preparation? Did you speak with anybody about, what it was that your task was, or?
Can you be more specific? I would say yes, but I don't think that's the answer you're looking for.
Okay. Well, I guess let me drill down a little bit. So with whom did you speak in preparation for that meeting?
I think I spoke with my assistant, Chris, and my town manager. I think we also may have, I can't remember if we spoke on the phone with folks from DEP or not prior to, I can't remember. I don't think we did.
Okay. And to the extent that you can recall, can you tell me a bit or the board especially about the substance of those conversations?
Just that, we felt it was, based on the photos, it was a very serious violation. And it was definitely one that we were going to need to likely retain legal counsel for. And we may have, I don't think we did speak with the attorney prior to, because I think we had inspection photos when we spoke with the town's attorney and realized that there was a conflict. So yeah, that wasn't prior to that site meeting.
Okay. All right. And so were you able to determine when work actually commenced? Durant was there, correct? I mean, he was on site. Did you
Yeah.
get a sense of when that work commenced?
Well, no, what I do know is the before photo taken from the drone was taken in August.
That was,
so I
and
know.
let me just be clear, the drone photos, that was taken by the Portland Water District, correct?
Yep. Yep.
Okay,
Correct.
so fairly soon, if those were taken in August, you attended on the property or heard that there was some work being done in October. So fair to say at some point in September, early October.
Yes. Yeah, I would say that's fair.
Okay. And do you have any sense of how many days it continued?
From what I can tell, work stopped at least by the day that we visited the site on October 26th.
Okay, but let me just be clear. You had said that you had been told or been notified by folks on October 14th. You attended on the 26th. Are you aware, do you believe that any work was conducted between October 14th and the 26th?
I do think so, yeah.
And what leads you to that conclusion?
Just based on the photos that we received from DEP and what the site looked like when I visited it on the 26th. When we got to the site, it looks as though it basically does today. Nothing's changed from that day. I don't believe any work's happened since, but I don't know that, I don't know that work didn't happen between October 14th and the 26th is what I'm saying.
Fair enough. And just to put a finer point on it, when you became aware on October 14th that this work was happening, because you were notified by others, did you reach out to either the property owner or Durant to say, hey, hold the phone? Or you obviously had some communication because you had to set up this meeting on the 26th. Can you tell me about
that was the conversation. It was, definitely need to hold up. There's no town permit and we need to meet on site ASAP.
And when do you have a sense of when, as between the October 14th and the 26th, that conversation happened?
I don't know off the top of my head. I could look, but it was pretty quick. Either on the 14th or the next day. It was pretty quick after that.
Okay. And at some point, you issued what we could call a verbal stop work order, basically stop.
Yeah.
And can you pinpoint roughly when that was?
I believe it was that week, the week of the 14th.
Okay. Okay. And that stop work order has remained in place?
No, there has been a demo permit issued for both properties.
I understand. I should say, when you say demo permit, just to clarify, that was with respect to the house, internal to the house, correct?
And the hot tub area for Fernwood.
But nothing with respect to the riprap, the stabilization work, correct?
Correct, yeah.
Okay, all right. And I think you said, and you'll correct me if I misunderstood you, that since that you basically said stop all work in the shoreline area, that has been abided by, correct?
Yes.
Okay. I think you mentioned you did not take the before shots. Everything in your submissions with respect to your exhibits, to your notice of violation, all of those photos, as far as you know, were taken by the Portland Water District, correct?
The before photos are all from the Portland Water District, yes.
Okay. And when you, and then a lot of the after photos that are so-called in your notice of violation, and I think in the slideshow, those were all taken by you?
Either by myself or submitted to us from DEP.
Okay. And the ones that were taken by you, did you actually make an effort to take them from the same angle, same perspective as those that were taken by the water district?
No, I actually hadn't seen most of the Portland Water District photos that first time we were on site.
Okay.
Actually, I was given it that day. Nathan gave us the drone photo that afternoon.
That day, meaning the 26th?
Yes.
Thank you. Okay, understood. All right, and so just as a general proposition, I'm not talking about this notice of violation, I'm talking about notices of violation generally. That's the world you live in, right? Is it fair to say that the purpose is at least twofold? First is to very clearly identify for the alleged violator the violations, basically what they did wrong. Basically say to them, hey, this is what the problem is, right? Is that a fair characterization? And then the second equally important part of those notices is to identify what they have to do to correct those alleged violations, and in essence, how they can come back into compliance, correct?
Yep.
Okay. All right, so let's go to the notice of violation, start working our way through that. And I'm gonna share my screen if I can. Okay. So just with respect to this first violation, violation number 1, and this is for filling and earth moving in more than 10 cubic yards, correct?
Yep.
And I'm reading from this notice of violation that basically the premise here is that there was a significant amount of soil disturbance, correct, within 100 feet of the normal high water line?
Yeah.
Okay. And what efforts did you make to actually determine where that normal high water line was?
Observe change in vegetation. Visually is what we would look for in a situation like this. That normal high water mark would usually be set by a state licensed surveyor.
Okay. But you didn't have it. So you were doing it by visual indicators. You didn't have a survey yourself, correct?
Yeah, that 100-foot distance that I am mentioning is based on the water line observed that day.
Okay. All right. And how did you measure? How did you measure it out? Did you actually use any equipment, or it was all just visual from your perspective?
The approximate distances were measured through just the measure app on a cell phone.
I'm not familiar with that. Can you walk me through what that means and how you use it?
Yeah, so basically any iPhone has a distance measurement tool included with it that's not 100% accurate, but is usually pretty close, within a foot at least.
Okay.
And for situations like this, it's a quick, easy way to get an approximate measurement.
Okay. And tell me this, we're dealing with volumes of material like loam and riprap, correct? So
Yep.
Tell me what did you use to actually measure the amount of, a supposed loam and riprap? How did you come up with that calculation that was more than 10 cubic yards?
I just based it on 2 inches. If someone had gone along and just pulled back all the grass, which was basically what was done on whitetail, all of the grass was ripped up to the left of the house and along the shorefront. If you take a 50 by 50 foot area at 2 inches deep, that exceeds 10 cubic yards.
And how do you know it was 2 inches deep? Did you measure?
Definitely just kicking with my toe in the ground. That's how much moved around. I think it's pretty clear that just with that alone, they exceed it. And then you add in all of the riprap that was deposited on site and the mulch that was put on the berms, around the banks. They probably well over, hundreds of cubic yards at that point.
Did you, so you didn't actually measure, you said you toe kicked, right? What about with the riprap? Did you toe kick the riprap?
No, I definitely didn't, but I think it's pretty clear based on the height of that riprap and the length. Those numbers could easily be added up to calculate based on the diameter of the rocks that was added, that they greatly exceeded 10 cubic yards.
And you had mentioned how they had ripped up the lawn, and when we're talking about the lawn, I'm just gonna let me go to some of these exhibits here so we'll make sure that we're talking about the same place. So bear with me. When you're speaking about this ripped up lawn area, is it this area? If I'm looking at the house from the water on the left-hand side, is that what you're talking about there?
Yeah.
Okay. And so are you aware that that is where the staging area was for all of the equipment that
Yeah, that would make sense.
And so basically just traveling back and forth in that area could possibly damage. And I'm looking at this lawn area. It's certainly, at least from my perspective, you've got some blank patches here. This is just, it's certainly not a manicured lawn. Would you agree with that?
Yeah,
And would you agree that by, you know, basically using equipment that's going to possibly damage some of that area, but it's not an actual act of physically ripping up the lawn? Is that fair to say?
I don't know. If you look at the after photos, it looks pretty well graded to me. I mean, I'm not seeing any large ruts. I don't know if you could point to any that you're seeing for where equipment may have been parked. You know, there's also a very significant difference when it comes to the rules on what's allowed when there's a permit issued and not. You know, if a permit had been issued for this activity, it's possible they could have used it as a staging area, and you know, it wouldn't be necessarily considered a violation at that point.
Okay, and I'm looking, you know, again, I'm looking at your Exhibit A here, where this area is, and I see, you know, there's still plenty of area. I mean, if you look, can you see where my cursor is here?
Yep.
So we've got leaf litter, we've got, looks like little pieces of lawn here that are just coming up through.
Mm-hmm.
Would you agree with that? You agree with that?
Yeah, I mean, I think you could see that if you look hard enough.
Mm-hmm. But you can see it, is what I hear you say.
Yeah, I mean, the issue is if you look back at the NOV, this particular violation is not as much about volume and you know, disturbance. It's really more about this activity taking place without an approved erosion control plan, which I think is the real issue here. Is, you know, this work should have had an approved erosion control plan in place, permitted or not, and they did have erosion control on site, but there's no approved plan.
So let's talk about that for a minute. You're aware that various PBRs or permit by rule applications were applied for, correct?
Yes.
And part of that, and this is the one, actually there was 3 for the different properties. So let me get to the one for Whitetail, okay? So this was applied for, and part of the description talks about how there's erosion control measures per DEP requirements, correct?
Mm-hmm.
And you see that right here on the form?
Yeah.
And I believe in the notice of violation, you talk about best management practices for erosion control that are based on DEP's regs, is that correct?
Based on the Maine Erosion Control BMPs for Bureau of Land and Water Quality, Maine Department of Environmental Protection,
and would
March 2003.
Would those not be the same best management practices that would have to be used in conjunction with a permit by rule?
Could be. I'm not sure. I don't enforce NERPA, so I'm not exactly sure what it is they look at, to be honest.
Okay, so it is fair to say that, you know, with respect to that permit by rule, that they were following erosion control best management practices in conjunction with that permit.
Yeah, but the section in the ordinance, I guess if I'm going to disagree, doesn't say that, you know, they just need to get a file for a permit by rule. The town wasn't ever given a copy of this erosion control plan that they had prepared at the time of this particular violation taking place.
Okay.
And I think that's the difference here for us.
And just following up on, I think there was some testimony in past hearings about in part of your materials, there were some pictures of silt fences kind of not rooted down into the riprap, and that were possibly, you know, not secured sufficiently, correct? Do you remember that?
Yeah.
But I think you had said that work had stopped, and those pictures were taken after the work had stopped, correct? So that could have just happened when folks weren't there every day after the work had actually stopped.
I would go to page 16 of the NOV.
Mm-hmm.
Where there's active work taking place on site, and you can see there's a section where the silt fence is on the ground, about 25 feet or so from which looks like an excavator.
Can I just ask, Alex, so everyone's looking at the same thing. When you say page 16, I don't have pages, I have exhibits. So.
Yeah, it would be exhibit E.
Mm-hmm.
Yep, this photo right here.
Right. And when was that photo taken?
That I'm not sure. This was one of the photos that was given to us from Alexis. I would assume this was taken on October 14th, the same day she took the photo of Fernwood. But here you can see, this is the time where we would want the silt fence in place the most, because you've got all that soil on the bank. And if we got a substantial afternoon rainstorm, that's all headed into the lake.
Okay, but you don't know, I think I heard you say you don't know exactly when that picture was taken, correct?
Yeah, I'm not necessarily understanding why that would matter, I guess, is what I'm saying.
Okay. All right, let's move on to the second violation number 2, okay? So essentially, the violation number 1 is filling and earth moving of more than 10 cubic yards, correct?
Yep.
Violation 2 is the same activity, filling and earth moving of more than 10 cubic yards without a permit, correct?
Yeah, correct.
And so it's basically, in essence, the same activity we're talking about with respect to violation number 1.
Yep. I mean, essentially, we just did that to. I like to do that to make it easier for people to break down the areas of the project where activity is taking place. So this is, again, in that same activity. However, the first section was for the lack of the erosion control plan. The second section is actually the violation for doing the work without the permit.
Okay, so when you say section, we're talking about the section of the notice of violation, not the section of the shoreline, right? Just to be clear.
Section of the shoreline zoning provisions specifically that they're in violation of.
Okay, but all right, so it is, I heard you say it's the same activity. And, I already asked you lots of questions about violation number 1. You are aware of your obligation to tell the truth with respect to the answers. And you testified truthfully with respect to those questions I asked you, correct?
Mm-hmm.
And so if I were to ask you similar questions based on the same activity for violation number 2, would your answers be the same?
Would they be the same? Is that what you said?
Yes, with respect to.
Yeah.
Okay, and so I'll move on then, so we don't have to. So with respect to violation number 3, this is piers, docks, wharves, bridges, and this is with respect to the boat launch. Okay, and so I'm going to direct your attention to Exhibit B, which is the photograph that you submitted in support of your allegation that the boat launch was expanded, correct?
Yep.
Okay. And so in that regard, I just want to make sure that this heading relates only, this violation number 3 relates only to the boat launch area, correct?
Let me just take a look. Yes.
Okay.
That is correct.
All right. And so we're not talking about construction here. We're focusing, I think your words were expansion or enlargement, correct?
Yeah.
And so there's an acknowledgement implicitly that this was a pre-existing boat launch area, and you can see it here. You see that area here and here.
Yep.
Okay.
Yep.
And did you determine the high water line relative to this violation?
No, the high water line would have been determined on site, just visually, and that would be probably best displayed by the after photo.
But you were saying you did it in the same way. It wasn't by measuring. You didn't have a tape measure. It was by visual inspection, correct?
Yes.
Okay. And the violation itself, going back to it, it talks about extending over or below the normal high water line, correct?
Yeah, expanded at or below.
Okay. And so how much was it expanded over or below the normal high water mark?
Well, the language there is expanded at or below. So we know it was definitely expanded at the normal high water line that we, inspected the day of, which is clearly shown, I believe, in the before photos where you see 2 pallets end to end, and then the boat launch that exists.
Alex, I'm sorry, I'm not following. Say that again. In the before photos where you see what?
Yeah, so if you look at the boat launch, if you want to call it that, in the before photos, it was a old wooden structure That was.
And you're referring to this, which I have my cursor on, correct?
Yep, which looks like 2 wooden pallets, end to end. And what's there now is no longer wooden. It's made out of riprap.
But is there anything? I don't think in your notice of violation you made any distinction about materials. It was just the expansion of the area, correct?
Yep, the use.
Okay. And so, as I said, we're talking about a use that's extending over or below.
At or below.
At or below.
Not over.
Okay, I'm sorry. I think the language is over or below if we're looking at the language, but we don't need to.
Yeah.
But I'm trying to determine, in your notice of violation, you talk about how it was expanded in this way. So I'm trying to understand by how much, exactly how much was it expanded?
I would say it's approximately 16 feet wide now, and was, from what DEP and myself have been able to determine, probably no wider than 8 feet before. Unfortunately, we don't know exactly how wide the previous wooden boat launch was because it's no longer there.
So you don't have precise measurements for how big it was at the time, correct?
We don't have precise measurements for how big it was.
I'm going to object to that. He just testified, and you can't contradict his testimony because you don't like it.
I'm not aware I was actually doing that. But bottom line is, I had asked him what was the degree of expansion. I heard him say he did not have measurements from before. And so by definition, it's difficult to understand how far it's been expanded.
He said he estimated it was 8 feet.
I believe we actually used this photo right here. This is the one that Jeff Kalinich and I had actually talked about because we looked at the stairs. There's no way that set of stairs to the left is any larger than 6 feet or 8 feet. And it looks to be just slightly smaller than that, boat launch. So by that, we figured there's no way this thing was any larger than 10, and we figured it was probably around 8.
So let me just, I need to catch up with you, Alex. So you're talking about this set of stairs here, correct?
Yep.
And you estimated that to be six feet or so?
We figured it was no wider than 6. And that's based on, average aluminum dock stairs like that, or no more. No, usually 4 feet. 4 feet's the allowed width. So we said, okay, maybe they're 6.
Being generous, 6 feet, fine. So we're going to move along to here, which is the expanse of the boat launch already, correct?
Yep.
I'm not sure how you're getting. We don't need to dicker around this, but the bottom line is, you did not have.
Well, I mean, I do think it's important. I think what you're trying to say is we can't prove that it's been expanded. Is that what you're trying to say?
I'm not trying to say anything. I'm asking you questions about what your measurements were based on.
Yeah.
About
so
how it has expanded.
Okay. So then to answer that question, we based it on photographic evidence from the site previously existing prior to the work. We used our opinion based on the stairs and what looked like a rowboat we figured at the top of the dock, and use that to kind of estimate what we believe.
That was how you were scaling it out, so to speak.
Yeah, unfortunately, we were never invited to the site prior to the work being done, which had we probably could have, but we weren't, as you know.
Okay. And these drone photos, right? These are the drone photos, the before ones, correct?
That's a drone photo. The photo we were just looking at actually was taken from the water by a Portland Water District intern. I believe that was 2000. Can't remember the year, 2014, maybe that one. But this is the drone photo. This is August, yeah.
And they don't come with any scale or anything like that. So you're just making your best guess, essentially.
We actually may be able to do that. I can find out about that. I know the company has specific GPS coordinates on everything.
Right here, right now, you don't know, correct?
No.
And when you were issuing your notice of violation, you did not
know? No, just based it on like I explained a minute ago.
Okay, fair enough. All right, moving on to violation number 4. So once again, this is based on the same provision of the ordinance, the land use table. Talks about piers and docks and wharves, but in this case, we're talking not about the boat launch, but the shoreline itself, correct?
Mm-hmm. Yeah.
Okay. And I'm just going to go to that table. Bear with me here. Okay. And so we're talking about this section here. This is the land use table, correct? And this is the provision 17 that we're talking about. And so just from a conceptual standpoint, when we're talking about land use tables, the point of these is basically to talk about, basically it enumerates, it's a list of the various kinds of uses or structures that either here are allowed, not allowed, and then it specifies who the appropriate authority is to grant a permit in that case, correct?
Mm-hmm.
Okay. And so subsection 17, it references piers and docks and wharves and bridges and other structures and uses, right? Extending over and below the normal high water line. I don't see it saying the shoreline itself is a use or a structure. Is it your submission that it is in fact a structure or a use?
Let me just take a look here. I want to see where you're at.
Sure, right here.
And this is in 4, right?
This is section 14, table of land uses. This is what you, you're no, it is violation 4, correct?
Yeah. So what we're looking at here is the area where that boat launch previously existed has been expanded, and this is where you were getting to a second ago, below the normal high water mark as we found it. And
so Alex, let me just stop you there. I want to be real clear on this. Are you saying that the only aspect of the shoreline that's been expanded is with respect to the boat launch?
For this particular property, yes.
Okay. So just again, to clarify for the record, it's your statement that the only area of shoreline that has been expanded in this area is with respect to the area on where the boat launch is located, nowhere else.
Yeah, I'm fine saying that for this. I don't believe that I have, any other evidence other than the boat launch at this point.
Okay, so let me just look at, we're just broadening the lens a little bit here, literally. So this is the shorefront here of the whitetail property, correct?
Yep.
And so fair to say it's heavily rip-wrapped already, correct?
Yeah.
Okay.
Yep.
All right. And so it's really only this area that you're talking about?
Yeah, actually, you got your mouse on it exactly.
Okay, perfect. Thank you. Just give me 1 second. I'm just looking at my notes here. And could you tell me, again, I'm looking for precision here, how much was the shoreline at that boat launch area actually expanded in your view?
Yeah, so if you exactly where your mouse is, you'll notice that the shore has a kind of a jog in. There's kind of an S bend here. You can kind of see from where the dry rocks meet the wet rocks that there's a curved line.
You're talking right here.
Right there. There's a little pocket right there. Exactly. Now, if you go down to the Exhibit B after photo.
Okay. This one here?
No, down one more. Right here.
Yep.
That jog is no more. There's now a straight line that goes across where the silt fence has fallen onto the ground. Exactly, actually.
So can I ask a question? Just humor me, because math and spatial relations are not my forte, okay? But if you have a straight line, as you have shown that we're looking at right here, correct? As opposed to a jog of a shoreline, that's a U, wouldn't that U necessarily be longer? And so in fact, this actually shortens the shoreline? Doesn't expand it?
I guess if you're talking about length, but if, for example, let's just say this property owner owned up until the normal high water mark, for example, and they decided to fill in some of the lake so that it was straight across. Now they own more land up to the normal high water mark instead of that small section of area being water. That's what I would call expansion. They're not making it any longer. Actually, our shorefront definition is pin to pin, so the jogs don't really matter.
But shorefront, I thought, is defined as the normal high watermark, right?
Our shore frontage in our ordinance is from corner pin to corner pin.
Right, but you didn't talk about shore frontage in your notice of
Right.
violation. You talked about shoreline, expanding the shoreline, correct?
Yes.
Okay. Let me just get there for a second. Okay. And the definition section, I'm just going to go to the definition section in the ordinance.
Yep.
Shoreline, the normal high water line or upland edge of a wetland. And so I guess what I'm trying to ask you is how exactly and by how much the shoreline in that area was expanded.
Well, I can't give you an exact amount, but I can tell you, based on the photos submitted in the exhibits, that the S curve is no more, and it's now a straight line, which means something had to get filled in.
Okay. All right. I'm going to move on here. And I think actually some of my questions may not be necessary because I think your testimony has clarified that you're not talking about the entire shoreline, but rather limited to a certain area. I just want to make sure.
Well, hold on one sec, Leah. I just want to make sure that we're talking about the same thing here, because I'm talking about, when I say that, I'm saying they only filled in or expanded that particular portion. I'm not saying that they, didn't do, unpermitted stabilization of that entire, riprap shorefront. I don't know if that's what you're trying to get.
Well,
to here. I don't know.
I'm glad we're clarifying here, because to me, there's a difference between expansion of the shoreline and unpermitted stabilization. What I'm making sure.
Yeah, that's why they're two separate violations on the NOV.
Okay. All right. Yeah, and you're talking about number 8 is what you're talking about. Okay. All right.
Yeah.
All right. Let's move on then. So we're on to violation number 5, which is the creation of a beach, right, without a permit.
Yeah.
And so I'm going to your exhibit about that creation of the beach. And actually not creation, it said construction. Reading your language, it says construction of a beach, correct?
Mm-hmm.
Okay. And so looking at exhibit C here, this is the before photo, correct?
Yep.
And here's the after photo, correct?
Yep.
All right. And so you would agree with me that there was a beach already there, correct?
Well, I wouldn't necessarily say there's a sand beach there. I would say there is the shore front with a lot of large rocks and boulders that have been removed.
Okay. And I'm just going to direct your attention to exhibit D of your own materials. Again, this is a before shot.
Yep.
And I'm looking at that area of what I would call a beach. I see sand and I even see beach chairs. Do you see those?
Yep. And then I see some rocks under the chairs, it looks like.
Mm-hmm.
And I don't see those rocks anymore. I don't know if those were removed. It looks as though they're gone. They weren't the dark color that's currently there. And they weren't
I'm sorry, I didn't mean to cut you off, please.
No, go ahead.
And as far as beaches go, fair to say that beaches are not static, that they change over time, that sand gets deposited or rocks can fall or move?
Yeah, you could say that.
And do you have any evidence at all, aside from supposition, that those rocks were aren't there anymore because of not from natural causes?
I would be surprised if they were removed by natural causes.
Okay, so I'm going to just show you some pictures that I'm going to represent to you that were taken yesterday, and I was out at the property and I took them. And this is again that same beach area.
Yeah.
that we're looking at, okay? And so when I compare those shots taken yesterday, see how we have a bunch of rocks here?
Yeah.
And again, rocks here, same kind of rocks that you had shown on your before pictures.
Mm-hmm.
So it's basically same area, stretch of beach, lawn chairs, people are enjoying it as a beach. And
So where were those in the drone photo?
Where were those in the drone photo? I'm sorry.
Yeah, I guess I'm wondering why you can't really see those. And actually, if you go to the exhibit, the photos that we took on October 26th, I'm wondering if we can see those rocks that you see there at the bottom of the stairs in that photo.
I'm not sure you can, but I think that's the point you had acknowledged, is that beaches change. They're not static.
Yeah. I mean, it almost, to me, just looking at these, seeing these new photos, it almost looks as though someone put some sand on top of rocks, and that sand maybe washed away over the last year. I mean, that's just what it looks like.
Right. So because beaches change, it's a dynamic situation.
Yeah. I mean, yeah.
So I'll go back to your before and after shots for the beach, okay?
Sure.
And how large was that beach before?
I would say that's probably about 20 feet. I haven't taken a tape and measured it, in width.
Did you use your app on your phone to measure it when you were out there?
Width, no. And I wouldn't bother to measure how deep it is because it changes throughout the summer.
Okay, so you didn't measure it before?
No, and I'm not saying that it's spatially, length and width. I'm not saying it's any larger that way.
Okay. And I think one of the points that you raised in the notice of violation is that it was constructed without a permit from DEP, and that was problematic, correct?
Yeah, yes.
And I understand from your testimony today and prior hearings that you've been working fairly closely with DEP regarding alleged violations, correct?
Yeah.
And are you aware of any violation that the DEP is asserting with respect to alleged construction of a beach?
No, I'm not sure. I know that DEP issued, a notice of violation. I don't have that in front of me, so I don't remember if that was one of the violations or not.
If I submitted to you that it was not, would that be surprising?
No, because that notice of violation actually came from Alexis at NERPA, and it was Jeff Kalinich, in shoreland zoning that actually suggested to the town that this was a violation of beach construction.
Okay, but as far as you know, there's no violations in that regard from DEP.
Yeah, if you're saying that, then I'd say sure.
Okay. All right, let's go to violation number 6. We're making our way through these. Okay. So this is with respect to vegetation removal less than 3 feet in height, correct?
Yep.
And I'm just reading from your notice of violation. It says categorically all existing vegetation less than 3 feet in height have been removed within 100 feet of the normal high water line, correct?
Mm-hmm.
Okay, so let's move through various segments of this property. And I'm going to go to Exhibit B here. Okay. So this is, I think you said, this is taken from the water. And this is the area, I think it's fair to say that's directly abutting the Furwood property, correct?
Yep.
And can you point to me exactly where the line, where the line is between where the property line is?
I don't know.
Okay. And do you know how wide essentially the Whitetail property shoreline is?
Not off memory. No, I mean I know there's a property pin that we were pointed out when we did our inspection. I don't know if that is the actual property pin, but I would like to believe it is.
Okay. And there's a survey, and I'm just going to bring it up here so we can all have a look here, talk about where that setback is, 100 feet setback, right? And so your submission is that all vegetation within this 100 feet setback was removed, correct?
Yeah, I guess, just in the interest of time, I know what you're getting at, and clearly all the vegetation within 100 feet wasn't removed. But to say that there wasn't a good amount of vegetation removed within 100 feet would be, a little ridiculous, at least in my opinion. So I think we can move on to the next one.
All right, well, I'm going to ask a few more questions in that regard. So I'm looking at the house here, right? That's where the structure is, that's the house. And this 100-foot setback certainly goes behind the house, correct? So the good area all through that is within 100-foot setback, correct?
Yep.
Okay. All right, so let's go back to exhibits here. And so I'm looking at, this is from the water, this is exhibit D. And based on that survey, you'd agree with me that this whole area right here to the right, we're looking at the house from the water, that whole area right there, that's within the 100-foot setback, correct?
Yep.
And that none of that has been removed, correct? Do you agree with me there?
Yeah.
In this area here, I see all sorts of shrubs and vegetation and lawn and trees. None of that's been removed right there?
Correct. Yep.
And again, I'm gonna just pull up the pictures taken yesterday. This area, that's been left undisturbed, correct, as far as you're aware?
No, I don't think so.
So is it your submission that this whole, all of the shrubs could have grown back within that period of time?
Yeah, it's possible. I mean, let me just look real quick and see. It's been a while since I've been over to that side. Yeah, I mean, are you saying, what are you asking? Can you ask that again? I guess I didn't really follow the question.
Well, you would, I think in your own violation, you had said that all vegetation within 100 feet. And that looks like it's pretty firmly established and has not been removed.
Okay.
If you're unsure, then I'll just move on to the next area. And so this is the area where you'd alleged that all of the vegetation had been removed. And obviously you can see here that that lawn has grown back in, but here again is more shrubs, trees that is within that 100-foot setback. Would you agree with me there?
Yeah, that's pretty close, but.
And similarly, this is right behind the house. And I think this is just from another angle, but again, vegetation clearly still intact that was not removed within the 100-foot setback, correct?
Can I ask a question to clarify? And so are these photos you're pointing to, these photos you just took today?
Yesterday.
Yesterday. Okay, so these are photos you took yesterday.
I said that was the case, yes.
Okay. I'm just trying to connect it up and understand what you're doing here.
Yeah, and I'll be clear. I did take these yesterday, but I think it's important to establish, and that's what I'm attempting to do, and I think I heard the code officer agree, that none of this area has been disturbed at all.
Yeah, thankfully, yeah.
Okay. Just bear with me 1 second. So Exhibit D. And I think you had said that sort of all the shrubs and such had been removed from that area, correct? And these photos are taken in the autumn. I'm asking you that.
Yep, these were taken in October, yeah.
Leaves on the ground, okay.
Yeah,
and so
almost a year ago.
Got it. And so this Exhibit D, right, again, it shows that these shrubs, granted, you can't see them as well because they're deciduous, but there's still shrubs here. Those have not been removed. Their leaves are removed, so they're not readily evident. But you'd agree with me that those shrubs are still there and intact.
In this photo, yeah. Yeah, in that photo they were.
Right, but you took that photo, correct?
Yep.
Okay. And my understanding is that one of the concerns about removing vegetation really is because it hastens the erosion and sedimentation of the lake or the resource. Is that fair to say?
Sure. Yeah.
And my understanding also is that you've been to that property several times, correct? Or
yeah, 3. Yep.
3 times. And so on any of those 3 times, were you able to see any visible siltation or sedimentation in the water?
In the water? I'm not sure. No, I
Wouldn't you have looked?
no, not necessarily.
Okay. And that protection of the resource is in fact one of the governing principles of shoreline zoning, correct?
Yeah, I mean, don't get me wrong. I mean, I'm not saying that we weren't down at the shorefront. What I will tell you is we walked down the first day we were there on October 26th, down where the jetty was, and it's all mud. I mean, but to see, you know, it all floating out in the water, you got to remember it gets pretty rocky down over there. So it had all basically washed up on shore at that point.
So you didn't see any sedimentation in the water or siltation in the water, what I think I heard you say originally.
I will say, yes, I did, because I'm walking in it. So yes.
Second, I'm just moving through here. You had mentioned the jetty, right? When we were talking about, you were just mentioning the jetty, correct?
Yep. Yeah.
And my understanding, that jetty is certainly not on Whitetail. I meant to be specific and direct my questions to you about, did you witness any siltation at Whitetail?
Yeah, I mean, we walked out right down that whole stretch. I mean, it carried all the way over to the launch.
So your comments are not, you said the jetty, but you're saying you saw siltation along all the way to the boat launch is what you said? Is that fair?
Yeah, let me see if I can find an exhibit to better describe to you what I'm talking about. Yeah, so the after photo on exhibit D, you can see the jetty far off in the distance. We walked down along that entire shorefront from the jetty actually to the boat launch, where you can see the silt fences fallen down, where the large rocks are. That was all mud, like walking on a mud flat. And it was a mix of all sorts of different things, you know, compiled in that one spot.
All right, moving on to violation 7. Again, this is essentially the same removal of vegetation in less than 3 feet in height, but without a permit, right? So it's the same underlying conduct as violation number 6, but focused simply on the absence of a permit, correct?
Yeah.
And I'll ask you the same questions I did before, that you obviously understood the obligation to testify truthfully, correct?
Yes, I think it's very important for people to understand you can remove vegetation less than 3 feet in height within 100 feet from the water with a permit.
And so bottom line is, if I asked you the same questions about this violation based on this activity, your answers would be the same.
Yes.
I don't need to duplicate. Okay. All right, let's go to violation number 8. And this is about stabilization without a permit, correct?
Yeah.
And would you agree that if shoreline
Excuse me.
stabilization,
I have a question. You haven't actually filed an appeal regarding violation 8, have you?
I know that violation 8 is certainly in our notice of violation, talks about the need to consolidate. And I will say also that if past is prologue, and it should be, that all of these arguments certainly have been, made, and that I think there's a recognition that the notice of violation is essentially, in essence, like a notice pleading like a complaint. And so, yes, there has been reference to violation.
No, I'm talking about your appeal. I'm talking about your appeal.
Yeah, I am too.
You said notice of violation.
I'm sorry, notice of appeal, I should say, or my the administrative appeal.
I guess I don't understand what the appeal is for violation 8 because it isn't there.
Well, perhaps hopefully the questions I ask will make that more clear, as will my arguments at the end.
I guess, so, Mr. Chairman, to the extent there is an appeal as to violation, I ask that it be dismissed. The ordinance requires that a notice of appeal state the basis on which the appeal is and why it should be granted. There is no explanation as to why violation 8 should be vacated. To the extent there is an appeal relating to violation 8, it should be dismissed for a failure to comply with the ordinance.
Mr. Chairman.
Want to just offer some insight here for us?
I'm sorry, I didn't hear you, Mr. Chairman. Are you asking for Attorney Wagner to weigh in on that?
Yeah, if I didn't say that, yes, Attorney Wagner.
I just didn't hear you properly.
Sure. Well, I think just Attorney Richardson, did you have a response to that argument?
Sure. Yes. I mean, in the administrative appeal, we talked about the need to consolidate various provisions. And throughout these proceedings, I've made it very clear that one of the reasons for that is that and this argument I know has been made on several occasions, that had they secured a stabilization permit as required, as stated that they should have done in violation number 8, had they done so, that would have subsumed so many of the alleged violations with respect to earth moving and tree cutting and vegetation removal. And so, yes, we definitely have mentioned, we certainly have taken exception to this violation throughout these proceedings, because it's verbatim to what has happened in Fernwood. The board has addressed that in prior proceedings, and I don't understand why it would be any different here.
I'd like you to point to your application for an appeal where violation 8 is appealed. I don't see it.
I'm going to bring that up. Just bear with me if I can. Trying to find it. One second, if you just bear with me. Talking about on page 4 of the February 28, 2022 administrative appeal that was submitted. And I'm sorry, I don't have it bookmarked here, but talking about how violations number 8 and 9 cite the exact same provision of this, the shoreline zoning ordinance. They're fashioned as 2 separate violations. And so that's just been consistent with the submissions from the outset. And it has, in fact, been identified as a basis for appeal.
So I just want to understand. So on page
and I think let me just finish that thought, Eric. I'm sorry. And I'm having deja vu here, frankly, because I think you raised the same exact objection in an earlier proceeding, same objection. And the board did not sustain it, and they moved forward to make the analysis on this issue.
So you can turn that right around to you. All the violations alleged against your client were all upheld. So why are we doing this? I mean, that is a circular argument that doesn't work. I'm entitled to raise the argument here. It's different. You pointed out this is a different site. This is a different appeal. So I raised it again.
So thank you both. So to the board, the objection that's been raised is that the appeal concerning notice of violation 8 did not contain reasons challenging violation 8, and so the appeal should be dismissed as to violation 8. So as before, I do agree with Attorney Wyckoff that it's you're not necessarily bound by your prior decision, but I do believe that Attorney Ration is correct that in the past you analyzed this, and I advised you to look at the notice violation, and if you felt it gave you sufficient notice that violation would be raised on appeal to allow the appellant to challenge that violation. So I would, my recommendation to you is to compare the notice of violation with the notice of appeal and see if, in your opinion, the town had sufficient notice that violation 8 would be challenged.
Let me be clear. The appeal set alleges that a procedural issue with regard to 8 and 9, that they are the same violation because they're factually the same. It also contains a substantive challenge to violation 9. There isn't one as to violation 8. So my point is, what I heard was a beginning of an appeal as to violation number 8 on a substantive basis. And I'm saying that appeal, we don't have notice of that.
So, Attorney Rachel, can you answer why violation number 8 wasn't significantly addressed outside of what was listed on page 4?
When you say page four of the appeal, the administrative
Correct.
appeal.
Yeah, we're under the procedural clause.
Sure. I think because the reasons I've stated that so much of what we are arguing is that there is duplication, that this unpermitted shoreline stabilization is just part and parcel. If you look at 9, right, which I think Attorney Wyckoff conceded that there was a substantive objection to, it's exactly the same provision. If you look at the notice of violation, it cites the same exact provision. And so one's unpermitted shoreline stabilization, it's both the same thing. And by saying it's duplicative, those arguments will apply similarly. And I will note that in prior proceedings, as I said, Attorney Wyckoff raised the same issue, that it should be dismissed. And this board decided that it should not, and you should consider it on its merits. That's not to say that ultimately, if you decide on the merits that you disagree, and I would ask you not to, but not to dismiss it in turn before even considering it on the merits. You've already done that in the prior proceedings. And I'd ask that you do the same here, based on the same reasoning.
Is the issue clear to the board?
Yeah, David, can I chime in?
Yeah, please.
Would it appease you is if you just argued 9? I mean, it seems like your intention, I don't want to get ahead of you, might be, as you did with 1 and 2 and 6 and 7, to kind of make your arguments for the first one and then ask if your arguments are still stand for the one that you're saying is a duplicate. Would it appease everyone if you just did that opposite and just made the argument for 9 and then said, Alex, do all of these? I don't, just maybe a way to, I don't know. It was just my thought.
Well, from a procedural standpoint, I just want to be clear. I'm not making arguments right now. I'm simply asking a witness question.
Yeah, I'm not a lawyer. I think you understand what I was saying.
So if I can chime in, perhaps this will help the board. I do agree that there's a difference. You can make a argument that there's a difference between whether violation 8 is being substantively challenged, and there's no evidence to support the claim of that violation, and that violation 8 is merely a duplication of violation 9. And I think you can draw, the notice violation draws the distinction between those two violations. But as before, I think I advised the board, in my opinion, that distinction is so nuanced, and I don't think it would be appropriate to apply that level of scrutiny on. I agree with Attorney Rachen's position. This is something analogous to a pleading, and the standard there is low. So if you didn't ask for my opinion, but if you were to ask for my opinion, I would agree that there's sufficient notice here to challenge 8 on its own. And so I would recommend that you overrule the objection from the town.
Rick, Tom, Fred, Pete.
Do we need to make a motion on this?
I would suggest that you should, yes.
I'll propose a motion that we, I guess, accept Attorney Rachen's argument. And
if I can, I suggest, why don't you make and you can make this motion, and that doesn't mean that you're going to vote for it, but make a motion to grant or sustain the town's objection and exclude witness questions pertaining to violation 8. So then if you were to vote against that, you would be allowing Attorney Rachen to continue with the questions.
So moved.
I'll second that.
Any further discussion? All those in favor? Let you guys start. It's got to be a roll call vote. All those in favor? All those opposed? David, yes.
Greg opposed.
All those abstaining?
I'm going to abstain.
Fred, Pete?
Opposed.
Opposed. Fred? Got to come off mute, Fred.
I agree with you, Dave, yes.
So we got 1, 2, 3, 4 opposed, 1 abstain.
So then the objection is overruled, and Attorney Rachen can continue with her line of questioning pertaining to violation 8.
Thank you. Thanks so much. I appreciate it. So we're at violation number 8. And so, Alex, would you agree that if a shoreline stabilization, if it was warranted in certain circumstances, that this is actually the sort of thing that you can obtain a permit for under the shoreline zoning ordinance? And I'm specifically looking at section 15C 12 here, that it contemplates that it is the kind of thing that you can apply.
Is it an allowed use or is it an allowed activity? Is that what you're saying?
With a permit, yes.
Yes.
Okay. And the argument, of course, is that the town did not obtain a permit. That's your argument for why this is a violation, correct?
That your client didn't obtain a permit, yeah.
And that, would you agree that this was part of the permit by rule that we were looking at? Let me pull that up for you. That this permit by rule was seeking the very kinds of shoreline stabilization, erosion control, filter fabric, riprap, bark mulch per DEP requirement. So that's the kind of stabilization that is contemplated here, correct?
This activity does also require a permit by rule, yeah.
Okay. And it's essentially very similar, if not the same activity that just requires permits from both entities.
Within 75 feet, you have to get a permit by rule, yeah.
Okay. And did you measure to determine whether more than 100 feet of shoreline that was covered by the PBR, I think here is 98 feet of shoreline was more impacted as far as you're concerned than what was applied for already?
Yes.
Can you elaborate on that?
I cannot, no. You're looking for the exact number? I don't have that exact number with me right now. I could find it, but it's going to take time.
Okay. All right. I'm happy to move on. I wanted to ask you about nonconformities. So we can put our attention here on section 12. You'll agree with me that this is section 12 of the shoreline zoning ordinance that deals with nonconformities, correct?
Yep.
And in essence, if we look at subsection B2, which is entitled repair and maintenance, talks about how the ordinance allows, without a permit, normal upkeep and maintenance of non-conforming uses and structures. You agree with me there?
Yep.
That's what it says. Okay. And so what I'm wondering is, are you looking at, you know, we talked about, we saw the pictures that this is a heavily rip-wrapped property. Do you consider the rip-wrapped area to be a use or a structure?
It would be a use, I guess you could say.
Okay. And so non-conforming uses and structures allow for repair and maintenance, correct? Under the terms of 12C.
As long as they don't exceed 50%.
50%, I'm looking for 50% of what? I'm not sure what you're talking about. Could you direct me to a provision that says that?
Yeah. You're going to want to go to number 4 under that section. Any non-conforming structure which is located less than the required setback from the normal high water line of a water body, tributary stream, or upland edge of a wetland, which is removed or damaged or destroyed regardless of the cause by more than 50% of the fair market value of the structure before such damage, destruction, or removal may be reconstructed or replaced, provided that, and it goes on and on and on. But 50% is typically when someone is repairing or maintaining a non-conforming structure, such as a deck that's just a few feet from the water that doesn't show up on a subdivision plan from 2007. If they were to replace that or reconstruct that by more than 50%, they would have to relocate it to 100 feet.
Understood. So a couple of follow-up questions then. You had said that this was a non-conforming use. This provision that you just directed us to is a non-conforming, deals with non-conforming structures, correct?
Yeah, and typically they are a wall for erosion control is typically treated as a structure. However, it's a structure that's not required to meet the 100-foot setback in most situations, unless it's not necessarily required for erosion control.
All right, so I just want to be clear. Are you saying that it's both a use and a structure, it's just a use, or just a structure?
I would say it could be both.
Okay, and when you say by 50% of the market value, how did you determine that this exceeded 50% of the market value?
Well, that would mean we'd have to assess a market value for the entire riprap wall that was there. And the easiest way in my mind to do that is to just do it based on, percentage of the wall replaced. They clearly exceeded 50% of that.
How is that clear? That's what I'm trying to understand. You say you're supposing it's clear. How is it clear?
Yeah, I guess we'd have to go back to what did your client pay for this portion of the wall to be repaired?
But, well, I think let's be clear that this is
if we're gonna make that conversation, or we're gonna have that conversation, then we're gonna probably need some more information, I think, to clearly come to that.
But I think it's
agreement.
critical to understand here is that this is your notice of violation, and the violations that are alleged must be substantiated before. We're not talking about after the fact. It's not our job at this point to submit additional information. This was your allegation. And so I'm simply trying to understand how it is that you came up with those calculations.
Right, Leah, but it's your appeal and that burden is on you. And you're saying, you're asking questions trying to prove that they are not in violation for something that's as easy as not having a permit.
No,
so I just don't see where we're going here.
Sure, and I don't want to engage in the back and forth, and I think the questions.
I'm fine answering the questions, but I need to understand where we're headed with this in order to give you the accurate information.
Sure. So let's back up. You had said that this I had submitted to you that section 15C of, section 12 with respect to nonconformities specifically states that you can repair and maintain. And then you directed me to this reconstruction replacement, and that was the basis for your thought.
Right. So to answer your question,
excuse me, Alex, I haven't finished. If you just let me.
I know, but I understand you're explaining it for me, for my benefit, and I get it. So let's not waste anyone's time. I do not believe this is repair and maintenance. This is not repair and maintenance. They completely replaced this entire existing riprap wall. if someone could explain to me why they felt like they needed to replace an existing secured wall, then we can talk about that. But there's no reason that I can see.
Okay, so it was, so I heard you say it was an existing wall, correct?
Yeah, but was it legally existing?
No one suggested that it isn't. Are you suggesting that now?
I'm not saying, I don't know if it was legally existing or not, is what I'm getting at.
Right, but there's been no allegation whatsoever that it was not legally existing. You have not made that suggestion. Okay.
We haven't formally said that, no, but we're giving that your client the benefit here and assuming that it is.
Okay, let me be clear. The notice of violation, going back to my earlier conversations with you, the notice of violation, the purpose of which is to identify any alleged violation, right?
Yes.
First principles. At any time, has it been suggested that this was not a legally conforming use or structure?
Has it been suggested?
In your notice of violation?
No.
Okay.
We have not
So
raised that, no.
Okay, so let's end that line of questioning then, because you have not raised that. But under violation number 8, right, it talks about over or below the normal high water line. So we're really talking about what's below, correct?
Yes.
Okay. And what you're talking about, I think, is over and above the normal high water line, correct?
We're still talking about 8 and 9, right?
Yes, we are.
Yeah. Yeah, so that comes from that particular section in the ordinance. And I've never understood why that's where the state dropped it in, but that's where the state dropped it in. Specifically 12, the technical standard that we're relying on is under the heading, for structures or uses extending over or below. And I think the whole point of that is because sometimes, a riprap wall is actually below the normal high water mark for a majority of the year, usually until September.
All right, I think I want to move on to number 9, all right? And this is, again, same provision, unpermitted shoreline stabilization, no barge, right?
Yep.
And I think you agreed that shoreline stabilization, if it's warranted, that is the sort of thing you can get a permit for if you apply.
Yeah.
And what was the level of the water when this work was done? Are you aware of that? Can you speak to it?
It was pretty low. I'm actually pretty sure you could find out the exact level if you wanted to on the website, but it's the low time of year.
What website are you referring to? Like
I don't know exactly.
Lake, or is it a Sebago Lake?
The dam has a website where you can go back historically to find the exact.
So at that point in time, it was fairly low, correct?
Typically September, October, it starts to come back up depending on the rain.
Okay. And do you know how much, just in terms of draw, in terms of depth, how much it draws when fully loaded with this kind of heavy equipment?
No, I don't.
Okay. And do you know where the barge would have been situated offshore?
No.
Okay. And do you know what the reach of the excavator is as far as? Okay. And what did you do to determine if that barge would have been feasible?
Just based on seeing it in that particular area, that same segment of shorefront on Sebago Lake. Okay. He has the barge, he uses the barge. It's in that, line of work frequently.
Okay. All right. I'm going to move on to violation 10. And this is removal in excess of what's allowed by the point system, right? Mm-hmm. And how many trees roughly do you think that was removed at Whitetail?
I would, off the top of my head, I'm going to say I would go to the NOV and see what is listed there, because I don't have that number memorized, unfortunately.
All right, that's fine. We can move past that. But you'd agree, and I think we've had this conversation before, that you can cut hazard trees without a permit if the person consults with you prior to doing so. So no.
Correct.
Okay. And you recall, I think I should ask you, do you recall the evidence that was submitted by Aaron Goslin of Q Team that most of those trees were, in fact, in his opinion, hazard trees?
I think that was specific to Fernwood.
I think it included whitetail as well. But
Oh.
do you dispute that that is the case? I mean, I can.
Well, I mean, we were told by Q Team that they didn't do any of the work on 28 whitetail. So I would kind of be a little confused as to why they were assessing hazard trees on 28 whitetail if they didn't do any of the work.
Well, I'm not sure that's the case. So let's just make sure we are clear. Because if you'll recall, Mr. Goslin submitted evidence in the last hearing. And I have this, I've called this up here. If you just bear with me one moment. Well, it was my understanding that it was both properties, but let's leave that aside for a moment and look at the photos. If you give me one sec. So I am calling these photos to your attention. And again, these were taken yesterday. And this is the tree that was removed. This is at Whitetail, and this is right next to the deck. Remember that deck area?
Mm-hmm.
Sorry, the stairs. Not the big deck out front, but the stairs. Do you recall that one?
Sorry,
And-
can I interrupt you just briefly? Are you screen sharing right now?
Oh, I'm sorry. I don't think I am. Thanks.
Thank you.
Okay. Can you see?
Yes.
Yep.
Great. So here we have one of the larger trees at Whitetail. And from my perspective, I'm looking at a fairly large tree with the middle portion, a large extent of that rotted out. Do you agree with me that that's a fair characterization?
Sure, yeah.
And would you agree with me that looking at this tree, that would be the kind of tree that is characterized as a hazard tree?
Yeah, could probably meet that definition.
Probably, or yes?
Yeah, I mean, who knows how long that's been there? That could have been there 10, 15 years. I don't know.
I think, is that not one of the trees that you identified in your NOV as having been removed?
I have no clue. I mean, I'm just not trying to be difficult. I'm just saying I can't really tell based on where this photo is taken if it is one of the trees or not.
All right, but you say that you agree that that is in fact a hazard tree.
Yeah, that would look like a hazard.
Okay, and you also agree that Aaron Goslin is a licensed arborist, correct?
Yes.
And you are not?
Correct.
Okay. One of the things that is alleged in violation number 10 is the fact that there was some canopy loss.
Mm-hmm.
Can you tell me how you measured that canopy loss?
Yeah, we based it on aerial imagery.
Okay. So from that aerial imagery, what did you use to measure that 250 feet?
That was Google Earth measurement from aerial photo.
And just for the layperson to understand, how does that actually work?
I believe if you go to the last exhibit in the NOV, it shows the dimensions that were measured based on the measure tool in Google Earth on that actual aerial photo.
Are you talking about exhibit F?
Yeah.
You can see my screen here. Is that what you're talking about?
Yeah, for some reason the markup's not showing on that exhibit.
Okay, hold on. I think I have another way to get to it. No. But these lines you're saying have been drawn from Google Earth.
Mm-hmm.
That's where you got it. Okay. All right.
Yeah.
And what was the canopy? What was it before the tree cutting? Are you aware?
So in that exhibit F, it does show the canopy before the trees were removed. I circled the trees that were removed, and provide a dimension for reference showing that number of 250 has been exceeded.
just so I'm clear, this exhibit F here, that's a before photo, correct?
Yeah.
Okay, so where's the after?
The after is not included in the NOV. It actually came out from Google not too long ago. It was probably the last 3 months that it actually was released.
Okay, so when you, at the time you drafted that, you did not have any after photos, correct?
Correct.
Okay. So moving on to violation number 11. This is vegetation removal in excess of what was allowed by the point system. I'm just, again, just going back to the canopy piece, right?
Yeah.
So we talked about how there's no after photo, but what's the scale of the after photo? How did you get that?
It's based on the area that's opened on that site visit. You know, assessing where that area is now open and essentially drawing a circle, and the number greatly exceeds 250. So yeah, I mean, I suppose you could try and say it's probably not exact, but we're talking it's well into the thousands of square feet, not hundreds.
And you're basing that on what though? Like how did you measure that when you say it's in the thousands? How do you actually measure that empirically?
By using the the measure tool on Google Earth, and measuring that shore frontage and looking and seeing what's open on site. We can easily assess how much area is open now compared to what would have been open if there was a large tree standing right in that spot.
Okay, but that was not that was just through the Google piece. That wasn't through your phone app or anything like that,
No,
right?
No.
And no. With respect to both your phone app and this Google tool that you're talking about, how are you aware of the reliability of those tools? Like, how can you verify whether or not those are reliable?
Well, again, I'm not a surveyor. I'm not a state licensed surveyor. So how reliable is a tape measure? I mean, it really all comes down to the user. I've tested the phone app, for example, and set 100-foot tape and then measured 100 feet, and it's not close enough to measure inches, but close enough to measure feet. I've also done the same with the Google Earth tool. So, we have to use what tools we have available to us, and that's what I've done.
Okay, so let's go to violation number 11, okay? And this is vegetation and removal of the point in excess of the point system. Can you just very quickly let us know how that point system works?
Yeah, so essentially you have, for selective removal or removal of vegetation within 100 feet only, within 100 feet, you have to establish 25 by 50 foot grids, and those grids have to contain 24 points based on the diameter of the tree at 4.5 feet off the ground. You have to assess every single tree within that 25 by 50 foot grid, assign it a point, and in the end, you have to have at least 24 points, and you have to maintain 5 saplings. If you have a 25 by 50 foot grid and you cut all but one tree, you are in violation of the point system because you cannot have 24 points with just one tree. So that's very easy for me to determine that's a violation.
Okay, and did you, when you were determining that it was a violation, did you go out, did you actually plot those grids yourself when you went out to the property?
I didn't physically plot them on site. We plotted them, again, through Google measurement, and looking at, you place that, that 25 by 50 foot grid right at the shorefront. And there's a place where there was trees and there's now no longer any trees. So it's very easy to see that, that grid is now empty, has no points, and it was selectively removed. It wasn't for removal of a hazard tree. So that's your only option at that point.
And sorry, go ahead.
Sorry.
No, go ahead.
That can easily be avoided by getting a permit. You can actually cut trees in excess of the point system if you have a permit for an approved activity.
Okay. Again, I'm looking at Exhibit F, okay, and this is what was submitted in conjunction with violation 11. Can you tell me where that property line is between? Because I know a lot of these trees that you're counting and indicating have been removed may very well not be on the whitetail property. So
I guess I don't see why. you know, I mean, obviously we're looking at the lines on this are tax map overlays. They're usually off a few feet. In this particular case, I can tell you they're actually, they're skewed too far to the right. When we met on site a month or so ago, we were pointed out the property line on the right-hand side next to the driveway where there's a shed that's actually over the line. And the property line on the right actually is just to the right side of that right white bubble or cloud that I drew. So by that, I can tell you this tax map line actually should be shifted well to the left. So where the deck is actually going to be where that point is.
Hold on, one sec. I just want to make sure that we're where you're. Let's make sure we're looking at the same thing.
Yeah. You're talking about Exhibit F?
I want to know what you're talking about. Yeah, I'm looking at Exhibit F, and I'm trying to figure out. I want you to tell me where on that exhibit that the property line is located.
If I can interject, I think the problem here is what you're showing as Exhibit F doesn't have the actual lines on it that the notice of violations has on it.
Yeah.
And I think that's causing some confusion.
Fair enough. I realize that somehow has been.
Do you want me to just screen share mine?
Yeah, that would be great, Alex. I'd appreciate that. Thank you.
Yeah, why don't I just, because I can actually explain it a little bit better here. So hold on one sec. Here we go.
I'll stop my share. Go ahead.
Yep. All right, so you can see the markup now, right?
Yep.
Okay. So what I was trying to explain here is the cloud, I'm actually going to see if I can just, here we go. The cloud over here, can you see my mouse?
Yeah, when you say cloud, you mean just kind of those squiggly, like
this right here. Yep.
Yeah. Mm-hmm.
The property line itself is actually right around there. So this tax map is off, the white line here, the white property line you're seeing. This corner right here that I'm circling is actually right over here. And that was pointed out to us on site. So this entire white line on the shorefront actually needs to get moved over here. So this side corner is actually down on this side. And the 50-foot wide walking path right of way that you see on the subdivision plan is actually right around here. Does that help?
Somewhat, yeah. Okay. All right. I'm going to move on to violation 12, okay?
Yep.
And I'm going to share my screen again, if I may.
Mm-hmm.
Okay, and so 12, you noted that this was within that 1250 square foot area, correct?
Yes.
And that's essentially the same area that's alleged in violation 11?
Yes.
And you measured it in the same way that you identified earlier?
Yes.
And how is that different than tree removal? This was vegetation without a permit. How is that different from the allegation that there was a tree removal in that area?
So you're saying how is 12 different from 11? Is that what you're?
Well, I'm wondering, it says removal of vegetation without a permit within the 1250 square foot area. And before you're talking about a point system, and here you're talking about just general removal of vegetation.
Yeah, so the point system is in violation of section 15 Q, right? Just making sure I have the section 15Q for the 250. And then you have 15Q2B, I believe.
I just
so
want
it's
to clarify.
One's 2A and one's 2B.
But you're basically saying that trees and, are you conflating trees with vegetation? Are you saying they're the same thing? It's just not clear from this.
Yeah, I guess I'm not necessarily following the question you're trying to ask.
The question
Because
I'm
it
trying
seems clear to me.
Okay, let me clarify.
Mhm.
Between the house, on allegation 12, between the house
Yep.
and the water, vegetation has been removed from a 1250 square foot area.
Yep.
In that,
Correct.
are you including just vegetation of less than 3 feet, or are you talking about trees? Are you talking about both?
Both.
And so basically, this is the same allegations, or the activity, I should say, that is included within violation 11 and 6. 11 being,
Yes.
okay, so we agree on that.
Yep.
Okay.
Yep.
All right. So moving on, we're going to talk about the corrective action, right? As part of any notice of violation, as we said, corrective action is specified, correct?
Yep. Yep.
And largely here, what you have asked for corrective action is a series of after the fact permitting, correct?
Yep.
Okay. And you're aware that management controls and various other parties have submitted after the fact permitting. Originally back in March, there were, I'll just bring these up here. Let's see. We had a series of 4 different after the fact permit applications submitted by Mr. Morse, correct? You recall that?
Yes. Mhm.
And for whatever reason, the town apparently was dissatisfied with this, and that my clients retained another expert, Elizabeth Ransom, correct? You recall that?
Yes.
And that she actually submitted back in early August additional after the fact permitting plans, restoration plans, correct?
Yes.
And the town refused to accept those. Do you recall that?
Yeah, we're not going to accept it until we feel it's adequate. Exactly.
And wasn't one of the reasons stated in the rejection that the application doesn't seek anything that the planning board can review here?
Correct. Yep.
Correct. But isn't this exactly what you had asked for, that they submit plans to the planning board and to the code enforcement officer after the fact?
Well, the planning board isn't responsible for reviewing a restoration plan. If it meets a specific, under that table of land uses, if it's required to go to the planning board for approval, then it should. But if it's a restoration plan that exceeds the scope of what's something that, could be, for example, it could be approved by a code officer, then it wouldn't need to go to planning board.
But wasn't the whole point of violation number 8 as asserted that they needed a permit for shoreline stabilization? And isn't exactly, this is exactly what is being submitted? The plans of the stabilization after the fact, as it may be?
Yeah, I think one of the difficult things for people to understand is the planning board likely would not be able to approve that. So what happens then? Your client will spend more time and money going to the planning board to get this thing approved after the fact. What if they say no? What if it doesn't meet the requirements of the ordinance?
Those are a lot of what ifs, Alex, but what is there, aside from submitting the after fact permit that was directly required under the corrective action. Anyway, I'll leave it at that. I think that's it, and I really appreciate your time. I know it's been a long and winding road. I appreciate that.
Yeah,
Thank
no
you.
problem.
Thank you. So just from a procedural standpoint, I want to make sure I'm clear. I have asked my questions. I don't have any other witnesses. Of course, I reserve the right to cross-examine any, if necessary. But, I know other parties have their case to put on, and I won't make any final arguments, of course, until after that. But I just want to make sure we're clear on the process.
Wagner, can
Yeah, so Attorney Wright, you're asking if you'll have an opportunity to make arguments after the other side has presented their witnesses?
Yeah.
So yes, generally how we've done this in the past would that you'd present your arguments now, and you would have an opportunity to give rebuttal after the town puts on their case. So I think you would have that. So yes, you would have that opportunity after
Okay.
reference.
Yeah. I think if I recall, we don't make our final arguments until after everybody has their testimony in. I just want to make sure that that's consistent with your recollection.
I think it's varied on each appeal. I mean, I know in the last one we had there was a mix of arguments and evidence all at once. But I have no problem, and certainly it's up to the chair. But I would recommend, to you, Mr. Chair, I think that's a reasonable approach, is to allow each side to present their evidence and then return to both the town and the appellant to then make closing arguments, essentially.
So Attorney Wagner, can I ask if you could outline for us the next step in this, and then I'm going to propose we take a 5-minute break.
Sure. So the next would be if the board had any questions for the appellant on this testimony so far, or for the CEO.
Board have any? I don't at this point.
Okay, and Attorney Regan, you have no further witnesses?
I do not. Nope.
Okay, any other evidence?
From a procedural standpoint, it seems to me, that we've been building from one hearing to another, correct? And we've all agreed, certainly for today's proceeding, that what is entered from one hearing will carry over to the next. You're going to make decisions here based on these arguments, and then theoretically, Big Lake Marine will have opportunity to have its notice of violation heard. I would suggest and would prefer, in fact, opportunity to participate in this line of questioning and in the discussion of evidence here, so that we actually have an opportunity to participate in the process. Otherwise, what we'll end up with, which is part of my arguments from the prior night, is that decisions will be made, and then we'll either make to pretend that the bell can be unrung and we get a fresh start, which I think we all agree, certainly in the same evening, is probably not an accurate description. Or I can have opportunity to participate, make some questions of the witnesses or arguments on Big Lake's behalf. And I think, especially since the notice of violations are literally identical, the determinations made by the board can be made as to both.
I agree with you. I think that you've, as other parties here, and I would call, I'm using parties loosely, but I would say you absolutely have an opportunity now, if you'd like to ask any questions of Alex, you can, and I maintain that you've had that opportunity before. So I guess that's why I was confused as to your objections last month. Is I've always thought, how I've laid out the procedure and how the chair's laid out the procedure is that you, even though you're not a party in this appeal, would have an opportunity, as you do now, and I'd say go right ahead to ask questions of this witness. So if you have any, now would be the appropriate time.
You would all agree with that? And do we want to take a break? I know the chair just mentioned that before I do that, or would you like me to continue on with the question?
I have a question. So is the thought then, Leah, as the appellant, has asked Alex to put him on as a witness, and then are you skipping the town now and then go into Greg to ask questions of Alex, or is it?
No, I guess Leah has Alex on the stand now as a witness, so I think it would be an appropriate time for Greg to ask questions relevant to the answers that Alex has given, and then the town will have an opportunity. You can certainly call Alex back up, and Greg will be given that opportunity again if you would like to ask questions relevant to the answers that Alex gave in response to your questions. Does that make sense?
No, I don't think it does, actually. I mean, that seems to be an inefficient way to go about it. I mean, if I was in, I guess what I had in my head is the appellant has gone and asked Alex, the questions she's going to ask. I think that then I should have the chance to, the town could put on its presentation, the presentation it's going to have. I can ask Alex the questions I have, and then Greg, if he wants to ask questions, then it's would have been had everything we had, everything I had, and then he can go again rather than him getting two bites at the apple. That just seems inefficient to me.
Yeah, I think you're right. And if I have no objections to that, then why don't we do that? And you'll, so we'll go as Attorney Wyckoff outlined.
Okay. Now, I heard someone mention something about a break first. Sharon Merch, do you want to take a break before we did that?
I do. So, showing 8:14, let's reconvene at 8:20.
Okay.
So I believe it was our understanding that Attorney Wyckoff now would have a chance to present. So Attorney Wyckoff, we would be happy to hear you have for us.
Sure. So my plan here is first I'm gonna ask Alex to give the board an overview of the violations at Whitetail Lane, and then after he does that, generally, then I propose that we go through each of the violations, and Alex and I will together address each of the issues raised by the other side. Bear with me, my computer's telling me it's restarting in 4 minutes here. Hang on, excuse me. I'm trying to prevent this, my computer from restarting. Bear with me, I'm sorry. Okay. With that, I'm going to turn things over to Alex, please.
All right. I'm going to share my screen. I'm going to try and do this quickly. Okay. Sorry. Whoops, I actually. Can you see that?
Yes.
Awesome. Okay. All right. So as you guys know, we were tipped off on this violation from DEP, October 14th, 2021. In an email, she sent us a photo of the activity taking place on the adjacent property, initially 18 Fernwood, and then eventually she also sent photos of 28 Whitetail as well. We inspected the site October 26th, and this is the condition as we found it. It was an overcast day. It wasn't raining when we were down there, but I believe it had rained earlier that day. I'm going to go through the violations listed on the NOV. And the first one is for filling and earth moving of greater than 10 cubic yards, no erosion control. So here you can see existing shrubs and lawn were completely stripped and regraded on the entire left side of the property. There is a mulch berm kind of where the arrow is here. It's actually not an erosion control mulch. It's more of like an ornamental mulch. Erosion control mulch is usually more of a reddish color and is larger. It's stump grindings, waterlogged so that it doesn't float away. Fill was deposited in spots when they created the new riprap shoreline. As I said earlier, this was existing riprap, clearly was doing the job, so I'm not exactly sure why it needed to be completely replaced, but ultimately that activity would have required a permit, and it would have needed an erosion control plan and erosion control on site. So here you can see where Leah and I were discussing earlier, the bottom of the boat ramp headed down towards the water. This section actually before kind of jogged to the left where the boat ramp was, and then back to the right as it went around that little peninsula towards the beach. The way they filled and graded this boat ramp made it a little bit less steep, but longer. Here you can see the erosion control on site, like, I don't know, less than 2 weeks after, maybe about 2 weeks, had fallen completely down here in this particular spot. The next one here is for the boat launch. And so here you can see the boat launch in these photos was 2 pallets end to end, and It was used to lower, a rowboat or kayaks and canoes down to the water, so they didn't have to take them down the rock shorefront or the stairs. It's really the only spot to access the water for something like that. That was the use for it, which we can tell by this photo. They've got some stacked up at the top. So this was the existing. This is what they replaced it with. It's now shallower, wider, firmer, and it was done without a permit from the planning board. Okay. The next thing here is for the shoreline itself. And this photo is a before photo. You can see the site as it existed from one of the older Portland Water District photos. The after photo, you can see all of the ground cover and trees in that area has been essentially all removed to grade that slope back with a very large riprap wall. Next one we're going to go to is beach construction. We did talk about this a little bit already, so I don't want to go into it too heavily detailed, but you can see there's large boulders on the shore at the water in the before photo. The after photo, all of the large boulders are gone. So they have effectively created a nice sand beach area, which once they go down and rake it up will be the perfect spot to hang out. Those rocks were removed, creating a beach. Coincidentally, it's also possible that they brought sand in to cover some rocks. Looking at the photos that Leah presented earlier from the site today, it does look as though sand may have washed away and it's now exposed the rocks that were there before. That's also possible, on site. Vegetation removal, less than 3 feet in height. You can see there's, in this older Portland Water District photo, there's grass and shrubs on a majority of the lot shorefront, and that has been completely removed. The work could have been done from a barge. Leah mentioned earlier that this area was disturbed for storage of the excavation equipment required to replace the existing riprap wall. That section exists in the ordinance to prevent that very thing. The planning board is supposed to make a determination if that work could be done from the barge or not, to avoid disturbance to the shorefront, the protected area. Rob does own a barge. He does do a lot of work on the barge, or has done a lot of work on the barge. And he did mention at a site meeting, a couple of months ago, that he felt as though he could do repair work from the barge down there if necessary. So I do think this work could have been done from the barge. Ultimately, that was the planning board's decision that they never got to make. Tree removal within 100 feet for activity other than timber harvesting. Multiple trees have been removed. Again, back to this old photo, you can see all the trees here, 4 small trees, a large one here, another cluster of small trees, and then a couple other larger trees have all been removed. You can see the after photo showing where they were. Again, on this drone photo from Portland Water District, you can see there's other trees that were existing that have all been removed. This is for vegetation removal in excess of specific standards. This first one is excess of the point system, which I explained earlier. 25 by 50 grid, diameter at 4.5 feet determines how many points the tree is worth, and you have to maintain at least 24 points. If we establish just one grid here, where a couple large trees were removed, these trees are no longer, there's one still standing in that area, but a majority has been removed. They definitely have exceeded the point system allowance here, and the 250 square foot canopy opening. I believe that is it. I'm going to pass it off to Eric.
Thank you, Alex. And then I'm gonna share my screen here, okay? Okay, I just want to make sure that you can see what I'm doing here. Do you see me changing a page number?
Yes.
Okay, good enough. Okay, so first, I'm going to address that management controls makes this overarching argument that it relied on its contractor to obtain permits and to do work consistent with the shoreline zoning ordinance. And in the first instance, the ZBA should reject that argument just as it did in connection with management controls, similar arguments relating to the Fernwood administrative appeal. As the property owner, management controls was responsible for what happens on its property at its direction. And here the contractor, Big Lake Marine Construction or Big Lake Marine, is management controls agent. Management controls hired Mr. Durant for the project. And we've seen a copy of the contract with the applications for an appeal here. And management controls acknowledges it asked Mr. Durant to obtain the permits. And I'm going to just show you for a moment the appeal that was submitted by Durant Excavating. And then bear with me, I'm going to show you that. And with that appeal, they submitted Big Lake Marine submitted the permit by rule notification. And on it, it identifies the applicant as management control and the agent is Big Lake Marine. And my point being that Big Lake Marine was acting as the agent for management control, and a principal is liable for the violations that are engaged in by the principal's agent. So management controls is responsible for any violations committed by its agent here, Big Lake Marine. And then I just want to go here. Here's the invoice where management controls is sending an invoice. Pardon me. Big Lake Marine is sending an invoice to management controls for the work that it did. Now, I also provided the board with a copy of a application that was recently submitted to the Department of Environmental Protection by Ransom Environmental on behalf of management controls. And I'm just going to go to the third page of this document. And on the third page of the document, Ransom describes what happened here as the work. It's right here that the scope of the work, it relates that these issues relate to the scope of work completed by contractors on behalf of management controls. And my point is that this work was, Ransom on behalf of management controls is acknowledging that the work was done on by other contractors on behalf of management controls. So here, a property owner and as principal, management controls is responsible for the actions of its contractor. And I've given you a statutory citation for that concept. And that another section 444, providing that any person who orders or conducts an activity in violation of a municipal ordinance is penalized in accordance with the statute here. And then the shoreline zoning ordinance itself says that permit applications must be signed by an owner or a person authorized by the owner. And I've also given you a case law citation for a case that stands for the proposition that a principal is liable for the agent's misconduct within the scope of the agent's authority, whether or not the principal is aware of the misconduct. So the ZBA should reject management controls contentions that it isn't responsible for any violations here because it hired its contractor to obtain permits and to do work consistent with the shoreline zoning ordinance. It's responsible for those violations as well. Next, I want to go to violation number 1. And violation number 1 relates to filling and earth moving that occurs in violation of the shoreline zoning ordinance. And the ordinance requires that that activity be done in a way that to prevent erosion and sedimentation of surface waters, and that if a permit is required, that it be done in accordance with an erosion and sedimentation control plan. For all the reasons that you upheld this violation as to management controls for Fernwood, you should uphold it. You should uphold the violation with regards to Whitetail as well. And now I'd like to ask Alex if he could just walk us through what this violation is and describe it.
Yeah, so here we have the activity of the soil disturbance taking place without an erosion control and sedimentation plan. We require that to be submitted, meet those requirements prior to the activity taking place, and then we also require that erosion control plan to be followed to protect the environment.
Okay, let me just go to the here's a photo. This is Exhibit B to the notice of violation. Alex, can you just describe to us what we're seeing here and describe the violation that's being depicted?
Yeah, I mean, there's, you know, at the top of the hill, you'll see there's exposed soils. And at the bottom of the hill, you see erosion control, a silt fence that's fallen down, was kind of carelessly placed, it looks like, at the bottom of that bank. But
is that right here where my cursor is moving?
Yeah.
Okay. Okay. Let me just go to Exhibit E. Okay, could you describe to us what's occurring here?
Yeah, so activity taking place in the after photo at the bottom here, it clearly shows that there's exposed soils on the bank, and at the bottom of the hill, the silt fence is in place where there's stabilization, and then where the bank is not stabilized, the erosion control ends, which is not what we want to see.
Okay. Can you describe what's happening in the bottom photo here?
Yep, same thing. Silt fence has fallen down and is not doing anything.
Okay. I'm going to go to the next violation is violation number 2. The shoreline zoning ordinance requires a permit from the code enforcement officer for any fill or earth moving of more than 10 cubic yards that occurs in the zone that's at issue here. Alex, can you just describe describe this violation, and I'll go to the exhibits.
Yeah, so 10 cubic yards is one good sized dump truck. So if you look at any of these exhibit photos and the after photos, you will see that a significant amount of disturbance has taken place, but they also brought in mulch. They brought in all of the rock, and it doesn't take very much to reach that 10 cubic yard threshold, which they exceeded by probably quite a bit.
Okay, so let's just let me go to Exhibit A here, and you could just walk us through these first 3 pages and just describe what we're saying and relate it to this violation, please.
Yep, so the bank has been stripped, graded. The old rock has possibly been removed or covered on top of with new material. Here is the area that's been, vegetation's been removed. And then this is the new bank in place with the new material. Just in this one photo alone, right there, I mean, they definitely exceed a single dump truck worth of riprap, that's for sure.
Okay, let's go to Exhibit B here. If you could just if you could describe this as well.
This one is for the boat ramp. Yeah, so the boat ramp, here you can see that they deposited, much more riprap than, was clearly on site. You can tell by the slope of that boat ramp is much shallower pitch than what existed before. All that mulch on the side.
Okay. can you describe what we're seeing here in relation to this violation of the filling and earth moving?
Yep, all of this material in the after photo, the riprap, the mulch, all of that's all new. Been deposited on site without a permit.
Okay, and could you describe on this page and this page the same thing?
Yeah, this is a very large area. It goes back almost about 100 feet from the water, and probably out 50 to 75 feet. Just the stripping of all of the grass that was there, or if you were running equipment over it constantly and disturbing that site, you're disturbing an area that's all sloped towards the lake, and all of the water from the top of the lot and the road behind it and the roof is all coming down that, headed right for that nice new pitched boat ramp.
Okay. I'm going to go on to violation number 3, and this violation relates to the boat launch. So, as a permanent structure, construction of the boat launch requires planning board approval. Alex, does the town have any record of any planning board permit relating to the boat launch?
No.
Okay. Now, the shoreline zoning ordinance also requires that a boat launch have a permit from the DEP. Are you aware of that existing?
No.
Okay. And now the ordinance provides that a non-conforming structure can be expanded, but only after obtaining a permit from the same permitting authority. Is that right?
Correct.
Okay. And so here then, expansion of the boat launch would require a permit from the planning board, correct?
Correct, yes.
And again, the town doesn't have any record of that, is that right?
No.
Okay. I'm gonna have, let's go back to Exhibit B and just have you just describe this.
Sure.
Okay.
Yeah, so this boat ramp was a wooden structure. Like I said in the presentation, it looks as though it was just 2 wooden pallets, end to end, used to transport kayaks, canoes, rowboats up and down the shore, since they can't do it from the rock because it's pretty steep already. And
okay,
the
and
stairs.
Alex, I'm just going to stop you for a moment, and I'm going to go to I'm going to show you for a moment some pictures that were just submitted today, that Leah re-forwarded to the ZBA today. These are photos that were included in there, and my understanding is, and you tell me if I'm wrong, that these show what the former boat launch looked like.
Yeah.
Okay.
Yeah, this
okay.
is definitely it.
So then here, that's what replaced it.
Yeah, I mean, it doesn't even look like the same lot.
Okay,
completely
right.
different.
I mean, it's clearly expanded, isn't it?
Oh yeah, definitely.
Okay.
I mean, it's much larger.
Okay, I'm going to go back to what management control also provided to the ZBA today. And in here, I don't know if you recognize this, but this is, you confirm it if to me, Alex, this is part of the application that Attorney Rachel described that was submitted to the planning board from Mike Morris. Does that look like what this is to you?
Yeah.
Okay. And I just wanted to point out here that in that document, here's what he stated. And could you just read that to the ZBA, please?
Yeah, the width of the boat launch was expanded to approximately 16 feet, largely as a result of the removal of a large tree stump that altered the side slope grade.
Okay, good enough. Okay. Let's see. I think that, and also actually, let's see. Okay, I think that pretty much wraps up for violation 3. Let's move on to violation number 4. Violation 4 is for enlargement or expansion of the shoreline without a permit. And here the shoreline zoning ordinance provides that where permanent piers, docks, wharves, bridges, boat launches, and other structures and uses extend over or below the normal high water line, approvals required from the planning board. And for all the reasons that the ZBA upheld violation 5 in the notice violation of management controls relating to Fernwood, you should also uphold this violation. But beyond that, Alex, could I have you describe the enlargement or expansion of the shoreline? And I'll go to the exhibits to the notice of violation for that.
Yeah, here in Exhibit B in the before photo at the very end of the arrow for existing boat ramp, you can see it curves in away from the water at the end of that peninsula, and in the after photo you can see that it's a straight line across. There's no longer the curve in where the water was coming in, so it's clear to me that this area has now been expanded towards the water to create more of a straight, cleaner angle.
And I think there was, I was kind of a little confused from the questions that Attorney Rachel was asking you, but I think what your testimony is that essentially the U is filled in. Is that basically what it is?
Correct.
And what has the U been filled in with?
Riprap.
Okay. Okay, I'm gonna have you look at Exhibit D here. You just describe what we're seeing there.
Yeah, so I mean, at the bottom here, you can see, that after photo, likely that shoreline kind of continued straight, kind of parallel with that silt fence, and then turned right once it hit that peninsula. But now it's kind of curving out into like more of a straighter line instead of having a jog in.
Okay. Okay, I'm gonna go to violation number 5. Now, violation 5 is for construction of a beach without a permit. And the shoreline zoning ordinance requires that the construction of any beach shall have a permit from the DEP. And for all of the reasons that you upheld violation 6 that was contained in the notice of violation of management controls relating to 18 Fernwood, you should also uphold this violation as to whitetail. So, Alex, could you walk us through this violation, please? And I'm going to go to Exhibit C.
Yeah. So yeah, what we're seeing here, then the before photo, there's some large boulders on the beach, rocks that don't exist in the after photo. My original assumption was that they were removed. I don't know if they were used to make the the riprap stabilization project work, or if they were brought into the water or offsite, who knows, or if they were covered with sand. Really, the end result is now a cleaner, smoother, flatter beach area.
Okay, very good. We'll move on to violations 6 and 7. So violation 6 is for clearing or removing vegetation less than 3 feet in height within 100 feet of the normal high water line, and the shoreline zoning ordinance prohibits that from occurring. Now, violation 7 is for clearing or removing vegetation without a permit, and the shoreline zoning ordinance prohibits clearing or moving of vegetation really of any height without a permit. And for the same reasons that you upheld violations 7 and 8 in the notice of violation relating to Fernwood, you should also uphold these violations here as to whitetail. Alex, I'm gonna ask you to walk us through these two violations here, and I'm gonna go to Exhibit D for that. Bear with me.
Yeah,
Okay.
so in the before photo, you can see that there's vegetation on the bank, and actually there's grass and some ground cover growing in this retaining wall, which is exactly what you want. And then in the after photo.
Yeah, I just want to be clear. And what you're talking about the vegetation growing within this hashed area that's marked by the hashed line?
Yes.
Okay.
Yep. And then in the after photo below, that segment of shoreline was replaced, and everything that was there has been covered or removed.
Okay, and then let's go to, just describe this to me.
Yeah, so here you'll see there's grass, natural ground cover, and shrubs, which have been completely removed. And I think it was stated that they were ornamental or landscape features that weren't serving any purpose. The ordinance doesn't differentiate between the two. Within 100 feet, vegetation less than 3 feet in height, or vegetation in general, is required to be removed under the removal standards.
Okay. Can you just describe this here too?
Yep. Again, here's that large section that I talked about before next to the house. That was grass. Originally, has been stripped of everything down to the water.
Okay.
And this is just a different angle of that same area.
Okay.
Yeah, I mean, this one is probably one of the more drastic angles of this particular property. You've got all of that vegetation, the ground cover in there that no longer exists. It's all been removed.
Okay. And just to orient ourselves here, is this the location here of the boat ramp?
Correct.
Okay.
That is it.
And just have you describe this here too?
Yeah, so you can see there's a few different spots where grass is, over the years grown up between this existing riprap. And that's exactly what you want, holding the bank together, absorbing rainwater as it comes down, and that's all been removed.
Okay, thank you. Now, as Alex pointed out, there's been some contention that this vegetation was of limited value. You should reject that argument here, because those issues would have been considered by the code enforcement officer if a permit had been applied for. Here, there was no application for a permit submitted. The code enforcement officer never had the opportunity to consider that, and you should reject that. And here, because this work was completed without a permit, it's a violation. And like Alex was just mentioning, whether the vegetation was within an existing lawn or ornamental shrubs, that just isn't relevant. What's relevant is whether vegetation less than 3 feet in height within 100 feet of the normal high water line was removed, and whether vegetation was removed without a permit. Both of those things occurred. Therefore, both violation 6 and violation 7 have occurred. Now, I just want to talk about violation 8. Violation 8 is for the unpermitted shoreland stabilization project. And there's some discussion about that. Alex, can you just describe what that violation consists of?
Yeah, I mean, there was, like we talked about before, there is an existing riprap shorefront here. The shoreline was all stabilized. There's no clear need for an erosion control project based on what we've seen on these photos. They, for some reason, decided that they didn't like the look of it, maybe. Maybe it just wasn't what they wanted. I don't know, but nevertheless, they went ahead and removed, covered, replaced what was there with new riprap without any permits.
No application for permit was made.
Correct. Yeah.
Okay. Okay. Violation number 9 is for completing a shorefront stabilization project without a barge. And for the same reasons that the ZBA upheld this violation as to Fernwood, you should also uphold the violation as to Whitetail. Now,
Mr. Chairman, if I may just register an objection, please.
Sure.
I've heard Attorney Wyckoff say on several occasions that for the same reasons that you should uphold the violations in Whitetail as you should on Fernwood. As I said in my initial remarks, I think it's really critically important to focus the board on the fact that these are two very different properties for all the reasons I identified. But I just want to make clear that is on the record.
I appreciate that. You know, you're right. What I'm really trying to say is for all, you know, for the facts are different, but for the reasoning that you employed with regards to the other property, that same reasoning should be used here, applying the facts relating to whitetail. So as Alex testified earlier, the stabilization project requires a permit from the planning board. And when that happens, the shoreline zoning ordinance directs the planning board to determine if access by a barge was feasible or not. Now, the contention by management controls that a barge wasn't feasible, you should reject that. You shouldn't pay any attention to the argument, because that issue would have been considered by the planning board had a permit been applied for. There wasn't an application for a permit ever filed, and the planning board never had the opportunity to consider whether a barge was feasible or not. So you should just reject that argument. So I want to have you, Alex, if you could just go to Exhibit E here and just describe what this photo, the significance of this photo.
Yeah, so this is a picture of Rob Grant's Big Lake Marine's barge and excavator moored on Sebago Lake, November 16th, 2021, just around the cove from where this property, the work has taken place, exists. So yeah, he does a lot of work throughout the summer on this barge. We see it all over the place.
And Mr. Durant, you've spoken to Mr. Durant about the concept of doing restoration work here this fall. Is that right?
Yeah.
And what did he say about the concept of using a barge to do the work?
Well, it was brought up on site when we met, I don't know, a couple of months ago at this point. Whoops, sorry. We met on site and it was discussed about who would do the restoration work and when that would be done, and would it be feasible to do the work this fall. And Rob stated that he felt as though he could do the work to the 28 whitetail property from the barge.
Okay. Okay. Next, I want to talk about violations 10, 11, and 12. Now, in the appeal, management controls contends that trees were removed to accommodate construction equipment. Now, you should just reject that argument, because that issue would have been considered had management control sought a permit, but as is clear, no application was submitted. So you should just reject that argument. And then there's also a contention that these trees would have been hazard trees and they could have been removed. You should also not credit that argument at all, because those issues would have been considered by the code enforcement officer had he been consulted as required by the shoreline zoning ordinance relating to hazard trees. Now, violation 10 is for violating the shoreline zoning ordinance's prohibition of removing trees that create an opening in excess of 250 square feet. Violation 11 is for removal of vegetation in excess of what's allowed by the point system contained in the shoreline zoning ordinance. Violation 12 is for violating the prohibition against removal of vegetation without a permit as a result of removing vegetation between the house and the water here. So the shoreline ordinance does allow hazard trees to be removed after consultation with the CEO if one canopy opening would be less than 250 square feet. If the canopy opening is greater than 250 square feet, then replacement with native trees is required, and the ordinance requires that stumps may not be removed. So now, Alex, was there any consultation with you regarding any hazard trees and removal of any hazard trees?
No.
Okay. So as a result, we don't know whether or not they were in fact hazard trees. Fair to say?
Correct.
Now, under the ordinance, if someone comes to talk to you about the removal of hazard trees, I understand you could require submission of that evaluation to a forester regarding hazard trees. Is that right?
Correct. Yep.
But that never happened, right?
Correct.
Okay. Now, an opening in excess of 250 square feet can be created, and if that happens, then there has to be revegetation, and revegetation can only occur pursuant to an approved revegetation plan. Was that submitted in connection with the removal of the trees?
No.
Okay. I'm going to have you walk us through the violation. I'm going to go to Exhibit F. Can you just describe this, please?
Yeah, so here we're seeing in the before photo, 11 trees that were removed for the erosion control project illegally without a permit.
Okay.
That's a perfect example of something that would get reviewed under the permitting process for an erosion control project, stabilization project.
Okay.
And here we're looking at,
go ahead.
Yep, 10 through 14 in the before photo, and then the approximate location of those trees on the new segment of shoreline.
Or rather,
today.
the non-existence of the trees than being removed.
Correct.
Okay. This photo?
And we're looking at, 11, 12, and 13.
Okay.
Which I don't see how, 12 and 13 were likely removed for the replacement of the wall. I would assume they clearly wouldn't have been hazards. I can't see how they would have been, but.
In any event, they were removed.
Correct.
And that was in violation of the ordinances.
Correct.
Okay. Can you describe this picture, please?
Yep. And here we're looking in the before photo of tree 14 as we identify them, and the after that tree has been removed.
And you weren't consulted about what that tree was like, and so you don't know what kind of tree what it was like.
Correct. Yeah.
Okay. Can you describe this page, please?
Yep. And again, before we're looking at trees 1 through 10, and then the after photo, the approximate locations of trees 1 through 10 during construction of the project.
Okay. Now, how do you know? So describe this this page, please. This last page of Exhibit F.
Mm-hmm.
Can you describe it, Alex?
Yep. So here we're looking at the aerial photo from, I believe this was 2018 Google Earth, and this is showing the areas where trees have been removed. And it's included, I've added some dimensions to give you an idea. 25 by 60 is in excess of 250 square feet by a good amount. And then you add in the other 2 sections and you exceed the standards for what's allowed to be removed.
Okay. And all of those trees that made up those bubbles are trees that have been removed. Is that right?
Correct.
And that was depicted in the photos we just looked at, that those trees that were removed.
Correct.
Now, earlier we heard Attorney Rachel was asking some questions relating to the notice of violation and what it stated could be done in order to eliminate the violations. And I just want to have you go to that page and read that to the Zoning Board of Appeals. She was trying to make it sound like the town was asking only for submission of after the fact permits. And I just wanted to have you relate to the board what the notice of violation actually said as to how they could be remedied. And you could just, first is for violations 1 and 2. Could you just describe what the notice of violation says?
Yeah, for violation 1 and 2, well, the above it asks for a global restoration plan, which should include the following. And then for 1 and 2, they needed to obtain after the fact permitting for filling and earth moving that occurred of more than 10 cubic yards. And if you cannot obtain a permit, restore the area to its condition before the filling and earth moving.
Yeah.
Yeah, and that's it for that one.
And really, that's the case for all of these violations, that the town asked for either to obtain an after the fact permit, or if that wasn't possible, to restore the site to its original condition. True?
Right.
Now, I think you said it, Mike Morse did submit an after the fact application to the planning board. Is that right?
Correct.
Do you have an understanding as to who actually hired him? Was he hired by Management Controls?
I believe he was actually hired by Rob Durant.
Okay. And did you review the restoration plan that he submitted?
Yes.
Okay. How did you evaluate it?
We found quite a few deficiencies, things that we were just a little disappointed by.
Okay. Now, do you have an understanding about what the status of that application is?
I believe it was submitted and then tabled. And I believe at that point, Mike Morse had contacted Sandy to let her know that this likely would need to stay tabled for a while.
Okay. So it's your understanding that he basically said to Sandy Fredericks, this should just be tabled until we let you know otherwise.
Yes, I believe so.
Okay. Okay, I just want to address some procedural arguments that have been made by Management Controls. They contend that it contends that violations 1 and 2 are the same violation, and that they're only listed twice in order for the town to seek duplicative fines. And the same reasoning that the ZBA used with regards to a similar argument relating to violations 1 and 2 as to Fernwood, the ZBA should also reject that argument. These are two separate violations. Violation 1 is for filling and earth moving without taking steps to prevent erosion and sedimentation. Violation 2 is for filling and earth moving without a permit. Even if a permit existed for filling and earth moving, there would still have been a violation, the failure to take steps to prevent erosion and sedimentation. And even if steps were taken to prevent erosion and sedimentation, but the work is done without a permit, it would still be a violation. Now, to the extent that Management Controls is making any argument relating to fines, you should reject that. Fines, that's a separate issue from violations, and the ZBA doesn't have any jurisdiction, doesn't have any role with regards to assessing fines. So that's really beside the point, and it isn't something that the ZBA should be considering here in connection with the appeal. Management Controls also contends that violations 6 and 7 are the same violation, and they're only listed twice in order for the town to seek duplicative fines. So just like I said, fines, that's not for the ZBA, doesn't have a role in connection with assessing fines. So that's just an argument that you should disregard. You should also disregard this for all the same reasoning you employed in the other appeal as to Fernwood. These are separate violations. Violation 6 relates to violating a requirement that vegetation less than 3 feet cannot be cut, covered, or removed, except for a footpath. Violation 7 is for moving vegetation without a permit. If there had been a permit, removing the vegetation less than 3 feet tall within 100 feet of the normal high water line would still generate a violation. So these are just separate violations, and you should reject this argument. Management Controls also makes a procedural argument relating to violations 3 and 4. And they contend that these both cite the identical provision of the zoning ordinance but are included as two separate violations, and it's only being done in order to seek duplicative fines. Same story there. That's not for you to deal with. Fines aren't something the Zoning Board of Appeals deals with. These are separate violations. 3 is for expanding or enlarging the boat launch without a permit. 4 is for expanding or enlarging the shoreline without a permit. They're separate violations and they don't rely on one another, and you should reject that argument. Management Controls also contends that 10, 11, and 12 are the same violations because they all involve unpermitted tree removal and are just redundant for seeking duplicative fines. Same thing there. Fines aren't for the Zoning Board of Appeals to deal with. That's not your issue to deal with. You should also reject this argument for all the same reasoning you employed in the other appeal as to Fernwood. These are separate violations. Violation 10 is based on the shoreline zoning ordinance, which prohibits removal of trees within 100 feet of the water that creates an illegal open in excess of 250 square feet. Violation 11 is a separate provision in the ordinance. It allows selective cutting of trees within a buffer strip as long as you maintain a stand of trees and other vegetation, and if other trees are present, that provides sufficient points to allow for selective cutting. 12 is removing vegetation without a permit, and it relies on a separate provision in the ordinance. So these are separate violations relying on separate provisions in the ordinance, and they don't rely on one another. I don't have anything else. Thank you.
Thank you. So Attorney Wagner, if I understand correctly, at this point, the zoning board can ask questions of Alex and great. So I do have a couple of questions, Alex.
Just to clarify, again, will I have opportunity to question the witness and participate in the proceeding?
Yes, after the board has had an opportunity to have questions, and Attorney Rachin, then we'll turn it over to you and any members of the public.
So Alex, for the notice of violation, specifically number 3, where we're talking about boat launch, there was a picture shown. I think it's under Exhibit B, and it shows the stairway, and then it shows the picture of the older boat launch, and then there was a reference given in that picture of the width of the older boat launch. Is it possible to bring that picture up again and essentially point out where?
I can share my screen.
Yeah.
I think, is this the photo you were talking about?
Yeah, especially the one on the before on the bottom. Just, I can see clearly, I can see the steps. Can essentially with a pointer show sort of like the width, you know, the side to side of the boat launch from that view. Is that an option?
Oops, sorry.
It's kind of coming blurry. So is there any chance with a pointer to just say, you know, point out from left to right, this is where you perceive the width of the pre-existing boat launch?
So I think you're asking Alex to do that, and I'm trying to figure out how to do that logistically. So this is on my screen. Oh, he's doing it. You're muted, Alex.
I love Zoom. Zoom is great. Sorry. Once you're in that particular menu, like you can't mute or unmute yourself. So, all right. Yes. So from here, it's black too. So hold on. I'll do it white. From here to here. From here to here. You see that one?
I can see, and I can even see the black one too. Okay, thank you very much for that.
Yeah, no problem.
For number 4, we're talking about the shoreline. The reference is to section 14, table of land uses number 17B, permanent piers, docks, structures, wharfs, bridges, boat launches, and other structures. Is the contention or the argument that shoreline is a structure?
Yes.
Okay. Do we have?
It also says uses.
So when we wrote this up, what is it? Are we defining shoreline as a structure or a use?
Hold on 1 second. I'm trying to find something that will help answer this question. If you want, I think Leah jumped in. If you want to maybe let her speak, and then I can circle back to.
I'm sorry, I didn't mean to interrupt the question. I just wanted to clarify that, you know, under this section, we're talking about piers, wharves, docks, those kinds of things that if you look at the definition of structure, it talks about, and I don't have it in front of me, but housing people and you know, a shoreline does not fall within those things that are traditionally associated with structure. I know that there was an indication of use, but again, if you look at the land use table, right? And if I could, can I share my screen for a moment? If that would be helpful?
Actually, yeah, I think I'm just gonna rely on Alex to provide us. All I'm looking for is where was Alex coming from when he
Okay,
wrote
fair
this?
enough, fair enough.
So, I mean, in this particular situation, we rely on what the ordinance says, and you know, under piers, docks, wharf bridges, and other structures and uses extending over or beyond the normal high water line or within a wetland, there's temporary and there's permanent. A permanent is a structure which will remain in or over the water for 7 months or more in any period of 12 consecutive months. The table, you know, lists who is the permitting authority. Then if you go to that particular section in the ordinance, it has standards specific to piers, docks, wharfs, bridges, and all that other good stuff, which is 15C. It's listed as other structures, and I believe the intent here, and this is something, you know, I've had conversations with Jeff Kalinich at DP. The intent is to treat it as a structure because a retaining wall at the shore to correct a stabilization or a erosion control issue usually is at or below the normal high water line. So that puts it below the normal high water line for more than 7 months a year, which makes it a permanent structure or other structure. And that's the interpretation that I've relied on.
Okay, thank you. For number 6, removal of vegetation less than 3 feet in height. We have the shoreline zoning reference, and then you also, in the beginning of that section, listed, you know, your own comments. Was the first word in this where it says all existing vegetation is all just an unfortunate use of words?
Yeah, it definitely is. And that's what I was trying to get at with Leah earlier. It's like, I you know, I understand exactly where you're coming from on that. Clearly, all is not the best word choice for that. And that is an oversight on our part.
2 more questions, Alex. For number 5, construction of a beach without a permit. It appears that there was a beach there previously. Can you construct something that's already there? Or
I would pose it in a question like this. If you have a beach that's covered with large rocks and you bring in sand to cover those rocks, do you feel as though that would be beach construction? Maybe the beach is already there and there's large rocks on it, but have you improved the beach? Have you done any activity, any construction activity to that beach? Now, if you go down there and you have a beach that's covered with large rocks, maybe 6 to 12 inches in diameter, and you go down and you pluck those rocks out, you remove those rocks, are you improving and continuing to construct an improved beach? And that's how I looked at it. Yes, there was, you know, an area that's flat for them to sit on and hang out. But did they actually go down, and was there construction to that area to improve it? That's the question I asked. And to me, there.
do you view just okay. And
David, I think one thing, sorry, we're not saying they created a new beach.
Right.
That's how I think I can best answer you. We're not saying there's a new beach here. They may have had a beach before, but there was improvement activity to that beach without a permit is what we're saying.
Okay, very good. My last question, Alex, is for number 8, permitted shoreline stabilization, no permits. There's been mention of this permit by rule I'm not sure if this is the appropriate place to ask it, but how does a permit by rule come into play?
So they applied for a permit by rule, I believe, in July of 2021. Under the process for a permit by rule, you submit this application to the state, and if you hear nothing within 2 weeks, you are approved. Alexis Savalos of DEP reached out a few weeks after they submitted it to let them know that the application had not been approved and was marked deficient. I believe they exceeded the length allowed. You're only allowed to do 100 feet of shorefront, and they were proposing much more than 100 feet with the two contiguous properties. They were, I believe, their opinion was that because the two properties were together, they thought they could do 100 on each to do a grand total of 200, I think. I don't want to get too much into this because that's DEP and I wasn't involved in that. All I know is from what we were told by Alexis, they did not have an approved permit for what took place on site.
Thank you, Alex. That's it for me. Any other board members? You have questions for Alex? Great.
Yeah, I have a question on number 5, and back to the beach. Perhaps you could pull up the before and after photos on that. Either.
Sure.
Anybody, what's wild card?
All right, so the beach. Yep.
Yeah. So Leah did a pretty good job, I think, at kind of establishing a timeline. I just want to verify the timeline of these photos. So actually, if you could zoom out so we can compare the, I'm looking at the water line and what is likely the time at which these photos were taking place. Can you explain the before photo? When was that taken?
The before photo was taken in August of 2021. The after photo was taken October 2021.
Okay. So there's a substantially lower water line in general between those two times of the year.
Yeah, so you've got this rock down here, which looks to be somewhere around here.
Okay.
So I guess what I'm wondering is where are all these dark rocks here? That should be right here.
Yeah, and are you suggesting that those were covered in the after?
Well, in the photos that Leah showed earlier from yesterday, there's now rocks in here that were not there in October of 2021. So I don't know if the sand that was here has eroded away.
Yeah.
So I'm trying to figure out, maybe with you here at the same time, how in August of 21, it looked like this up here. And then in October looked like this. And then now today, again, looks like this, if that makes any sense.
I mean, sand kind of does come and go a little bit on a beach. It's not necessarily guaranteed that.
Hey, Alex, this is Tom.
Hey, Tom.
Okay. Go ahead.
So all the black rocks disappeared, and then what Leah showed us of today's photos, there's new rocks thrown in there from some source. Is that what my takeaway is? Someone threw in some additional rocks and.
Well, I don't really know what the conclusion is on that. I mean, the other possibility is you can get a permit from DEP to rake sand out from the lake up onto the beach. Although it doesn't look like there's much down here for sand. It looks like you got a lot of rocks right here. So you can go in and rake some of that out if you have an existing beach. I don't know that happened. I don't know. Wave action could have pushed sand up, but again, if this was all sand here, I would say that's possible, but where did all of this sand here come from? Is the question. For me, like I said to Dave a minute ago, I'm not arguing there was no beach. I think there was a beach. I think there has been some type of activity that's taken place on the beach that has improved it. And that's why they were given the notice of violation.
I see, but you can see that there's a certain amount of flux in the natural change of a beach anyway, and what I guess what you're saying is that your opinion is that it exceeded that threshold.
Yeah, yeah. Based on what we saw when we went down in October of 2021, we felt there was a significant change that had taken place.
Okay. And then I have just one other question on, I always get, this is always a tricky one for me, but 6 and 7, if we could pull up an example of a violation of 6, discrete violations of 6 and 7, where they're not kind of overlapping. I think just in particular, I have a hard time understanding the distinction. I know you're referencing different ordinances. I just was hoping you could point out specifically where 6 was uniquely violated and where 7 was uniquely violated.
Yeah, so 7 is the table. So that's the actual activity without a permit. And then 6 is the actual removal for the project, for the erosion control project. So you can, like I had said before, you can remove vegetation less than 3 feet in height for an allowed use or permitted project. And that's allowed. In this case, there was no permit issued. Had they gotten a permit for the stabilization, that tree removal would have been allowed. But they didn't get a permit for that. And then they didn't get a permit for just the tree removal for that, for vegetation less than 3 feet in height. So people often will apply for a permit just to remove vegetation less than 3 feet in height within 100 feet, which is not allowed. The only time it's allowed, like I said, is for permitted use or if you're creating a 6-foot wide meandering path for the water. Now that removal doesn't necessarily mean you're going in and pulling up, what's there. It can be trimming it, it can be covering it, it could be putting a tarp over it for 6 months, all sorts of different things. Now, I don't think that's going to answer your question based on how I've seen you handle this one in the past. But what I will say, I'm going to go back to my old one. Let's say theoretically they went down there and they built a house 25 feet from the water, and they didn't get any permits to do it. There's multiple sections in the ordinance they would be in violation of. It's one activity. The building the house is that one activity, but they would be in violation of the 100-foot setback. And they'd also be in violation of the requirement to get a permit. So we have to, when there's a violation that takes place, we have to look at the ordinance and determine out of this, couple 100-page document, where all the violations are and which sections they're in violation of. So that's why we approached it that way.
But is it fair to say if they had a permit, then both of those violations would go away?
Yeah. I think all of them would, most of them.
But for the vegetation less than 3 feet, right?
Yeah.
Right.
Yes.
So then, yeah, I mean that's I'm having
is there a situation? Whoops, sorry, go ahead.
No, I understand that when there's specific subcategories, like there's a point system for trees, there's canopy coverage, there's like erosion control, and then there's just certain thresholds of moving earth that are kind of different specific things that you could uniquely violate. This one, and the reason why I'm bringing it up, and I hate to belabor the point, but I think this one, 6 and 7 seem really hard for me to tease apart, and I was just hoping we would try it again. I think we're kind of at a similar junction.
Yeah, and I think one thing you said last time was, is there ever a possibility where someone could get a permit for the activity and then still be in violation of the other one, right? And they could get a permit to remove vegetation for less than 3 feet in height and then exceed what was allowed under that permit and be in violation of the specific standard, exceeding what's allowed under that with having a permit in hand. Now, you probably argue that they then don't have a permit for that portion of the activity, I suppose, but that would probably be the only situation where that would work.
Yeah, I understand what you're saying. I'm not sure I'm quite moved that much than my previous understanding, but I get it. That's it for me.
Dave, can I ask Alex a question?
Yep, please.
So on the tree removal, even if it's permitted to be removed, you're not allowed to remove the stumps, correct?
That is correct, within 100 feet.
Now you're allowed to grind them down.
Correct.
So do we know if them stumps were removed or if they were covered or ground? Or?
We believe they were removed. At least the large stumps at the shorefront. And that was actually, I believe, in Mike Morse's submittal that Eric brought up earlier that had me read from. I think they actually removed a stump at the shorefront, and that was the reason for expanding the boat ramp.
That's all I have.
David, can I ask Alex one last question?
Yeah, of course.
Alex, I know the town owns several boat ramps on different lakes in the town of Raymond. Is there any of them that are 16 feet in width besides the Sebago Lake double ramp?
You know, that's a great question. I'm not sure, to be honest.
I bet they're not. Just
yeah, probably not.
I've been to 2 or 3 of them, so just ammunition for you.
Pete, did you have any questions? You're on mute, Pete.
Yeah, I don't have any specific questions for Alex, but I do have a comment that I'd like to make, if that's okay. Is this appropriate to do that?
What do you have to say, Pete?
So I took a quick look at the letters from Q Team, and I just wanted to point out that the first letter does not make any specific reference to either property, but the second letter does specifically identify 18 Fernwood.
Thank you. So Attorney Wagner, does this, I believe, that we allow Attorney Rachin opportunity?
Yes, Attorney Rachin, and then I turn it over to Attorney Braun and members of the public.
Good. Attorney Rachin.
Thank you. I just wanted to state for the record, because I'm required to do so, to preserve any issues that or concerns I have. I just wanted to make clear that I don't think it's appropriate for board members to be advising the code officer about ammunition that they should have. And I think that that's inappropriate, and I'm just registering that as a possible indication of bias or due process. So I will leave it at that, but I do need to register that for the record. I just have a couple follow-up questions, if I could, for Alex. I think on a couple of occasions that I wrote these words down, so I think they're correct, but you said that the riprap was replaced or removed. I think you said that both of those things could be true. And I just want to go back to a picture of the property itself. Let's look at this. I'm going to share my screen in just a minute. Can you see my screen here?
Yep.
Yes.
Okay. And so clearly, I mean, we've got quite a large boulders here. Fair to say those would be pretty hard to remove. Or let me ask a different question. What evidence do you have that the existing riprap wasn't in any way removed? I mean, did you look underneath the new riprap that covered it to maintain it, or do you have any evidence?
No.
Okay.
I did not look underneath
Okay.
the new riprap. No.
So to the extent that you said it's replaced or removed, we don't know that's the case, correct?
I mean, we would rely on you to let us know if there's anything different than what we're saying. I mean, if it hasn't been replaced or removed and it's been covered over, then that would be good to know.
Okay, so that I'm going to ask my question again. Do you have any evidence to suggest it has in fact been replaced or removed?
No, I guess we don't. Unless you want to help us with that.
Okay, so the next question I wanted to ask you about is with respect to the boat ramp. And I'll pull up some pictures of that if I can. There we are. And I think you had mentioned a couple times, you talked about how its pitch has changed or its slope has changed. Can you just talk about what your basis is for that? Did you measure the slope, or what are you basing that on?
Based on where that boat ramp lands on the before photo, it's much further back.
Did you measure it at all?
Yeah.
How did you measure that? With
Just
what?
based on visually, I mean, looking at that.
Okay. So no, I think you had mentioned,
How would we measure that with the survey equipment, or what would you accept for a measurement on that?
I'm asking you if you did measure it. I'm not suggesting options. And I heard you say no.
Well, I mean,
I'll move on.
what would be a measurement, I guess, is my question, because it's possible we did measure it then, depending on what you're looking for.
You talked about how I think you said you believed that there were stumps removed, and I think you mentioned that there was one place in particular near the boat ramp. But with respect to all of those other trees, do you have any evidence to suggest that those stumps were removed?
I believe we do. Let me just take a look.
And while you're doing that, well, go ahead. I'm sorry. I don't want to interrupt you.
Yeah, I mean, the best evidence I think we have would be under Exhibit F, which shows no stumps.
But those stumps can be ground to the level of.
Yeah, I don't believe they were. No.
Based on what though? Is what I'm asking.
Testimony from Rob Durant on site.
Okay, and what about the evidence? I believe of.
And I don't understand. That wouldn't make sense to me why they would remove one or two, but not all. When you're going to be stabilizing a bank, you're not going to put filter fabric and riprap over, tree stumps.
But isn't it your testimony that's what standard?
No, I'm saying they have removed the tree stumps.
Okay, but you didn't. Have you observed any sort of areas in the land that show that there's a gap? That usually when stumps are removed, it's my understanding that there's some, I forget the word, but you can see in the land that there's a depression there.
Well, unfortunately, the site was completely altered and filled and graded, so there's not going to be very much evidence after the fact. The site was very soft, I can tell you that. It was not as firm as it would be if there was, 12 or 10 stumps holding a bank together.
Okay. One question was going to the PBR, and my understanding with permit by rule is that when an application is made to the state, that towns are notified. In fact, I believe that states that on the application itself. Were you notified by the DEP of the application?
Nope, the state does not notify the towns, even though it's on the form.
And okay, so you're saying as a practical matter, even though the permit actually says that they do not?
Correct.
And you did not, in this instance, receive notification?
Nope, I saw all this in October.
Okay. And regarding the Google Earth, I'm going to just circle back on that, the measurements that you used with respect to Google Earth. Mm-hmm. And for some reason, can you bring yours up, that Exhibit F, to the notice of violation? Would you be so kind to do that?
Yep. It looks like you'll need to stop screen sharing first.
Oh, yes, of course. Sorry. Thank you. Mm-hmm. And can you tell us when that was actually taken?
Yeah, this is a 2018 aerial photo.
Okay. And those measurements that you put on there, you talk about these bubbles, right? Yep. Just so I understand, you talk about bubbles, but it really is supposed to be a grid, correct? There's like okay. Yeah. And these don't look like grids to me. they are not that sort of, I think it's at 25 by 50.
Mm-hmm.
Okay. So you'd agree with me that a grid tends to be a square rectangular
Absolutely.
area. Okay.
Yep.
So with respect to Google Earth, I see that you put these on. You drew these, right? These measurements here.
Correct. Yep.
And how do you know the margin of error with Google Earth?
I don't know. No one's ever questioned it.
Okay, and that's the scale. With respect to camera height and such, doesn't that make a difference as to what the scale is?
Yeah, but that's usually calculated based on the height. That's how it works. At least that's my impression of the technology.
All right. And the after photos that you have, you don't have Google Earth after photos, correct? That would show the beam area?
Not included with the NOV, no.
Okay. All right. A couple more things. I'm trying to find that picture of the boat ramp at the bottom, right?
Mm-hmm.
And you talked about how there'd been some filling there.
Yep.
And again, the violation, I think, references at or on or below the high water mark, correct?
Mm-hmm.
So tell me where the high water, can you on that picture point out to me where the high water mark is? Actually, I want to find the photo. Oh, here it is. Yeah, if you would do that.
So this particular day, it would be here.
Okay, so how on any given day, I thought that the high water mark was what the high water mark was. I think, like you mentioned, that website. And doesn't that website sort of specify 266, or I can't remember what the numbers are, but are you suggesting that the high water mark changes on any given day?
It changes depending on what the town's ordinance says. And our ordinance doesn't specifically take the elevation of the water.
Okay, so when you put this line in that you put in, what are you basing that on?
Basing it on where the water is right there. I can tell you observed change in vegetation is going to put the high water mark much higher. So that would be up here. But realistically, that's not the normal high water mark. So in this type of situation, the way we handle it is we accept a surveyor's decision on where that mark is, which they did do.
Okay, and so this lower mark here is the surveyor's position?
Nope, that was ours based on our site visit that day, having to determine a location.
All right. I think as far as cross-examination, that is it for me. My understanding is that Greg will now go, and then I'll have a chance to summarize.
I would say, yeah, Greg would go. I would then give an opportunity for Attorney Wyckoff if he has any re-examination, and then you as an appellant would have the last word.
Thank you so much.
Attorney Wagner, when's the best time to open this up to the public? We don't have any members of the public, but.
Well, I would turn it over to Attorney Braun and then the public after that.
Very good. So, Attorney Braun.
Sure. So
you have to say.
Going to touch on an awful lot that Leah has already touched on. So I'll try hard not to be repetitive. But to the extent that I am, it's important, I think, to make sure the record establishes certain facts. And so I just want to confirm some of the statements or testimony you previously gave. First, you indicated that you have no background or training as an environmental engineer. Is that correct?
That is correct. Code officers are not required to be.
Okay. And you have no background or education in surveying. Is that correct?
That's correct. Code officers are not required to be.
Okay. And similarly, no background or education in geology.
That is correct. Code officers are not required to be.
And no background or education as a civil engineer.
That is correct. We are not required to be.
Right. And so the extent of your training and knowledge base here, you indicated was based on your state certification to become a code enforcement officer, correct?
Yep.
All right. When did you obtain that certification?
2015, I believe.
Okay. Are you required to do any sort of a continuing education to maintain that certificate?
Yep, we are. I was actually recertified in January, I believe.
All right. And as part of that certification in your position, are there any sorts of best practices that the office requires or obligates you to follow?
No, we just need to make sure that we maintain the amount of continued education credits per year that we need to keep the license active.
All right. Surely it teaches you and gives you some idea of how to do your job, correct?
Yep.
All right. And so based on your training, when you're advised that the violation may have taken place, what does that training tell you you should do?
We need to basically notify the violator that the violation is taking place. And then tell them to stop work.
So your training then, you're testifying, doesn't provide you any sort of instruction or guidance on how to determine whether or not a violation is actually taking place?
Well, yeah, we must use the ordinance to determine that.
All right, and the ordinance tells you what is legal and what is not legal, correct?
Yep.
Okay, but what does your training tell you, or how does it instruct you to determine whether or not that law or ordinance has been followed or not?
I guess I don't know how to answer that question, Greg.
Okay, so I'm just trying to clarify here that through your code enforcement officer training, you can't speak to any specific protocol that you learned as it relates to establishing whether a violation took place or not?
Yeah, there's a CEO handbook that the state issues.
And what does it say as it relates to establishing whether a violation has taken place or not?
I don't know that off the top of my head.
Okay. Did you review it before you went out and saw this property?
We often will review that when we are looking for different, procedures and rules.
Did you do it before you went out and looked at this property?
When specifically?
Well, I guess you indicated you went out on October 26, 2021, based on some photos and reports that you'd received. Did you review your code enforcement handbook as it related how to establish whether a violation had taken place?
I did not review the CEO handbook on October 26th, no, 2021.
And in fact, you testified that when you went out to the property on October 26th, you brought no equipment with you whatsoever.
That's not true now.
That's not what you testified to?
That's not what I testified to, no.
Okay, well then clarify then. What did you bring with you when you went out to the site?
I had a cell phone.
Okay.
Yeah, that's
all right. So
camera, notepad,
equipment, and the extent of your equipment was you brought your cell phone with you. That's what you're testifying to.
Yeah, that's what I had in my pocket. But of course, we do keep a toolbox with tape measure, pop level. We keep all of this stuff in the car. Of course, we have all that stuff with us.
Okay.
Notepad right on the phone, camera right on the phone, measurement tool right on the phone.
Okay. So you brought all of that with you.
Yeah.
Okay. How many times have you been out to the property?
3.
Have you ever asked for permission to visit the property and been denied?
No.
How far is it from the office, just roughly?
About 20, 25 minutes.
Okay. And so you've been out there 3 times. At no point have you ever been told you couldn't visit the property.
Yep.
It's in close proximity to your place of work.
Yep.
You bring tools with you when you go.
Yep.
And yet, in all of those visits and in all of these processes, you never once took a single measurement, did you?
Of course we did. Have you not been listening? I mean, we've taken measurements.
Using your cell phone.
We've taken all sorts of different measurements. And
Using
yes, they've been on a cell phone, not just a cell phone, Greg.
Did you at any point pull out the tools that were in your toolbox?
Yes.
Okay. So when you were asked earlier what kind of measurements you took, and you did not indicate that you used a tape measure or a level or any other tools, that was not true?
I guess I don't see how that's relevant.
Well, I'm trying to determine how, in fact, you came up with the measurements that you came up with.
Which I've already told you and the board and Leah.
So exclusively then using your cell phone?
No.
What other methods did you use?
We use Google Earth measurement as well.
Okay, Google Earth. In your code enforcement officer certification class and continuing education that you take, does it discuss the use of this iPhone app to measure distances?
No.
Is there any training program related to that app?
No.
Okay. In your code enforcement certification course, did it discuss using Google Earth to establish measurements to determine
No.
if a violation is it? No. Okay. Are there any training courses related to it?
Yes.
To Google Earth?
Yes.
Have you been certified in a Google Earth training course?
I've not.
Okay. Are you aware of any studies or evaluations that determine the accuracy of these programs?
Yeah.
Okay. Can you please clarify or expound upon those?
If you want to give me a few minutes to pull it up, I can.
All right. So currently you have not, is that correct?
I'd know off the top of my head, no.
Okay. And in fact, you indicated that you had run a personal test related to this iPhone app. Is that correct?
Yes.
That in the past, you had run a tape measure and then walked it to establish whether or not the distance was the same.
Yes.
And you found that it was the same.
More accurate than
to
tape.
an extent, correct?
Yes, because you understand horizontal measurement, correct?
Right. So
Right.
there was a difference in the length that the Google or that the iPhone app told you and what your tape measure told you. Is that correct?
Right, because the tape measure is not completely level, correct?
Okay. So do you think there's any risk in relying exclusively on your iPhone app and Google Earth to make these measurements and determine whether or not a violation has taken place?
Absolutely not.
None whatsoever.
No, absolutely not. No.
These are records that you can rely on, or measurements that you can rely on.
Absolutely. Yep.
Okay. And you think it's fair then to say that online databases like this are accurate and correct?
Yeah.
Okay. So
I have,
I'd like
I
to,
have no issues with confidence when it comes to the measurements that we've taken on site.
Sure. So if I can, and I don't know how to share the screen, I guess I'd ask real quick just to have permission to do that.
Greg, yes, you have permission. I'm going to ask that we take like a 2-minute break. I need to step away briefly and come right back. Okay, I apologize for this, but I gotta step away. We all good with taking a 2-minute break?
I'd like to finish this line of questioning before
I would love to allow that for you, but I got to step away for a few minutes and I'll be right back. Okay, thank you for your patience and I apologize for the interruption. Attorney Ron, please continue.
So where we last left off, I just asked Alex about his belief and trust in these online databases and systems. And I'd asked if you would please allow me to share my screen.
Yep, from my perspective, please go ahead.
Well, I got to do it. I don't know if I can. Let's see here. Okay. All right. So we'll just go ahead and take this Exhibit F. This comes from your notice of violation. It's one of the attachments, correct?
Yes.
All right. And you've been asked a lot about these clouds that you drew in on this picture, but I want to specifically draw your attention to the white lines that are here. Those indicate property lines, correct?
That's the tax map overlay. Yep.
And you indicated that those are wrong, did you not?
Incorrect. Yep.
Yeah. So this is an online system that taxpayers in fact use to establish ostensibly their property lines, and you've used it as an exhibit here, knowing that the property boundaries it indicates are wrong. Is that correct?
It's a tax map overlay. I'm sure you understand tax maps are often incorrect. The tax map and the property lines don't have anything to do with the exhibit.
Well, they're here for some reason, correct?
Yeah, because I have the KMZ filed and installed on my Google Earth, so I can find properties easier. It has nothing to do with 25 by 60 foot canopy opening.
Well, I'm not asking about that. And so you indicated that
Well,
this overlay.
You're asking why it's part of the exhibit. I'm telling you why it's part of the exhibit.
All right, and you just indicated that these white lines and this overlay, in fact, are part of Google Earth, correct?
They are part of Google Earth, but they're tax map lines. They're tax map lines, just like we have the parcel maps. What would I have done to show this violation? I could have drawn this on a tax map, not use the image overlay.
Okay. What could you have done to demonstrate and show this violation? It's a good question, Alex. That is a really good question. So, all right, let's come back here. Let's look at before and after, right? These are befores and these are afters. Can you indicate in these after pictures where you used a tape measure or another physical device?
I'm not gonna carry that on because it's 10 o'clock. But listen, I'll explain. I'll answer your question. I was going to, but you interrupted. I use the tools that I have available to me to display where I found the violation and how I found the violation. I use those tools that you keep mentioning. And I feel like I did a pretty good job with displaying where they're in violation of that canopy opening.
So it's an honest statement then that at no point did you use a tape measure or another physical device to measure any distance on this property.
We had a tape measure on site.
But you did not use it.
In fact, Jeff Kalinich and Chris Hansen were on site a week after this picture was taken, and they measured everything with a tape measure.
All right, but you did not.
My assistant went for me because I was in a meeting.
All right, and her measurements are not included in your notice of violation.
Yes, they are.
All right.
How do you think we put that together? We used measurements from on site. Now, Chris has been to the property more than 3 times. He is my assistant. He went and took some of these photos.
But
I signed
you used an iPhone to make these measurements.
Greg, you just wasted the last 10 minutes trying to make a point that I didn't actually pull a tape measure on site. I'm telling you, my assistant pulled a tape on site with the shoreline zoning coordinator for DEP.
Okay, so let's
Just
look.
drop it.
Let's look at the before and after photos here in Exhibit B. You indicated this stairway here is still present, correct?
That stairway was in this picture used as reference.
That's right. But the size of it is just an estimate based on your best guess of what a standard commercially available stairway might be, correct?
Yeah.
Your previous testimony was that you did not measure that stairway.
That's correct. We were not there. We were not able to measure the old boat ramp because your client pulled it up without getting a permit.
Sure.
Correct? Correct.
So, but you've used it, right, this good faith, best guess analysis to ascertain or establish what you think not only these measurements are across here, but also what this new ramp might be. Is that correct?
No, we pulled that right from Mike's document as we displayed earlier.
All right. So you're saying you measured this physically yourself to establish.
We have measurement, yes. I did not myself, no, but I had my assistant go do it, which is totally fine.
All right, and yet we don't have an accurate measurement of what that width is, do we?
We do. It's 16 feet.
And where do you indicate that in your notice of violation?
It's not in the notice of violation.
Okay, why is that?
It didn't need to be.
You indicated that this has been extended, and when asked for an accurate determination of how wide it's been extended, you've only given best guesses and not included any specifics in the violation. You don't think that was necessary or relevant information?
I still think it's a violation regardless.
Okay, so you think
no one has been able to prove that wrong, I guess, at this point.
Okay. take a look at Exhibit C here. Similarly, it sounds like at no point did you walk down to the beach and actually measure physically the distance either from the water to the stones or across from one side to the other. That's an accurate statement, correct?
Yeah, I don't see why I would need to do that.
All right, well, you've alleged that a beach has been expanded or
That's
built.
not what we alleged. That's incorrect.
That's not
What did we allege, Greg?
All right, let's take a look here. So if I'm looking at,
Because I've stated it twice tonight.
this right, notice of violation 5, construction of a beach without a permit.
Yep.
Okay. And you have alternatively indicated that either sand may have been brought in to increase the size of that beach, or that rocks have been removed to increase the size of that beach. And yet you've just testified that you didn't think taking a measurement of that beach to establish its size.
I've said twice.
You know,
tonight.
I've been very patient here. You are, you know, the tone you're taking with him is insulting and offensive.
I agree.
You've mischaracterized his testimony, and I object to that.
Multiple times.
My tone. I'm just trying to establish what actions he took on the property to reasonably and effectively measure these dimensions.
You've been taking his testimony and twisting it and misrepresenting what it is.
Well, I disagree.
Greg, I'm sure you do.
I've said
I'd ask
twice.
you to treat him with more respect.
I've said twice tonight. I actually literally said, like probably an hour ago, I'm not saying the beach has been made any larger. So I don't know why we're talking about the beach needing to be measured.
So you
no
agree with
sense, and it's wasting everyone's time, and it's disrespectful. So let's move on.
All right. Let's see here. Similarly, we're going to take a look. All right. So I'm curious here. What is the square footage of these clouds that you've drawn?
If you guys want to take another 5-minute break, I can give you the exact number. I don't have that prepared right now.
You have not done that math previously.
I can tell you what 25 by 60 is.
All right, but is that a rectangle?
That's 1,500 square feet. So that cloud is larger than 25 by 60. So I'm going to tell you this is probably around 1,700 square feet. Now that's not an exact number, but it's much larger than 250 square feet. Therefore, that's a violation.
That's an estimate, right? Again, you didn't actually measure that section. We're just giving
Greg, if you want to, if we can take a 5-minute break, I will get that number for you.
All right. So I think you testified as it related to notice of violation 1. When you were asked about the cubic yards and how much had actually been brought in or not, that in trying to establish how much that was, you didn't actually pick up or look under any of the riprap to establish how deep it was. Is that correct?
No.
Okay. And when it related to topsoil and mulch or other material put in there, the form of measurement you took was to kick it with your foot. Is that was what your testimony was? Is that correct?
Yes, we could take the length and the width and multiply that by a centimeter, and it would still exceed 10 cubic yards.
How many inches is a centimeter?
I don't know off the top of my head. I can look it up if you'd like.
Well, you just suggested that that was sufficient to cover it. I didn't know if maybe you'd done that math. All right.
It's very easy to find this information. It's all out there.
The high water mark, I think you indicated that generally you obtain a survey to establish what that high water mark is. Is that correct?
That's what the property owner did. Yep.
All right. So you relied on the property owner's survey to establish that?
No. As I said earlier, we relied on the watermark the day of when it came to determining where the high water mark was.
All right. But you acknowledge that changes day to day.
Yeah.
The lake, it doesn't have like tides, right?
Correct. Yep.
But the water level does change depending on the time of year.
Yes.
Okay, why does it change?
It's regulated by a dam.
All right, and so water is let in or let out of the lake.
Yes.
All right, and there's actually a website that you can go to determine what the level is. Is that correct?
That's correct.
All right, but your testimony here is that you did not take that step.
Correct. Are you aware of our definition for normal high water line?
I'm just asking what steps you took to make those measurements.
Right, but to answer your question, I'm asking, do you know what our definition for normal high water line is?
Yeah.
No, you probably have to look it up, right? Yeah, that's what I usually do all day long too. So the definition for normal high water line says the line which is apparent from visible markings, changes in the character of soils due to prolonged action of the water or changes in vegetation, and which distinguishes between predominantly aquatic and predominantly terrestrial land. Areas contiguous with rivers and great ponds that support non-forested wetland vegetation and hydric soils, and that are at the same or lower elevation as the water level of the river or great pond during the period of normal high water are considered part of the river or great pond, period. There's nothing in there about elevation marks or elevation points or dam regulation. It's based on those changes visible. It doesn't say anything about requiring a survey to come up with that number or that height.
And you took no measurement of it when you were on the property. It was based solely on your visual perception.
How would I measure that other than a photograph? I am not a surveyor. I don't have survey equipment with me. How would I measure the normal high water mark with something other than a photo?
You were physically on the property. Yes.
And
you brought a toolkit with you, yes?
And
is that true?
We've already determined that, so let's not waste everyone's time. Please move on.
It had a tape measure at least in it, correct?
Yes.
And you didn't use any of those tools to try to establish that, correct?
Mr. Chair,
establish what?
This is getting a little ridiculous. How can I determine
I have to
normal high
admit,
water mark with a tape measure? For crying out loud, that's ridiculous.
Greg, can you move on from this? I think that we have gotten clear testimony about
embarrassing.
We made a determination of the normal high water line, so I'm not sure what the line of questioning here is really adding.
All right. So I'll move on to point or notice of violation number 8 and 9 here collectively. I'm hoping you can explain to me what you believe section 15, subsection C, 12 requires as it relates to work on a shoreline.
All right, hold on. So 15.
Yep, just notice 8 and 9, the quoted text there.
Yep. All right, vegetation may be removed in excess of the standards in section 15Q of this ordinance in order to conduct shoreline stabilization of an eroding shoreline, provided that a permit is obtained from the planning board. Construction equipment must access the shoreline by barge when feasible as determined by the planning board. That section?
That's it.
Okay.
Okay. Continue.
When necessary, the removal of trees and other vegetation to allow for construction equipment access to the stabilization site via land must be limited to no more than 12 feet in width. When the stabilization project is complete, the construction equipment access, when the stabilization project is complete, the construction equipment access way must be restored.
Okay. So you've alleged it's a violation to complete this work from the land and not a barge absent a permit.
Yes.
What in this provision indicates that the work has to be completed and done from a barge?
It needs to be, the planning board must make that determination. And the work was done from land without approval from the planning board, without that permission.
I'm looking for clarification here, and I mean, I'm not going to lie, like this verbiage is new to me, so maybe I'm missing something. But what I see in a couple instances here is the word access, right? And not only access, but it indicates that if access needs to be made from the land, that the width of the path to access the work zone cannot be any wider than 12 feet. And when the project is completed, the access way must be restored. And so this seems to me to be a provision related to how you get the equipment there, not how the work is actually done. And I'm looking for some clarification from you as to why you believe whether or not the work is done when when the equipment is on a barge as opposed to being on land.
That determination must be made by the planning board. Unfortunately, your client didn't apply for a permit by the planning board. So I really can't give you much more clarification on that.
So can you, so you agree then that at least you can't clearly point out to me where it says in this provision or this ordinance that work needs to be completed from a barge surface?
Say that again, sorry.
Sure. So I'm still just trying to see within this ordinance where it indicates that work would need to be done from a barge and how this doesn't simply apply to how you get your equipment to the job site.
Construction equipment must access the shoreline by barge when feasible as determined by the planning board. That's the violation.
And so you take that to mean that unless the permit authorizes otherwise, the construction equipment would need to remain on a barge in the water and not actually on the land.
That's up for the planning board to determine through their approval process.
All right. Okay.
I wouldn't make that call. That would be the planning board would review that under their application, for a site plan.
Regarding the tree removal, you've done a lot of work with, or you've been involved in at least in a number of jobs with Rob Durant and Durant Excavating and Big Lake Marine, correct?
Yep.
He doesn't hold himself out as an arborist, does he?
He does cut trees.
Okay.
Yeah. He's not an arborist, but he does cut trees.
All right. You generally understand that this property and the adjacent property to which we previously had hearings was considered one large project, correct? It went on to multiple property sites, but it appeared to be essentially the same job, correct?
Yeah.
Okay. And you know that Q Team did the work on the adjacent property, correct?
Yep.
All right. Is there a reason, or can you explain the basis why you didn't cite Q Team for cutting these trees and doing the work on this property?
I had a meeting with Q Team about a week after we did the site visit, and they told us at that point that they did the work on Fernwood. They admitted to it. They sent us a letter confirming it, and they also stated that they weren't taking any ownership of the work that was done on 28 Whitetail, and that work was done by the contractor who did the site stabilization work.
All right. And so they had their tree cutting equipment out there, correct?
I don't know. I never saw it.
You never saw it. All right. They did tell you that they did the work on the adjacent property.
That's what they said. Yeah.
Right. And solely based on their testimony and indications to you, you chose to believe that you can do the tree cutting on this property.
No one's told me otherwise.
All right. Well, we filed a notice of appeal that indicated Big Lake Marine didn't do the work.
Did it? No. Is that what you're saying? Big Lake Marine didn't do the work?
Yes, that's what we alleged. That's what our appeal indicates, is that they did not do the work as related to the tree cut. Just one final question. When you went out there on October 26th, you communicated orally to Rob Durant and the other people there that they should stop work on the project. Is that correct?
Yeah.
All right. At any point, did you actually issue a written stop work order?
Not written in the heading, but we know, we basically, sorry, I'm getting tired. I'm very popular tonight, so I'm getting a little tired. We gave him a verbal stop work order, and the communication that we gave him at that point was, we're going to be sending you a notice of violation. And the intent through that was they're one and the same.
Is that standard procedure for the town of Raymond?
No, I wouldn't say it's standard procedure. We do it differently. Sometimes it's written a little differently, but just for this particular situation, we met with him on site, and he told us he was done. He wasn't doing any more work. So I trusted that. I have no reason not to trust that. And as far as I know, he hasn't been back to do any work. So I think we're good.
All right, and in fact, I think you testified that based on your observations and site visits, no additional work was committed or completed on the property after that October 20th date.
Correct.
All right. Apology for getting you riled, Alex. I know it's been a late night, and I thank you very much for answering my questions.
Yep.
So Attorney Wagner.
Yes, I would turn it over to Attorney Wyckoff if he has any re-examination.
I do, thank you. First, Alex, there are some testimony or some questions from Attorney Rachin about the riprap along the shoreline at the Whitetail property. And my question for you is, if riprap was only added and wasn't removed or replaced, does that change the situation with any, the existence of any violations here?
Mr. Chairman, before the answer to that question, I just wanted to ask Attorney Wagner perhaps to weigh in on a procedural issue. Again, the hour is late and I know we're all tired, but my recollection is that after I did my examination of the code enforcement officer, Attorney Wyckoff had an opportunity to redirect.
I did not.
Okay, then I'll stop and I will mute myself.
I don't know that you answered the question I asked, so let me just ask it again. So there were some questions for you about riprap, and my question for you is, if riprap, let's see if I can say it without tripping over my tongue here. If riprap was only added and not removed or replaced, would that change whether any of these violations have occurred or not?
No.
I'm going to go to Exhibit F. I'm going to share my screen. Okay. Exhibit F here, it has the bubbles that show the area of canopy that has been removed. Now, how do you know that greater than 250 square feet of canopy have been opened? Could you just describe how you know that?
Yeah, it's very clear if you stand on site and you look up, especially on the right-hand bubble where you see the deck that exists on site that wasn't on a subdivision plan in 2007. You can see that that entire area was once canopy. That's now all open, basically back to the deck. All of that. So anything that's there in that particular bubble is now gone. That adds up to greater than 250 square feet. And same thing on the other side, we established a 25-foot distance, and it's actually greater than 60 feet on that side, but we're calling it 60 to make it easier. It exceeds by 1,000 square feet, probably.
Okay. I mean, what's 25 times 60? Do you know what that is?
I don't do public math.
Okay.
By rule,
I'll represent to you
1,500.
I'll represent 1,500 square feet.
Yeah.
That more than 250 square feet?
Yeah, it is. Quite a bit.
By a factor of 6?
Yeah.
Okay. So in other words, you were satisfied that there was far more than 250 feet of canopy opened up?
Yeah.
Okay. There's a question from Attorney Braun relating to cutting of trees at Whitetail Lane, and it's really an issue relating to the Big Lake Marine appeal, but I just want to be clear about it because he raised and he asked the questions now, and I want to get it clearly understand from you about that. So you understood that management controls had how many contractors working in this project?
2.
Who are those?
Rob Durant, Big Lake Marine, Rob Durant Construction, whatever it is, and Q Team.
And you met with someone from Q Team?
Yes.
And that was about the violations that occurred?
Yes.
And what did you understand from that meeting with Q Team?
Yeah, they came in and met with Chris and I want to say less than a week after October 26th. And they told us that there was an oversight. They usually obtain all the permits for their projects, but in this particular situation, they didn't ensure that a permit had been pulled. They apologized. They admitted to doing the work on 18 Fernwood. And we asked Robert Fogg who did the work on 28 Whitetail, and he just kind of said the contractor.
And did they also talk to you about whether they cut small vegetation or not?
They did, and because that was something that was originally referenced, and they, his answer to us was, I think word for word was, we're in the tree removal business. Those aren't trees. They're not going to waste their time with that, essentially.
Okay. Now, they sent you a letter too, right?
Mm-hmm.
And do you recall what that letter said?
Yeah.
What did it say?
They essentially said exactly what they said in the meeting with us, and that they were, responsible for a certain amount of the work that had taken place. And it was an error that took place, and they were under the impression that a permit had been pulled.
And your understanding from them is that they didn't do the tree removal at Whitetail, and that Big Lake Marine did.
Yes.
And did you find them credible in them describing that to you?
Yeah. I mean,
why did you find them to be credible?
I mean, they owned up to the work that they did do without permits. I guess my impression of that would be, why would you admit to one but not the other? It seems a little odd. And I have no reason not to believe, what they were telling us. They've always been very good about following the rules and doing what they need to do. So I did believe that it was an oversight.
Okay. I don't have any other questions. Thank you.
Attorney Wyckoff, I guess do you have any summary arguments before I turn it over to Attorney Rakin? I don't recall if you had that opportunity.
No, I haven't had the opportunity. And I guess I would just say, we've gone through in fairly gory detail about the existence of these violations. And Alex has described how the facts underlying these violations, and a number of arguments have been raised by management controls as to why those violations haven't occurred, or why those violations are duplicative of each other. And for all of the reasoning employed by the ZBA in connection with the Fernwood violations applied to the facts here, those arguments about why the violations are duplicative and shouldn't exist should be rejected, and the ZBA should uphold the violations as Alex Roy has described here today. Thank you.
Okay. And Greg, or Attorney Braun, did you have any summary arguments? Okay. So then I would give the last say to
I do that it appears to me that and again, argument, what I ascertained from this is that very little in the way of documentation or explanation in the form of measurements or clear explanation has been provided. rather, the board is just being asked, or it's being suggested that the thing speaks for itself. Not only in the extent or measurements in dimensions of the project and the property, but also as it relates to some of the wording in these violations. You know, we want to explain away all existing vegetation less than a certain height as just, you know, we could have done it better, but we didn't. You know, access compared to completion as it relates to violations number 8 and 9, and there not being a distinction. And to those points, I would argue, especially in a case like this, where publicly the town has indicated that this is the most egregious thing they've ever seen, and you know, potentially they're seeking millions of dollars in fines, that a higher level of proof and explanation should be required.
Okay, Attorney Rachel.
Yeah, so I will just summarize and basically talk about the themes we've been talking about all along, but understanding that, again, Whitetail is not Fernwood, it's its own property, and it should be treated and viewed as such. But, you know, the first argument, of course, is that the wrong person has been held responsible here, or is being thought to be held responsible. And this notion that, you know, somehow management controls is an agent, or I should say the other way around, that Durant or Big Lake Marine is an agent of management controls, that's just legally incorrect. An independent contractor is just that. They're independent and they are not in an agency relationship. So that's incorrect. The second theme that we've been talking about here is that heavy duplication. And I do need, I know it's late, but I do need to talk about what that duplication is and talk about how these things should be consolidated. When I say these things, I mean the violation. So as you know, the notice of violation actually alleges 12 separate violations. Many, if not most, are duplicative. We've argued before, and I'll renew this argument, that had they sought and received a shoreline stabilization permit under section 15C12 of the ordinance, it would have covered many of the other purportedly single violations, such as earth moving and filling and vegetation and tree removal. All of those things would have been subsumed. And so we would respectfully request that all of those, meaning violations 1 and 2 relating to earth moving and filling, violation 4 regarding expansion of a shoreline, violation 5 regarding a purported beach construction, 6 and 7, which deal with removal of vegetation, 9, use of a barge, and 10 through 12 are tree removal, that those all be stricken entirely because they are subsumed under violation number 8. If, and that is our ask. Now, if the board decides that they are not going to strike, at least it's really important to understand the need for this consolidation, because so many of these purportedly single violations are in fact one and the same. They're based on the same activity and often based on exactly the same provision under the ordinance. And I'll identify those quickly. Violations number 1 and 2 basically should be consolidated, because on the one hand, violation 1 simply states that it's earth moving and filling in excess of 10 cubic yards. We know that that activity in and of itself is not a violation unless and until a person didn't get a permit. And that is what they allege in violation number 2. And so those are exactly the same violation, and they should be consolidated accordingly. With respect to violation number 4, which alleges an expansion of the shoreline without a permit, and number 8, which is an expansion of shoreline with riprap, this is the same thing, again, that would have been subsumed under a shoreline stabilization permit. So 4 and 8 should be consolidated. Looking at violation number 3, which is the expansion of the boat launch, and violation 4, which is expanding the shoreline, I think it's important, and the testimony of the CEO is actually very revelatory in this manner, or in this way, that both of the violations, they cite the exact same provision under the ordinance. That would be 1417 sub B. And I think it's clear that the code enforcement officer said that the expansion of the shoreline the shoreline was limited to that area of where the boat launch was expanded. So again, even according to the code enforcement officer's own testimony, same activity, and therefore those violations should clearly be consolidated. Again, just like violations number 1 and 2, violations number 6 and 7 talk about an activity which is actually permitted, here, removal of vegetation, and then slaps them with a second violation for removal of that vegetation without a permit. Again, same activity should be consolidated. Numbers 8, violations number 8 and number 9, 8 being the unpermitted shoreline stabilization without a permit, and number 9 being unpermitted stabilization without a barge. Again, those are both activities relating to unpermitted shoreline stabilization. They cite exactly the same provision of the ordinance, and they should be consolidated. And again, with respect to numbers 10, 11, and 12, all relate to vegetation and tree removal, same activity, should not be 3 separate and distinct violations. So that is with respect to our arguments around duplication. Let me talk to you about the last round, and that is the fact that as alleged in the notice of violation, they simply, we know the purpose of a notice of violation is to give notice of what the violation is. And here, it's been a long night, but the testimony and it's our respectful submission that the evidence just simply does not support a conclusion that many of these alleged violations occurred. And I'll be as quick as I can. But with respect to violations number 1 and 2, again, that's the earth moving and filling of in excess of 10 cubic yards. The evidence does not establish that there was actually greater than 10 cubic yards. As there was a lot of testimony and a lot of questions about that, and that there was no empirical specific measurements in that regard, and therefore it was not established. With respect to violation number 3, the boat launch has been expanded. Again, the pictures that were shown you were from a great distance. They were fuzzy. There was no scale associated, and it was very difficult for them to establish that there was, in fact, that area of the existing boat launch. And let's be clear, it was existing. No one's disputing that it was expanded beyond the scope of where it was originally. With respect to violation number 4, that being the alleged expansion or enlargement of the shoreline, first and foremost, there's some doubt as to whether or not this was a use or a structure as defined in the ordinance. But even if it were, the code officer did not provide measurements. Again, like I said, he's saying that the expansion of the shoreline was exactly the same thing as the expansion of the boat launch. And so all of our arguments in that regard apply, that the evidence just does not support a conclusion that there was in fact an expansion there. Another piece of that is that it's important to understand that any addition of riprap, I think we heard the testimony of the code enforcement officer to say he didn't know and he couldn't establish that there was a removal or I think he said a removal of the existing riprap. Rather, it was just something that was put on top. And as stated earlier, that it's our submission that under I believe it's section 12 of the ordinance, that repair and maintenance of existing non-conforming structures or uses is permissible without a permit. With respect to violation number 5, I think it's clear the evidence absolutely does not support a conclusion that the beach was constructed. Those were the words used, constructed. It clearly already exists. And I think, as the chair very eloquently stated, how can you construct something that's already there? Even the code enforcement officers before photos show beach chairs. Clearly that was being used as a beach. And to the extent that rocks were allegedly removed, again, the evidence doesn't say, even the code officer himself acknowledged that beaches are not static, the sand moves in, moves out. And so it just has not been established that a beach has been constructed. And to the extent that improvements are somehow a construction, again, The sand can move in, sand can move out. Code enforcement officer himself acknowledged that. With respect to violation 6 and 7, that again is the removal of vegetation of less than 3 feet in height without a permit. This is just another example of the town's overreach. As we highlighted, it talks about all existing vegetation. The evidence clearly shows that that is not the case. All existing vegetation has not been removed. With respect to violation number 8, which is no permit for the stabilization project, the permit by rule covers actually a certain portion of that stabilization project. Also, as I noted before, that this was in the nature of maintenance, adding, again, the evidence is clear that this shoreline was very much characterized by extensive riprapping already. And so just adding some additional is in the nature of repair and maintenance, not an entirely new project. Also, I think the code enforcement officer testified, and I may not have his exact words, but where the water is where the high water level is. The normal high water mark is where the water is. But there's no evidence that there was stabilization below the normal high water mark. And if we look at the ordinance in the section that he is citing, it is talking about work below the high water mark. And so there's no evidence to establish that. Getting there. Violation number 9 is that was the stabilization without a barge. Again, we dispute that it was feasible to conduct this work, given the fact that, the time of year, the water was low. There's no evidence to suggest that a barge could, in fact, do that work and be able to reach the areas given the water levels. And finally, with respect to violations 10 through 12, this is with respect to tree removal and the point system and doing the work without a permit. The evidence supports the conclusion that the trees at issue here were largely hazard trees. We have evidence in the record where Mr. Goslin indicated that. We also have evidence that the code enforcement officer himself says that the folks from Q team are trustworthy. There's no reason to not believe that what they are saying is truthful. You have pictures showing clearly that one of the trees that was right next to the stairway, which was identified as a tree that was removed unlawfully, clearly this is a hazard tree, just like all of the other ones that were removed, or at least the majority of them. And again, ultimately, these 3 violations all involve the same activity, removal of vegetation and trees, and therefore they should be consolidated because they are not in truth 3 separate violations. And that is it. I thank you for your time. And if you have any questions of me, I'm happy to answer them.
So, Attorney Wagner, I have 3 yes/no questions for two of the attorneys. And then my thought is that given the time that we work to potentially table these until tomorrow evening, that match your thought process?
Yes.
Okay, so my 3 yes/nos, Attorney Wyckoff, there was a document that came up during one of the screen shares regarding the boat launch, and a testimony by someone indicating that the boat launch had been expanded to 16 feet. Can you, we have so much talk, can you just simply provide that document to the board for tomorrow's meeting? To have so much documentation here, I would just like to just have that single document available.
Okay. You have it. It's a 249-page document that was provided by Attorney Rachin today, and it's on page 71 of the PDF.
Print that out, David.
Attorney Braun, 2 yes/no questions. During your questions for Alex, you had some concerns over the tools that he was using, Google Earth, and as well as the tool on his phone. Again, just simply a yes, no answer question. Do you have any evidence that the tools that Alex used are inadequate for what he was trying to accomplish?
So a little longer than a yes or a no.
No,
Yes.
all I want is a
Yes,
yes.
I do.
Okay, can you provide that?
Sure. In fact, you already have it in its Exhibit F that Alex included with his notice of violation. He himself indicated that document and the overlying lines that were included with it to ascertain or establish tax maps were part of Google Map and Google Earth. And he also indicated that they were wrong and incorrect.
Okay, is that the only evidence you have? Yes or no?
Yes.
Thank you. And finally, do you have any evidence that Q Team was contracted for use at 28 Whitetail?
No.
Okay. All right, that's it for my questions. I'll ask the board, do you have any last minute questions, please, for our attorneys?
I don't have any.
Okay. I would like to, unless anybody objects, I would like to make a motion that we table. Yeah, Attorney Wyckoff.
I have a procedural question.
Yeah,
I don't think the public has had an opportunity.
This is true.
I think Attorney Wyckoff is correct. So could we just go through the motions of asking if there's any members of the public who wish to
Yes,
speak?
I can do that. So I will open up the public hearing portion to this. Do we have any members of the public that would like to speak in favor of this application? Do you have any members of the public who would like to speak in opposition to this application? And then finally, do we have any members of the public who would like to just speak from a neutral perspective on this? Seeing and hearing none, I will go ahead and close out the public comment portion of this.
So before, I think you're in the process of motion to table, though I guess I would suggest first we motion to close the public hearing and the record, and then take up a motion to table deliberations until tomorrow.
So I will motion that we close the public hearing and wrap up the testimony. Something that's like I'm so tired too.
Second.
Thank you.
Close the public hearing and close the record.
Close the public hearing, close the record. Second.
I'll second that.
Thank you. Any further discussion by our board? All those in favor of doing so, David March, yes.
Yeah. Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Lockwood, yes.
Step is, I'd like to make a motion to table our two appeals with regards to 28 Whitetail until our next meeting.
I'll second that.
Further discussion? All those in favor of tabling, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Lockwood, yes.
Okay, so we get to have fun tomorrow night, starting at 6 o'clock.
Just one question for you. Do you have any other business besides the parties that are here today?
We have another administrative appeal.
Do you have any sense of how involved that one is? I just know, I think that party got pushed away last meeting because of this group here, and I just want to be respectful to their time. And if it's a short, if we think it's short, I might suggest trying to get them in first so that they don't have to sit through what I suspect will be another long night.
Yeah, understood. My sense is short, but can I get a couple other board members to chime in on that one? This is,
My without really knowing how long it would be, was to deliberate on this first and then do that before we go into the other two, just because the continuity makes it a little bit easier. That would be my only thought.
That's reasonable.
Again, I don't think the next one will take a lot of time, and I'm okay with deliberating first.
So I don't know, I mean, it looks like it could be shorter, but I guess you just never know, so. I kind of am aligned with Greg Dean, that we just sort of continue on with what we started tonight. Unfortunately, you know, they're just in the order that we come through them, so. That's my inclination anyways. Okay. So I'll make a motion to adjourn for this evening. Second. All those in favor, David Murch, yes.
Greg Dean, yes.
Miller, yes.
Lockwood, yes.
I can't hear you.
Sorry, David. Go ahead. I got distracted for a second.
Okay, we're adjourning. You good for that?
Thank you so much.
Okay, all right. Thank you, everyone. We will do this again tomorrow night.
Have a good night, everyone.
Good night.
Thank you for your time.
Of course. Thank you. So welcome to the September 27th, 2022 Zoning Board of Appeals meeting of the town of Raymond. The Zoning Board of Appeals will come to order. The board does have a quorum. I'm now going to do a roll call. I will start with myself, David Murch.
Greg Dean.
Fred Miller.
B. Lockwood.
This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all exhibits that are presented. Please notify the chair if you are unable to see or to hear. The board works from a published agenda and will be considering tonight's items in the following order. Number one, call to order. Number two, approval of minutes from August 30, 2022. Old business. Deliberations on the following matter tabled on September 26, 2022 special meeting. Administrative appeal, re-notice of violation issued 1/28/2022. Applicant Leah B. Rachin, location 28 Whitetail Lane. Follow that by a public hearing on following matters tabled on September 26, 2022. Administrative appeal, re-notice of violation issued 3/10/2022. Applicant Gregory P. Braun, Esquire, on behalf of Big Lake Marine LLC, Robert Durant, member manager, location 28 Whitetail Lane. Following that, new business table on September 26, 2022, administrative appeal, re-denied business license, applicant Adam Nappy / Highwire Hydroponics. Then finally, adjournment. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or state law. After the board votes on the merits of each application, it will prepare a written notice of decision. Because the notice of decision may substantially affect any appeals rights, and also as a matter of courtesy, the board asks that those attending the meeting with regards to a specific application not leave until the board has completed its discussion. Generally speaking, appeals from adverse decisions must be filed with the Superior Court as otherwise provided by law within 45 days of this board's decision. Also, to be certain that you preserve your individual rights to file any such appeal, you must be certain that the board's record evidences your appearance this evening in opposition and the basis for your opposition. All persons speaking, including representatives of the applicant and members of the public, are asked to state their name, address, and affiliation with the application, either being for, opposed, or neutral. All persons speaking shall address all remarks or questions to the chair. This meeting is not over until the board has formally adjourned. Any discussion not included on the meeting agenda or accepted by the board is to be held until after adjournment or conducted outside the meeting room. So first up on our agenda is approval of minutes of August 30, 2022. Does anybody on the board have any questions with regards to those? Any corrections to be made before we make a motion to approve? Okay, motion to approve the minutes of August 30, 2022 as submitted. All those in, oh, thank you. Yep. All those in favor, David Murch, yes.
Fred Miller, yes.
Greg Dean, yes.
Lee Lockwood, yes.
Okay, that will be unanimous. Old business, deliberations on the following matter tabled on September 26, 2022 special meeting. We have two administrative appeals as for 28 Whitetail Lane. These are on the table. I'd like to get motions to take them off of the table. Can I get that motion?
So moved.
And can I get a second?
I'll second that.
Okay, all those in favor of taking these two administrative appeals tabled for 28 Whitetail Lane off the table, in favor, David Murch, yes.
Fred Miller, yes.
Lee Lockwood, yes.
Okay, those are off the table. So the first up is deliberations on the following matter tabled on September 26, 2022 special meeting. Administrative appeal, notice of violation issued 1/28/2022. Applicant Leah B. Rachin Esquire on behalf of Management Controls LLC, location 28 Whitetail Lane, lot map 001020, zone LRR2, description administrative appeal from notice of violation. So Attorney Wagner, can you sort of work us through our procedural steps here?
Sure. So as you will, can you all hear me? Yeah. So as you'll recall, the board closed the public hearing and table deliberations. So I do see that Tom just joined us.
Yes, I do see that.
Yes,
Wow.
I'm online. I don't know. I tried 4 times to log in using Sandy's link, but it didn't work.
Okay. So since, although we've called the meeting in order, since we haven't begun any substantive discussion, I see no problem with Tom joining us for this, unless there are any objections by the other attorneys. Seeing none.
Obviously not here.
No objection from the town.
Okay.
Specific to his timeliness in participating tonight, no objections.
Okay. Understood. So we have 5 members participating. Before we go into deliberations, the board, or rather the chair, I believe, has received 3 different submissions in advance of tonight pertaining to this matter. 1 from Attorney Wyckoff and 2 from Attorney Braun, and they are both following up on questions that were asked by the board. I'd like to address those 3 items in turn, and some of them, but not all of them, and so we'll address it in turn. I think introduce what would be considered evidence, and the record is closed. So if you want to accept that evidence, you would need to make a motion to open the record back up, and then I would recommend motions to accept the evidence or not into the record, and I'll walk you through that. So, sorry, Attorney Rachin.
Thank you. Just a quick question procedurally. Are we going to have a brief opportunity, attorneys, to weigh in on that, just the procedural issues?
Yes.
Okay. Before the motions are made, whether or not to accept them?
Yes.
Okay. Thank you so much.
So the first item I have here, bear with me while I just pull it up on my email. I believe the first one to come in was from Attorney Wyckoff at 10:36. Does everybody have a copy of this? subject matter is administrative record content submitted by management controls. It's from an earlier chain. It's 1034.
Yes.
Yeah. Yeah.
Okay. I suppose would it make sense if I can turn it over to Attorney Wyckoff just to explain what this is and whether, in your opinion, this is new evidence or just answering a question, and whether we would need to open up the record to accept that or not.
Sure, I'm happy to address that. Last night, Chairman Murch asked me to point to some documents that were referred to during the town's presentation regarding the width of the boat launch. And what I did was I sent an email in response pointing out where he could find those. So the document, the references were to a 249-page PDF that Attorney Rachel provided to the ZBA yesterday with a link, and that she shared a document. So the documents aren't new; they're already before the ZBA, and I'm just providing page numbers that the board can refer to relating to the boat launch. So I don't think it's necessary to move or open the record because it was already in the record.
Thank you. I'll open it up to Attorney Rachin and then Attorney Braun to weigh in on this if they want to.
Sure, just briefly, and I certainly agree that that document was part of the record, and I don't think a motion is necessary to entertain whether it should become part of the record. I did just want to make very brief comments about that reference. It's important to understand and appreciate the context in which that record from Mr. Morse was submitted. It was responding to the notice of violation itself, and we certainly appreciate that these are administrative proceedings and that the rules of evidence don't apply. But that said, it's pretty well established in law that there has to be some indicia or some indicators of reliability when it comes to that sort of the evidence that you're looking at. And so at this here, there's no evidence that Mr. Morse had personal knowledge of the dimensions or where those figures actually came from. And so I think it's important to appreciate that you can't look at that from a legal perspective as some kind of admission from a party opponent. And especially because Mr. Morse is not a party to these proceedings. He's an independent contractor. And again, we don't know the basis of what those measurements were. So I will leave it at that. And we don't object to, that it's not the entry of additional evidence into the record.
Attorney Braun.
I would just concur with Attorney Rachin's comments, and would agree generally that it is already part of the record.
Okay, thank you. So my advice to the board is that I agree with everyone here that this is not introducing any new evidence, so I think you can take note of it and we don't need to make a motion to do so. But if the board feels differently, let me know. So hearing nothing, the board can accept this as something to consider in its deliberations. It's basically analogous to as if Eric had, Attorney Wyckoff had provided this answer during deliberations. And you can take the comments that the other attorneys have made under consideration as well when considering the relevancy and credibility of those documents. So the next item, I believe, came from Attorney Braun, and so this is an email that was sent to some of the parties. I guess one of the town's attorney was inadvertently dropped off on that email, but subsequently received it. So I'll refer to the original email being from Greg Braun, 12:11 p.m. and it includes an attachment of the tow emails regarding tree removal. So Attorney Braun, I would turn it to you to just briefly describe what you're trying to introduce here, and your arguments as to why the board should reopen the public hearing to accept that.
Sure. First, an apology. I'm noticing a lag in right in volume here. So if you lose me, please let me know. Maybe it'll also inspire me to be a little less long-winded tonight. Regardless, at the end of requested or asked if I had any evidence related to the tree removal and who performed those services. At the time, I indicated that I did not have that evidence. After deliberation with my clients early this morning, we were able to identify several communications on point, and it ended 3 emails that specifically indicate the tree work that was performed on the 2 subject properties. The one that we've already come to resolution on, that being Fernwood, and this appeal being Whitetail. I would note that as it relates to this specific violation, the board may or may not deem it relevant in that it doesn't speak to whether or not the actions took place, but rather grants culpability or responsibility for those. Those questions seem relevant and appropriate to the next hearing that we have scheduled tonight, for which the evidence has not been closed. And so I would just acknowledge that as it relates to those emails.
Okay, Attorney Wyckoff.
So the town does object to it. I mean, the record was closed. Let me step back. First, as Attorney Braun stated, he was asked whether he had anything evidence relating to whether Q team had removed trees from the Whitetail property. He answered no. So then he produced these, he's provided these documents today and wants to have them included in the record. I mean, his client was on the text, so in other words, there was access to them, and there must have been a strategic decision to not provide them and to instead wait and provide them later. So I object to that. And then I guess beyond that, the documents, I'm not sure they have any value here, and they just confuse matters and make it very unclear. The messages don't refer to a particular property. It doesn't say what property the work's occurring on. So they're really not of any utility. So I wouldn't confuse matters, and I think they ought to be excluded.
And I want to be clear that right now we're only discussing and determining its inclusion in this current proceeding and hearing, and not the one that is to follow related to Big Lake Marine.
That's correct. Attorney Rachel?
Yes, thank you. As you know, I also represent Q Team, but because this appeal doesn't relate to Q Team, I'm not going to be making any submissions in that regard. So thank you.
Thank you. So members of the board, the question for you is, we'll just, I don't think we have to do 2 separate motions, one to open up the record and the second to admit. So we'll just call it I would suggest someone make a motion to admit the email and the second, and then that'll frame it up for discussion, and I can advise you on the factors you can consider, or my opinion. So why don't we just queue up a motion?
Can't hear you, Dave.
I'll make a motion to admit or submit. Can you hear that?
Second.
Okay.
Okay. So the issue here is whether this additional document should be submitted after the record has been closed. As you know, there are no rules of evidence that apply here in terms of your ordinance. Obviously, once the record is closed, no documents, further evidence can be introduced unless the board decides to open it up to allow that evidence in. And it's my opinion that's within your discretion to do. In terms of guidance for this decision, I think Attorney Wyckoff's arguments touch on the 2 principles that are at issue here, which are 1, fairness, You know, is this information that could have been provided before last night's hearing? You know, is there any legitimate reason why it wasn't? And I think you can factor that in. And the second principle is relevance. And, you know, is this information something that, you know, would help you make your decision, and you believe it's so relevant that it is worth allowing into the record?
Sure. I mean, I'll start. I appreciate the information that was provided. I do think that in terms of relevance to what we have to discuss next, it probably doesn't have any, but I would like to reconsider this when we look at our next appeal. Anybody else on the board?
I agree with you, Dave.
Yeah, I'm on the same page here. I think that there's definitely an issue of, you know, it's a pretty, it's not an obscure question that was asked, and this is surprising that there's, you know, evidence of denial of you know, his client denies the violations is now introduced, you know, kind of after the fact. I think it's a little unfair. Seems reasonable that should have been introduced with the rest of the evidence.
And I think we should, you know, we need to relook at this with our next appeal.
Yep.
Okay. So I think we can just go ahead with a vote on this. So the motion was to approve this, or to bring this into the record, or I guess to open and then bring it in. All those in favor? All those opposed? David Murch, yes. Opposed?
Parker, yes.
Fred Miller, yes.
Yes.
Okay, so that one is not going to come in.
Okay. So the next item is an email from Attorney Braun at 2:29. It includes 2 attachments pertaining to the accuracy of iPhone measurements and horizontal position accuracy of Google Earth. So again, I would turn it over to Attorney Braun to give a sort of offer of proof, if you will, as to what this is, and your argument for why the record should be open to allow it in.
Sure. So again, similar to the last issue, this was a question that was raised at the end of the meeting. I at that time had no information. You'll recall, or you probably came to know, that yesterday was the first time I think any of us that were parties to this proceeding learned of the specific tools and methodology by which measurements and fact finding was conducted on the subject property. So this is not something that I had previously had noticed that was an issue or was relevant in the matters before the board. Following that hearing, I did online research today, and I was able to identify 2 articles that were clearly on point to the questions raised by the chairman. The first was an online article published in August of this year in a online technology journal and or magazine related to the iPhone, and specifically the iPhone app that the CEO testified he used on site to make these measurements and to establish whether or not a violation had taken place. This is relevant, timely, and it comes from, by all appearances, an honest and trustworthy source. The second is an article that has to do with Google Earth and the accuracy of its horizontal and geographical indica or measurements. This was published in a medical journal of technology. Again, something that seems to be clearly relevant to the questions at hand, and comes from a noteworthy and trustworthy source. So again, given the lack of notice as it related to these being relevant issues in the hearing, given how spot on they are to the questions and concerns that the board raised yesterday, and given the source of the information, I do believe that the record should be reopened and that these documents and the contents therein should be allowed to be discussed and considered by this board as part of this hearing.
Sorry, Attorney Wyckoff.
Thank you. The town opposes the opening of the record in order to introduce these two, I hesitate to use the articles because I don't even know what they really are. The record was closed. The question was asked, do you have anything regarding accuracy of Google Earth or the Measure app? The answer was no. And then some time was spent and he identified these. So the problem is we don't know anything about these articles. We don't know anything. We don't know who the authors are. We don't know what the qualifications of the authors are. We don't know if the authors are viewing the same thing that Alex used. This is kind of like a medical diagnosis by Google. It's like I Google my symptoms and I was like, I find out it's for cancer, so I have cancer. That's what it's like. It's medical diagnosis by Google. And with regards to the Measure app, I mean, the article says, you know, measurements cannot be off by a few inches. And measurements can be off by between 2% and 20%, et cetera. And I don't really understand, there's no explanation as to what that is meant by that to understand what might be driving differences in those numbers. And with regards to the Google Earth piece, candidly, I don't understand what it is. I don't even know what it says. I don't see how it could be helpful because it's almost indecipherable as to what it's saying the issue is with it, if there is an issue, which I don't really understand. So for all those reasons, both of those ought to be excluded from the record. Now, if you're inclined, if the board is inclined to allow both of these to be put into the record, then the town requests that you open the record for the purpose of Alex Soroy being able to address why these articles, whatever they say, don't matter and why they shouldn't impact your decision. Thank you.
And I'm going to go to Attorney Rajan first if she has any comment.
Thank you so much. Again, I'll be brief. Not only do we not object to the addition of this to the record, we join in that request. We think that these materials are probative of the relevant issue about reliability of the iPhone measuring app and the Google Earth. I echo Greg's comments that much of the testimony, it came as a great surprise that when I say he, I mean Alex, the code officer, had used this iPhone app. That was the first time, at least in my understanding, that was raised. And so I think it does bear response. You know, if the notice of violation had said we used X version of the iPhone app to measure on a certain date, then we could have a cogent discussion about the accuracy of the measurement. But with the absence of that info, like, you know, what version of the app was used or what day or what protocols were used when he implemented the app, then, you know, we being the appellant, or appellants, I should say, there are two of them whose rights are, you know, at issue here, then we don't have any ability to replicate or test those measurements. And so, as Alex himself pointed out last night, it is indeed, it's without a doubt the appellant's burden to show that he erred in his determination, but it's important to appreciate that there is a fundamental threshold requirement that the CEO be able to explain his methodology in a manner that ensures the accuracy of his measurements. And without, like I said, the ability to replicate these measurements, you know, unlike, say, a tape measure, again, you know, it creates a due process issue. And so we do believe that it's important for this information to be considered. And on that point, I would ask specifically that in light of these issues and the reliability of the measurement, it has become quite important to these proceedings, that when you are doing your deliberations and when you're issuing your conclusions and findings in this case, we would ask that the findings and conclusions specifically address whether or not accuracy of the measuring devices is considered and germane to your findings. And so we would make that specific ask that be addressed
just making a quick note. Attorney Brown, do you have a brief rebuttal?
Very brief. Just first to say that both of the articles explicitly identify the authors. I believe the iPhone app has a short summary of who they are and what the background is at the end. Both articles also are replete with citations to other relevant information. The date on which they were obtained, which is today, is clearly indicated on the top, as is the internet address. And so any member here who would so choose to either vet those documents or confirm any of the contents or citations, it's quite frankly an internet click away. And as it relates to Attorney Wyckoff's argument that they can't be trusted or they're confusing or we don't really know if they apply here, I would say all of that speaks to the weight to give into the articles and what sort of outcomes to be considered or come to by the board, but it doesn't speak to whether or not they should be allowed to be entered. Thank you.
Thank you. So I'll turn it over to the board. As before, I suggest a motion to reopen the record and admit the materials, and the second to prompt that for discussion. But let me just explain that if the board were to affirmatively pass that motion, I agree with Attorney Wyckoff that the town should be provided an opportunity to respond, and that would include putting on additional evidence. That's if you admit that. So can I have a motion on that?
So move.
And a second. Do we have a second on that motion?
Second.
Thank you. So before further discussion, same advice applies. Fairness and relevance should be your guide, and this is a discretionary call.
So do we have the choice of admitting? Do we have to admit both, or do we have a choice of admitting one over another?
You could, it's entirely up to you. You can admit one over the other. I would, if you did, I would hope that the board has a clear articulation as to why one should be admitted and the other shouldn't.
Sure. So in regards to the documentation that was provided, looking at the horizontal position accuracy of Google Earth's high resolution imagery archive, the document itself was published December of 2008. All the reference material is dated from years 2007 and older. Given how technology evolves so rapidly, so quickly, a document that's 14 years old, I think is a bit outdated in terms of what we're looking at here for tonight. In regards to the other documents, I don't have an issue with bringing that in and hearing how Alex would compare that to what he does as well. Although I would have to admit this is just one person's opinion, but it would be, from my perspective, nice to hear Alex's feedback in terms of how it compares to his own work. That's just my 2 cents.
David, I agree with both of those points. I do notice that the article was 2008 and the other one is much more current. So I would agree. I'd also like to hear Alex's testimony on the iPhone app.
Well, real quick, I don't want to get too much into deliberating on this, but is it reasonable to ask what specifically you think this evidence, which there's a lot of measurements that have been talked about, and I'm assuming that the iPhone article is in reference to measuring whether or not there was thresholds met for moving soil, or how long the shorelines were, or how long certain distances were. It doesn't seem like any of these are, even if you take the maximum error that the article is saying, and this is kind of, I think, a central point, is we're not close to a tolerance that would make the violation under a threshold. So I'm not sure it's super relevant, to be honest with you. We spent a lot of time talking about measurements. It's amazing that there's smoking gun, new evidence when it seemed like it was a central thesis to the appeal. I just don't fully understand. Even if you took worst case scenario on these articles, it doesn't. If you could articulate which violations you think that would put us under a certain threshold on it, that would be helpful. And I'll open that as a question to either Attorney Rachin or Ron.
Sure. And so I'll start there. I think it's relevant to, in fact, any of the notice of violation points that speak to the measurements. First, as it relates to 10 cubic yards, of soil moving, and that's in point notice of violation 1 and 2. Establishing length and width there is terribly important. And as the article related to the iPhone indicates, there can be a variance of up to 20%. Not only that, but it also explicitly discusses the necessity to calibrate your device and how different either geographic variables or locations, i.e. connectivity or location compared to cell towers, can have an impact on what those variations or measurements might be. And so I think it's not just, as it relates to, meeting minimums here, but it's a question of whether or not the tool itself is even a trustworthy measurement for any of these violations.
Yeah, just to follow up on that, that's a good point. I think that part of the testimony was that Alex did calibrate this with a tape measure. Also, part of his testimony indicated that, that's my understanding of what he said. I see a lot of people shaking their head no, but it's my time. Like that's what I have in my notes. So I think that, there was calibration done. He also did testify that his assistant CEO followed up and he, with different instrumentation. I don't see any of these measurements, including the 10 cubic feet that you mentioned, that if these measurements were off by 20%, that we'd below a threshold. I think he mentioned quantities in excess of hundreds of cubic feet.
Well, and Greg,
so
I'm sorry, I don't mean to cut you up.
I guess I'm still struggling with the relevance. Sorry.
Right. No, that's fine. Just to point, it's cubic yards, and not to belabor that, but that's the difference of a threefold, right? And so the distinction between a cubic yard and a cubic foot is actually quite substantial, exponential.
Sorry, yeah, but the tolerance is not exponential. It's 20%, so it actually doesn't matter what the unit is. The article, as I understand it, is percentage based. So 20% of, I don't think it matters.
May I address those points briefly?
Sure.
Thank you. So I agree with Greg's comments. A couple of other things is that, I think we talked about if you are reading it most generously and that well, let me back up just with respect to the notion that because it was the article was written a while ago, I think it was a 2008 article, that it should not be admitted. Again, I think that goes to weight, but importantly, they do raise issues that regardless of whether technology changes, the fundamental salient points are that, things need to be calibrated. That doesn't change with technology. You need to know what version is being used. So I think while technology changes, I think it's critical to point out that the flaws and importance of methodology, that doesn't change over time. Those are points that are, in essence, they don't change. And so I think, as Greg had said, that it's not so much about admitting it, because I think it is proper to admit. You can ascribe whatever weight you think, but just because it's old doesn't mean that the concepts described in there are irrelevant or untimely. The other thing that is important, I think, with respect to that swing up to 20% possible inaccuracies, I think it's also really important to remember that some of the violations that we're talking about here is for activities on or below the normal high water mark. And that, I believe, where Alex, I don't have the image, but particularly with the boat launch, where he placed the normal high water mark, that's inches. I mean, that's, if you recall possibly, is that how much work was going on below the high water mark? That could be inches, and that 20% could be significant. And so I think it's important not to minimize that.
Which violation do you think it's important for specifically, as a follow up to that?
Sure. Let me find expansion of the shoreline.
4.
Thank you. Yep. And the boat launch. I mean, as I said, I'm going to echo Greg's comments that it's absolutely relevant to all of them, but specifically, particularly when we're talking about a small area, which is below the normal high water mark, which I think several of the violations reference, then I think it is even more important.
That's all I've got, David. I think you need to wiggle your mic cord there a little bit.
Oh, does anybody else have any other questions? No. So the motion is to admit these, open the public record and admit these two pieces of information. All those in favor, David Murch, yes.
Greg Dean, no.
I'm Hennessy, yes.
Miller, yes.
Lockwood, yes.
Okay, so that's 4-1 in favor of admitting sorry, that was on both, correct? The motion was on both of the documents. Did everybody understand that that's what they were voting on?
Can't hear you, Dave.
Yes.
Okay, so everybody understood it was both documents. Okay, so the board has motioned to open the record to admit both documents. As I advised, if we're going to do that, I think we should provide the town an opportunity to, as they've requested, put Alex back on to speak to this, and again, give the parties an opportunity to respond, not to repeat what was already discussed, but just any further response as to the relevancy of this evidence. And also further, we should open it up to the public briefly to comment on this as well.
So procedurally, does that go then to Attorney Wyckoff and Alex first?
No, we should start with the appellant actually. So Attorney Rachin, I think should be given the first opportunity.
Okay, so I'm sorry, just to catch up procedurally, I'm going to be asking Alex a couple of questions in that regard, if that's the division.
I guess however you would want to handle this evidence, you know, if you want to call Alex, you can certainly do that. Perhaps town will have an objection to that, but I think it's
I think here. Oh, Greg, I see Greg's hand. Is that?
Yeah, apologies, Attorney Wagner. I may have missed this point, but I just want to be clear. So the last motion and vote was to accept these two documents, but I understood the admission of any additional testimony or evidence from the CEO to be a separate matter. Are we discussing whether or not to allow that, or have we just established that he's going to be allowed to produce additional testimony and evidence?
So the motion was to open the record and introduce it. I agree that it's a separate question for the board. I don't think there needs to be a vote here unless you're objecting and sort of insist that the board make a affirmative vote to allow the introduction of testimony in response to this evidence.
I mean, I would defer to you and your advice to the board on whether to vote on it or not. But I would note I would simply abstain on an argument either way.
And from my perspective, I was asking more for procedural clarification as to, I think the language, or at least the advice that you had given, Stephen, to the board was that if those articles are admitted, which sounds like they have been, that you give the town and Alex an opportunity to speak to it, and then the parties would respond. So, and I think that if I remember the order of operations is that Attorney Wyckoff had asked that he be given that opportunity. So it seems to me that that would be, again, I defer to your good judgment, but perhaps have Attorney Wyckoff ask those questions or whatever questions he believes to be relevant, and then Attorney Braun, and because it was his motion, and then perhaps me, or whatever order is appropriate.
Yeah, I think that's a reasonable approach. I deferred to our typical order. As you're the appellant, you have the burden, so I wanted to give you that opportunity first. But if you're willing to turn it over to the town first, I do think that has more logical appeal to it. So why don't we do that?
Makes sense to me. I can have Alex appear and take his mute off. Okay, good enough.
Evening. Hello.
Alex. Oh, okay. So Alex, what I would like you to do is to help the board understand and to explain to the board why these articles regarding Google Earth and the Eiffel Measure app, why they don't matter and why they shouldn't be concerned about them. Okay, so yeah, maybe first the way for us to approach this is, so the violations that involve some kind of measurement, I think those are, and you tell me if you disagree, I think those are the location of 100 feet from the normal high water line, the opening in the canopy of 250 square feet, and then the 25 by 50 grid to apply the point system, and then the 10 cubic yards, the earth moving or filling of 10 cubic yards. Would you agree with me that those are the items we need to be concerned about?
Yes, I would agree. Although I do think that some of those are a stretch when it comes to specifically the use of technology. But yeah, I'll agree for conversation's sake.
So let's talk about the 10 cubic yards first. Why doesn't any of this matter to the determination of whether 10 cubic yards were moved or earth filling occurred of 10 cubic yards or more?
And why doesn't the admission of the new evidence, that's specifically what you're looking for, right?
Exactly.
Actually, first, can I just ask a quick question on a show of hands? Did all the board members get a chance to read those two documents today?
Yes.
So everyone's up to speed. Okay, good. Yeah, so, I think when it comes to the calculation of the cubic yards of material, phone measurements weren't used for that. So I'm not sure why that's being discussed.
Okay. How did you, so just remind us why the board should feel comfortable that there were at least 10 cubic yards of earth moving or filling occurred.
Yeah, so I mean, first off, let's not ignore common sense here. I mean, looking at just a photo of the after result of this property, and keeping in mind 10 cubic yards is a dump truck, one dump truck.
Mr. Chairman, I just need to object to this line of questioning. This is just a reiteration of information. This has already been part of the record. I don't think we need to revisit testimony that was already given. This was very much the subject of the questioning prior to, and I don't think that this is appropriate to have somebody retestify as to the same things they've been already asked. This is about the accuracy of the measurements, not the measurements themselves.
And
may I respond? May I respond?
The question came to me, so I'll answer. I think I do think there's relevance to this. So if we're talking about accuracy, and if something comes down to inches, but we're really looking at it in terms of feet, yards, or greater, you know, there's a big difference there. So I think from the board's perspective, it does not hurt us to get a recapture of that picture of what Alex's measurements were like, and you know, his reasoning behind it.
Okay.
Thank you.
Yeah, so sorry, now I've kind of lost my train of thought there. So yeah, I think a lot of this we need to use common sense. Looking at the shoreline, keeping in mind that your 10 cubic yards is a single dump truck of material. There's scientifically, mathematically, you know, there's no way that there's less than 10 cubic yards of material brought in. But again, common sense. The measurements of the riprap brought in, if you look at those numbers, you know, let's say that it's 6 inches deep that was added on top of the existing riprap, 60 feet long, 10 feet high. That's already over 10 cubic yards. And those numbers are duplicated everywhere. And I don't see how you can argue that those aren't factual numbers at this point.
Okay. Okay, so then let's talk next about 100 feet from the normal high water line and why the board shouldn't be concerned as a result of these articles that have been entered into the record, why it shouldn't be concerned about that number.
So I think the accuracy number that I heard was, you know, 20% margin for error. So I think that puts us at, you know, possibly us having it at 80 feet instead of 100. I think clearly all the work that was done, you need to go, please go, has been done within, you know, 20, 25 feet of the shoreline. If we are talking about work that was done, hey, can you come take him, please? Work that was done 75 feet and beyond from the shoreline, maybe we could have you know, a chat about accuracy. But as I read that article from a random blog post on the internet that anyone can post in 2022, it seems to be pretty favorable when it comes to iPhone measurement. And if we're saying 20% is the margin, then I think we have no issues at all, because clearly all the work was done much closer than 80 feet.
Okay. And by the way, what steps did you take to make sure that using the Measure app was sufficient for your purposes? How did you determine that it was?
Well, it's just one of the tools that's used. And, you know, the Measure app, like I think I said last night, is, you know, something that's been tested and is accurate to inches in certain situations, depending on, you know, how fast you move, how light it is, and, you know, making sure your camera is not covered with fingerprints. Little things like that can affect it. If it's used correctly, if you actually know what you're doing, it's going to be pretty accurate. Now, the other thing to keep in mind here, and the reason why I actually prefer to use that method instead of pulling a tape, is if you're by yourself, to take accurate measurements with a tape is practically impossible, because you have to then calculate what the slope is of your tape measure to take out the effect of, you know, it being a horizontal measurement. So, you know, these are things that we have to do to get these accurate numbers. And unfortunately, that often involves using maybe technology that some people just aren't comfortable with or used to using. But, you know, we used 3 different types of measurement when it came to this.
And what do you mean by that? What 3 different types of measurement? What do you mean?
iPhone measurement, tape measure, and Google Earth.
Okay. So, and I think yesterday, I think you testified that you actually tested the Measure app on a tape.
Yeah.
And can you just restate what the results of that test were?
Yeah, I mean, I can get it to be exact depending on, you know, like I said before, all those variables. It is very sensitive to light, so if you're going to try to do it in, you know, at sunset, it might not work as well, you know, or after sunset. But if you have a light day and you're moving slowly, you know, and you get a contrasting starting point and ending point, you know, I can get it down to practically exact, maybe an inch or two off.
Okay. And you also mentioned that a tape measure was used. Could you describe what the circumstances there?
Yep. So actually, DEP came to meet with us on site last year, a whole year ago, when we did this, and they took a bunch of measurements that day, and with Chris Hansen, my assistant.
And they verified all the distances?
Yeah.
Okay. Now, next I want to ask you a question about the 250 square foot opening and canopy and why the board shouldn't be concerned with regards to that dimensional number by these articles.
Mm-hmm. Yeah, so there's a couple of spots on the lot where they've opened up canopy in excess of 250 square feet. Why the board shouldn't be concerned? I mean, let's break this down. 250 square feet is only a 10 by 25 foot area. And if you look at, you know, the before photos, the large tree that was over 100 feet tall that was taken on the peninsula, that had you know, a width of, you know, well over 10 feet, well over 25 feet. And same thing with the tree that was removed over near the stairs. Again, unfortunately, the ordinance was not followed. The contractor didn't meet with us on site prior to removing the trees. So we don't have an accurate measurement from end to end on how wide that tree was. We have to base it on the information we have. And that's not our choice. Unfortunately, that's what the town has to live with because the contractor didn't follow the rules.
But you know at least that canopy was more than 10 by 25.
It was definitely more than 10 by 25. And you know, there's measure tools other than Google Earth that we can use to measure using the survey that was done of the property by Jones Associates. And we can take, you know, approximate points and measure the width of that, looking at the before photos, and come up with a pretty accurate number on what we believe, you know, the width of that tree could have been.
Have you done that?
Yeah.
Okay. And would you be able to walk the board through that calculation?
I could probably do that right now. Yeah. Let me just see if I have. Everything that I need. Yeah, I can do that. Does the board want me to do that?
I'm just gonna, if I can, just register an objection. I think what we need to remember here, what is relevant is what measurements were in this. What's relevant here is what was known to the code officer at the time of the notice of violation. And I think we're getting really far afield here. You know, again, much of the evidence has already been submitted. I think to Attorney Wagner's point, one of the important things to consider here is that this is not another opportunity to backfill or to supplement evidence already given. I think, as Attorney Wagner said, is that it's important to understand what evidence could have been or should have been given at the time. I mean, we're you know, I think that this should not be looked upon as an opportunity for the code enforcement officer to look in the rear view mirror and supplement the record. What's important is what was known at the time of the notice of violation and what was actually included in it. So I think we're going a bit far afield here.
May I respond?
Yes.
You don't get to eat your cake and have it too. You moved to supplement the record. It was granted, and it's only fair that Tom be able to respond to what you've put into the record. And that's exactly what we're doing.
If I may, again, I think there's a distinction between the use of this tool on site and how it relates to the relevant articles that have been entered, and a discussion about how evidence or purported facts and figures that were obtained following the issuance of the notice of violation in some way impact or cure, as it would be, any obvious defects in those notices. And I think that, if I can summarize, I believe to be Attorney Rachen's argument.
So I'm gonna, unless the chair has an objection to it, just offer my opinion here. I think that the door's been opened to questions about how measurements were made and the reliability of Alex's testimony of his measurements, and so I don't see anything impermissible about the line of questioning here. Again, I think the door's been opened for that. So those considerations of fairness and relevancy, you know, that was what should have and was considered before this was admitted, but now that it has been admitted, I think the line of questioning is fair. But I would just ask that we, you know, keep in mind the time and try to be brief about it. So that's my recommendation to the board.
I don't disagree. What I'm saying simply is this, is that we are not talking about, if we're talking about accuracy of what was used at the time, we don't need to then go and talk about, oh, and then I looked at a survey later in time yesterday after this was raised. I understand that, you know, the town has the opportunity to talk about the accuracy of the methodologies used, but then it's not appropriate to talk about what they went back to their office today after that testimony yesterday. That's the only distinction I'm making. The accuracy of the methodologies used in time at the relevant time, which was prior to the issuance of the notice violation. That's it.
Yep, I appreciate the clarification, and I think your point's clear on that. But just so that the board knows, I stand by my finding that this questioning is permissible, as you know, the parties have introduced, all the parties here introduced and relied on evidence that has happened after the violation. So I don't think that the fact that we're talking about measurements that occurred after the notice of violation was issued makes the evidence inadmissible.
Yeah, if I could just add real quick one thing on that. I can't take you guys all to the site right now and paste the site with the app to do that in real time. Fortunately, that was done then, and there's no way to duplicate that. So I don't know how we would at the moment, but we can do that now.
If I may, Mr. Chair, I'd just like to preserve and point out an issue with due process there. As CEO Soroy has just indicated and testified, there's absolutely no way to develop or recreate the results in which he's seeking to testify here. And I think that's part of the problem and issue, and what either Attorney Rachen or I's additional questioning might indicate here. Is that as a defendant, as an appellant in this case, we're being presented with facts and measurements and circumstances that the CEO himself has just indicated he cannot reproduce.
I guess I just don't agree, because I don't see how that's any different than me going and pulling a tape.
So can I think we're getting into a bit of back and forth. So I'm going to turn it back to the chair. You know, there was an objection from Attorney Rachen to this line of questioning. Does the chair, it's totally within your discretion if you want to permit this line of questioning, or if you would like to instruct Attorney Wyckoff to move on.
Yeah, two things. I'm perfectly fine with continuing on with this, because it was my understanding that with the submission of this information and hearing from Attorney Rachen and Attorney Braun, that it's important to establish that accurate measurements were taken. So it is important to hear how Alex went through with this, and if inches really matter in these cases, or if it's you know, potentially not that concerning. And also, Alex, you'd asked if you need to go through the steps of showing the canopy. I don't think that's necessary. I think we tracked with you fine with that yesterday, unless somebody else on the board says otherwise. Again, we don't have to get too deep into this, but certainly clarification of the measurements, which I think we all think are important. Clarification of what steps were taken with regards to the measurements. It's appropriate to hear through again. So I guess we'll turn it back over to you, Attorney Wyckoff, unless Attorney Wagner thinks otherwise.
No, what I understand is you're allowing Attorney Wyckoff to continue with that line of questioning and noting that the objection has been made for the record.
Thank you. Alex, let's go back to where we were. Can you continue where you were, or do you remember where you were?
No, why don't we fire that back up?
Okay, I think I maybe lost track too. I think we were talking about the opening in the canopy. Actually, no, we didn't. I think, did we complete that? I've lost
No,
track.
that's where we were. We were on the
Okay.
canopy. You're right.
Okay, so could you just help the board to, I think you said that there was another way to verify that, and I think you were gonna lead us through that.
Yes, I can do that. But you guys got to be kind because I don't do this publicly normally, so it's going to be interesting. So let me just share this screen here. So here you can see the before photo. You've got the tree next to the stairs, and if you look here, you can see that this tree that existed that we were unable to actually physically see on site hangs over the stairs, very clearly hangs over the stairs. And the stump for this tree is located at the top of the stairs. So using a scalable plan, which is derived from the survey from Jones Associates, I'm assuming right now, based on the information I have, not being invited to the site to actually inspect this tree, that we've got a canopy that hangs over to the stairs here, and like I said, ends with the stump around right there. Measuring that with this scaled measuring tool, that right there is 16 feet, and it's clear from the photo that you've got an area that's at least 16 feet wide with this tree, from almost all the way over to where this deck is and back. Again, we're relying on what we have available to us here. Measuring from here over, saying that the center is around there, again, we've got close to 20 feet. And so let's say, for conversation's sake, that was 20. I think it's actually 23. 16 by 20 is 320.
320 square feet.
320 square feet, which is, that's a pretty conservative measurement of just one, quarter of that pie squared off. So, it's easy to see just based on that there, that they exceed 250 square feet. And it's definitely a violation of that section. Now, that's only one tree. There's other sections, of this lot that canopy was open, and that one is, just the easiest one I think to see in this particular situation. But clearly it's in excess of 250.
And the document you were looking at, can you just describe what that was?
Yeah, this was a plan created by Stony Brook Consultants. Actually was used by Mike Morse when he created his first rendering of a proposed replanting plan, I think,
and
at some point along the way.
And is that at page 138 of that 249-page PDF that Attorney Rachin provided to the board yesterday?
I believe it is. I don't have that up in front of me. I think I closed that window, but I believe that is where I got that. Yeah.
Okay, very good. Okay, now, so in other words, in that one, you measured that one instance. So, and that's just one of them. So in other words, you're exceeding the 250 square feet opening in the canopy by factors, actually, correct?
Yeah, oh yeah, definitely.
Okay, so then let's next talk about a 25 by 50 grid to apply the point system. Can you explain to the board why it shouldn't be concerned about that number by these articles that have been submitted?
Yeah, I mean, and we could use that same tree for conversation's sake. You know, that particular grid, if you were to establish a 25 by 50 foot grid in that section of the yard, that was the only tree within that grid. And even if we give it the maximum number of points, it's still only going to be worth 8 points. You can't remove any trees if you're going to have less than 24 points as the end result. So I just don't see any particular situation where you could establish a grid that would also include that tree that would give you more than 24 points. It just doesn't seem possible.
Okay, so in other words, there's many more than a single 25 by 50 foot grid that doesn't have enough points.
At least 2.
Okay. Could I actually, could you go back to that plan that you showed earlier? Could you go back to that, please?
Yeah, hold on one sec. Sorry, I got too many things open here.
No problem.
All right, this one here?
Yeah, that's right. Could you do me a favor and zoom out a little bit?
Yeah.
And I just want, and there, Attorney Rachel had mentioned an issue that Chief perceived relating to the location of the normal high water line as a result of this stuff. And what I'd like you to do is, could you zoom in on the bubble that's included in this document that's already in front of the board that relates to the location of the normal high water line, please?
Now you're talking about this one down here?
That's right.
Yeah, so this says that the shoreline was regraded with riprap between survey dates of 6/20/2019 and 11/9/2021, which changed the horizontal location of the high water line, which you can see here. The 11/9/2021 date is this line here. Sorry, I got the measure tool on. Let's turn that off. This line here, oh, that's white. And then the original shoreline is the dash line, which they're pointing to here, which was 6/20/2019. So you can see there's areas here where the shoreline jogged back.
Now that's actually
over to, yeah,
that's
I'm trying
actually,
to get over there.
Okay, good enough. Yep, you anticipated my question.
Yeah, that's just where the note is.
Yeah. Right. So stop there. Stop. Now that heavy black line.
Yeah.
That's there. What does that depict?
Are you talking about the one down the center?
Yes.
That's the lot line.
That's the lot line between Whitetail and Fernwood, correct?
Yep.
And Whitetail is on the right side of that heavy black line.
Yeah.
And that former normal high water line extends over the lot line and into Fernwood, Whitetail, doesn't it?
Yeah, I believe you're talking about this dash line right here.
Right.
And then the new line. Yeah. Yeah.
Right. So what does that survey show you?
Looks to me as though the shoreline's been expanded.
Okay. And you didn't need to have any Google apps or Measure app to figure that out, did you?
Correct.
Okay. I don't have any other questions. Thank you.
Yep.
So I would turn it over to Attorney Rachin as the appellant to ask any questions of Alex.
Sure, thank you. So back to, what I'm trying to think the whole point of this submission of this article was to talk about the accuracy of the measuring tools that the CEO said that he was using at the time to establish that there were violations. And so with that in mind, Alec, what version of the iPhone measuring app were you using?
I'm not sure. Whatever version existed back then.
Okay.
I don't know particular.
All right. So you're not sure, but how recently did you update that app on your phone?
I am not sure. It would have been last October. I don't, it's a year later. I don't know what version we were using at that point in time.
And did you ever upgrade it or did you just take what was on your phone and use that?
I update my apps daily. There's notification for updates required. So it would have been whatever the version was at that particular date.
Okay. And in your testimony, I think I heard you say that, the protocols that you use, how much you move or, what time of day, those kinds of things are critical to the accuracy of the measurements. Is that correct?
Yeah.
Okay. And do you recall what time of day it was that you were using this app?
It was midday. I think it might have been late morning.
Okay. And how did you ensure that you were, I think you said you can't move that fast, or, do you have any recollection, or did you note how fast or how you were using that app?
Yeah, used it as I normally would.
Okay. And I think in the article, and you may have even said this yourself, that you need to take, in order to ensure accuracy, multiple attempts, take those measurements multiple times. Did you do so?
Yeah, we did multiple measurements. Yeah.
I mean on your phone app while you were doing the measurements, just to be clear.
Mm-hmm. Yeah.
And did you take?
I usually go from the water up and then from that point back to the water.
Okay, so when you say
so
multiple
usually
times,
always 2.
Twice. Okay. And while you're doing that, in order to have records of that and to record it, did you take sort of screenshots, or how did you record your multiple attempts at measuring?
I just noted it.
Where?
In our logging system, our note system that we have, just a notepad.
And when you say notepad, is that something, when I'm old school, this is my notepad. Are you saying you had like an iPad that you recorded that in?
No, just like to be honest, a lot of times I'll text myself if I'm, in a situation, but I usually will do voice notes because it's just not, try to send a text in the rain, for example, it usually is pretty difficult. So I'll usually do voice notes.
Sure. And so you maintain those records? Do you keep those records?
I'm not sure if I have any specifically for that. I know, a lot of our mission the day that I went out initially wasn't necessarily to, be getting specifics on dimensions and stuff like that. Also we need to remember things like the boat ramp were gone. There was a lot of things that, we really didn't need to measure necessarily that first day we went out. It was more or less to assess the violation. Now, when DEP went out, they did take more specific dimensions, and Jeff did actually log that information, I believe, on just a notepad. And I know Chris has some notes on a notepad as well as far as dimensions go.
Okay. And let me just follow up on that question. When I just want to be clear, I said this initial day when you went out, and you said that you weren't thinking necessarily of taking precise measurements. And when you drafted that notice of violation, were you going off those measurements that you took that day?
Well, we had been to the site multiple times when the NOV was issued.
Okay, that's fine.
By the time the NOV was issued.
Okay, and one other question I had for you is the document that you were showing, that Stony Brook survey. I noticed that you were using that tool and had various scaling and such. What was that program that you were using?
That's just Adobe.
That's Adobe.
Yeah.
Okay. And did you have any particular training in Adobe to be able to do those kinds of methods?
Yeah.
What was that?
I took multiple courses in digital media using various Adobe Suite products in college.
All right. Thanks, Alex.
Yep.
Attorney Braun, I would give you an opportunity.
I think Leah touched on most of the things I was going to ask, but just to ask a few extra. Alex, you testified there that I believe your exact words were "little things can affect it." That's a quote. And you pointed out fingerprints can affect the accuracy of the measurements you take with that device. What sort of steps or protocols do you use to speak to that, or make certain that measurements are accurate?
Yeah, it's a great question. I think it would be if you guys all tried it out tonight. If you have an iPhone, it's probably would probably enlighten you a little bit on how it works. So it uses your phone's camera. So it's very easy. If you hold up your camera and it looks blurry, it's smudged. So you just wipe it off. That easy.
Okay, but you do understand that the specific phone and the specific app that you used or what is relevant in this matter, correct?
Sorry, you cut out a little bit. I didn't hear you there.
Sure. So you invited us to try it ourselves at home, but you do realize that the specific phone and the specific app you used are what's relevant to this, right?
Sure. But I mean, everyone needs to understand the information, specifically the board members.
Okay. You said that when you went out and did the measurements, you did it as you normally would. Do you have a written process or protocol that you follow when you go out to these sites?
No.
Okay. As it relates to your note keeping, you said sometimes you send voice texts, sometimes you send or voice notes in this case. Is that correct?
Yes.
Okay. And in fact, you're not certain what sort of working notes or on-site notes may actually exist as it relates to your evaluation of the property. Is that?
Yeah. No. I assume you're specifically talking about October 26th, and the goal for October 26th, like I said, wasn't to go out and get all of our specific dimensions and stuff like that. It was literally to meet with Rob Durant on site to say, dude, what happened? Sure. And that was our mission there.
But you did also give orally a stop work order on that day, correct?
Yeah.
And so you would have then had to have made some determination that a violation took place to substantiate that oral stop work order.
Yep, but we didn't, serve a notice of violation on that day, as you know.
And you didn't follow that up with a written stop work order afterwards, correct? Just to clarify.
Correct.
Okay.
Correct.
Do you recall, you said it was sensitive to light. I don't want to belabor it, but just for the record, do you remember what the weather was like on the 26th when you went out?
Yeah, it was cloudy. It was overcast.
Okay. And how does that affect the accuracy of that measuring tool?
Worked fine.
Okay. And what history or examples can you compare that to say it worked fine?
I mean, I've been using it for, I don't know, 3 or 4 years at this point, long before I was in Raymond. So I would compare that to previous uses. I mean, there's times if you use it in the dark, you're going to tell it's not working correctly. So I wouldn't use it if that were the case.
All right. And finally, the device that you're using, is that town issue? Does that belong to the town or does that belong to you personally?
Belongs to the town.
Okay. And do you use it for personal purposes as well?
Nope.
Okay. No further questions.
So, do we have any members of the public who have any questions for Alex? Sorry, Mr. Sorey. Seeing none, I'd turn it back to Attorney Wyckoff. Do you have any re-examination?
No, not necessary.
Okay. Does anybody have any further comments from the attorneys? Oh, I'm sorry, actually, does the board have any questions for Mr. Sorey? I'm not seeing any. Did any of the attorneys have any closing arguments to make? I think we've covered everything on this point, but providing that opportunity, not seeing anybody taking it up. So I would suggest to the board that we close the public hearing and the record again.
So we need a motion for that, correct?
Yes.
Yeah, so moved.
Attorney Wagner,
seconded.
Just to confirm, do you need to have it open or offer comment from the public for this reopened evidence? Just again, making sure we're.
I gave an opportunity for the public to speak. I guess yeah. Let's just act consistent with past practice. How about, can I have a motion to reopen the public hearing? Can I get a so moved on that?
So moved.
And can I get a second?
I'm sorry, I'm confused, to be honest with you.
Second.
So what I'm doing right now is just reopening. In the past, we've had a practice of making a motion to open the public hearing and then ask if there are any public comments and then close that. And so I think Attorney Braun raises a valid point that we should go through that practice again so that it's clear that the public was given an opportunity to respond. So we have a motion and a second to open the public hearing. Can we do a roll call on that?
Sure. All in favor, David Murch, yes.
Greg Dean, yes.
Fred Mello, yes.
Henderson, yes.
Pete Lockwood, yes.
Okay, so that's unanimous. Any comments from the public? Seeing none, can we have a motion to close the public hearing?
So moved.
Second.
And roll
David
call.
Murch, yes.
Greg Dean, yes.
Fred Mello, yes.
Henderson, yes.
Pete Lockwood, yes.
Fred, I think we're waiting on you.
Fred Mello, yes.
Okay, and so now I would entertain a motion to close the record.
So moved.
Second.
All those in favor, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Mello, yes.
Pete Lockwood, yes.
Okay, so the record has been closed. That additional material and testimony is now part of the record. So now we would proceed to deliberations. I don't know if I'll defer to the chair if you want to call a break in between now or if you're ready to dive into deliberations.
Yeah, given we're an hour and a half in, let's take a 5-minute, 5-minute break and then return and kick into those. So 7:37. So Attorney Wagner, you've been good to walk us through these from a procedural perspective. If you could do so again, that would be greatly appreciated.
Sure. So the board's now entering into deliberations on this appeal. As before, I suggest that we have in front of us with these documents that I'll be using and encourage the board to use just to help guide us as the notice of violation for this appeal, the notice of appeal filed by management controls, as well as the town's proposed findings of fact and conclusions of law. As you'll recall, in the past, we've sort of used those 3 documents to guide our decision process and then consult, evidence as we go through it. As before, I suggest the board we go through issue by issue and make a tentative vote on each issue and articulate the factual findings of the board. As before, I'll sort of take a consensus on the factual findings, and that'll help me write up that decision that we'll vote on. So again, those votes are tentative. The final vote will be based on the draft written decision that I'll present to you at a subsequent meeting. And at that time, we'll take a vote, and that will be the final decision. So I again suggest that we, as we go through, identify the applicable standard, review the arguments on both sides, get a sense of where the board is on, whether that particular violation should be upheld or vacated, and go through the analysis there. So you can bear with me a second. So as I see it, the first initial issue is whether all violations should be vacated because management controls reasonably relied on its contractor to obtain all required permits and act consistent with the shoreland zoning ordinance.
I'm sorry. can you repeat that? Yeah.
Sure. So I think the first issue to address is the argument from management controls that all violations should be vacated because management controls reasonably relied on its contractor to obtain all required permits, and that consistent with the shoreland zoning ordinance. So, Chairman, oh, now you're back.
Okay. Yeah, I'm just looking at some insight from my fellow board members.
Yeah, I'm sorry, I'm just reviewing the actual. We've accrued quite a few documents at this point. Yeah, I mean, I think with respect to the reliance of the contractor, I think it's doesn't really invalidate the NOD. I think I don't know if it's even our roles unwind the accountability to that degree. So I sort of think the town's position is correct here. But with everybody else's thoughts.
Greg, I believe the town has shown. Tom, anybody else? Pete, Fred?
I agree. I think the town has demonstrated that the owner is responsible.
I agree with this as well.
I smell like poop now. Is he farting?
I agree. I think the town is
talking. I'm sorry, got a little distracted there. Was that you just talking, Fred?
I said I agree. I agree.
Okay.
With all of you. Yes.
So I'm sensing the board is unanimous in that. Can I ask, so previously in the management controls decision for 18 Fernwood, the board made factual findings here that I'll just briefly summarize, and my question is going to be if those same factual findings and reasoning that you applied when this issue was raised there apply here. So actually I won't even summarize. Let me see if I can just get an answer to that. Do you agree with the same findings you made in that case and the same reasoning for that you gave for why the argument here you were not persuaded by, and you believe that management controls is liable for actions, or rather the fact that the actions were conducted by management controls agent does not invalidate the violations?
Yeah, I agree with that.
Okay.
I agree.
So the only difference being, of course, that here you're dealing with 28 whitetail. So your findings would be that the MCL is the owner of 28 whitetail, and that they contracted with either Durant Excavating Marine and or Robert Durant to obtain all permits and perform the activities giving rise to the notice of violation at 28 whitetail.
Yeah.
Okay. So I'm sensing unanimity on that finding. So I would suggest a motion concluding that the board concludes that MCL is responsible and the CEO did not err in all violation. Well, that's on the negative. So how about a motion to deny a motion to uphold, a motion to deny the appeal on the grounds that all violations shall be vacated.
So moved.
I'll second.
Favor, David Murch. Are you hearing?
Yep.
Okay. Gotcha.
What's up?
I think
Yep.
we're
Roll
going
call.
roll call vote. Yep. In favor, yes. David Murch.
Yes, Craig Dean.
Tom Hennessy, yes.
Miller, yes.
Reed Lockwood, yes.
Did we get everybody on that?
Yep.
Okay. So the next issue is whether violation 1 should be vacated. I'll summarize that this relates to soil and water conservation practices in this zone, which may be conducted without a permit, and the applicant's position is that there was, sorry, just catching up on my notes here, that the town had presented insufficient evidence that this violation occurred. So again, my suggestion is that we identify what was raised in the notice of violation, the applicable standard, and make your findings and conclusions based off of the evidence presented on those issues.
So the notice of violation, filling and earth moving of more than 10 cubic yards, but the shoreline zoning positions was specific to erosion control. Section 15, land use standards, section U1, erosion and sedimentation control, filling, grading, lagooning, dredging, and earth moving. And all other land use activities shall be conducted in such a manner to prevent erosion and sedimentation of surface waters to the maximum extent practical. All activities which result in unstabilized soil conditions and which require a permit shall be developed in accordance with an erosion and sedimentation control plan prepared in conformance with the requirements of the Maine Erosion Control BMPS, Bureau of Land and Water Quality, Maine Department of Education and Environmental Protection, March 2003, and subsequent revisions thereof. So we're looking at erosion control. And I believe it was presented that no erosion and sedimentation control plan was prepared or submitted. We did see pictures that indicate that what erosion control was in place. Some of it was down. I don't see that this particular item was in error. I think it's correct. Anyone else?
I agree with you. The pictures, was showing that that it was laid down, by the boat landing area there.
I agree as well, David. I think there were some pictures that even showed some erosion.
So one of the threshold findings here, and I'm going to just read from the proposed findings on this issue, is that filling and earthwork of more than 10 cubic yards took place within 100 feet of the normal high water line of Sebago Lake. So I'd ask the board to give me your thoughts on whether you think the evidence supported that finding, and I think it's important to point out here, what evidence you are relying on to make that conclusion.
Yeah, I think that's. I'll take a swing at this. So I think that the whole. Well, I guess there's two parts. There's one is the measurements that have been demonstrated, do they exceed the threshold? And from the visual evidence that's been displayed, and there's the pictures of the riprap that's been added, or sorry, the beside the house that has the vegetation removed, all sort of exceeds the threshold based off from the reported measurements. And then I think as a secondary measure, hey bud, hold on 1 second, daddy's talking. And as a secondary point there is the quality or the accuracy of the measurements. And I think that I find that the threshold is the degree to which the earth has been removed doesn't come close to any of the kind of demonstrated counterpoints on the accuracy. So I guess that's kind of the twofold issue here. But I think that's what Ms. Rachel had asked us to specifically address. So we'll do so and say that we considered at least I considered the possibility of error in the measurements, and don't find that it would, even if you take the face value of what the appellant is saying is the maximum error, it puts it within a reasonable tolerance that would fall underneath that threshold. Is that not very concise, but sorry, that's kind of.
No, I think you articulated that well enough for me to follow. So does the board agree with that finding?
I agree.
I agree as well.
I agree.
Anyone hear me?
Yes.
Okay, good. I agree.
And do we agree that a permit was required and no permit was obtained?
I think that falls more under number 2, but although I do.
If a permit was obtained, then they would have had to have done the sedimentation and control plan. So I think
Gotcha.
that's
Yeah. Oh, that's a good point.
Yeah. No permit.
Okay. So I think I've got clear factual findings. So I would suggest a motion to deny the appeal as to this argument and uphold violation 1.
So moved.
I'll second.
David, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Steve Lockwood, yes.
Okay.
So our third item, number 2, on the notice of violation, filling in earth moving of more than 10 cubic yards without a permit. Filling in earth moving more than 10 cubic yards occurred in LR2 zone without a permit from the code enforcement officer. Looking at shoreline zoning provisions, section 14, table of land uses. Item number 30, filling and moving of more than 10 cubic yards. Yeah, we recognize, at least I recognize that a permit was not obtained, and as discussed, more than 10 cubic yards was moved.
Yep, I agree for the same reasons, including accuracy of measurements, but when it comes to the threshold. Yep.
Okay, so what I'm hearing is same reasons and findings that applied in 1 apply here.
Yes.
Okay. I think it makes sense to also address here the argument that 2 and 1 are duplicative and should be consolidated. Do we want to address that now?
I look at this, I've presented here 2 separate items of the shoreline zoning provisions. One is very specific to filling and earth moving. More than 10 cubic yards, or the other one, while that does include filling and earth moving, it's also specific to an erosion and sedimentation control plan. And so I find them to be separate items. At least that's my perspective.
Does anybody disagree?
No, I agree.
Nope, I agree.
I agree.
So I think what you articulated is consistent with the board's reasoning on this issue when it was raised as it pertains to 18 Fernwood. Would you agree?
Yes.
Yes.
Okay. So I think at this point I would suggest a motion to deny the appeal as it pertains to this argument and to uphold violation number 2.
So moved.
Second.
Good Merch, yes.
Greg Dean, yes.
Fred Miller, yes.
I'm gonna say yes.
Lockwood, yes.
Okay, that's unanimous. So the fourth issue pertains to violation 3. I'll turn it over to the chair.
Piers, docks, wharves, bridges, boat launches, and other structures and uses extending over or below the normal high water line or within a wetland without a permit from the planning board specific to the boat launch. Boat launch has been enlarged or expanded at or below the normal high water line of Sebago Lake without a permit from the planning board. For land zoning provisions, section 14, table of land uses. Item number 17B, permanent piers, docks, wharves, bridges, boat launches, and other structures and uses extending over or below the normal high water line or within a wetland require approval from the planning board within the RP, SP, LRR1, and LRR2 districts. So this is definitely in the LRR2 district. The question is, do we have evidence supporting that boat launch has been enlarged or expanded?
I'll take a swing at that, David.
Sure.
Yeah, I find the evidence pretty clear, given the comparables beside the boat launch and the visual evidence. It looks like it was expanded substantially. It also looks like that expansion falls to the degree at which the error would have been. Again, if you take the maximum error, it would not reduce the expansion kind of below where it would need to be in width. So I think we're talking like 8 feet to 16 feet. And I don't see anything that was presented that would make that a meaningful amount of error. You'd have to lose a whole 8 feet for it not to be expanded. So I think there are multiple ways of measuring that, and kind of I think it's pretty clear from the visual evidence that it was expanded.
Yeah, I would agree. I would say based on the visual evidence, testimony from Alex, and also the information that we received in that large PDF document about.
Yeah, that was Exhibit B.
Yeah. Specifically, page 127 of the PDF, where it says contractor 1 has stated that the boat launch structure was widened by approximately 6 additional feet in the southerly direction after removal of a large tree stump immediately to the south. But I'm not relying on that alone. Again, both visual evidence and testimony by Alex would lead me to believe that yes, the boat launch has been expanded, and I would also say that there was no approval from the planning board to do that.
I agree.
I agree as well.
I agree.
Okay, so what I'm hearing is you find that there's no record of a planning board permit for the boat launch. The boat launch was enlarged, expanded, and replaced, and that this was done without a permit, and that this work therefore is in violation of section 14 at line 17B, as well as shoreline zoning ordinance 12C4. Is that accurate?
Accurate, yes.
So if you can bear with me, I just want to check my notes on the other arguments that were raised on this issue. So, and as the board had considered, the appellant made an argument that, this was a non-conforming use, and it really wasn't replaced. There was just, I guess I would characterize it as a modification with similar material to the shoreline, and it was a minor modification of an existing non-conforming use. Was the board at all persuaded by that argument? Any additional findings or reasoning concerning that argument?
I'll take a shot at that one. From
ahead.
the photographic information, it looked like, as Alex presented also, there's a few pallets of wood and some planks to hoist in small kayaks and dinghies. And the after effect is now a very large, long riprap boat launch that vehicles and trailers can now go and launch their boats. The former one was just a homemade little plank of wood to throw in small boats. So it's completely different.
I agree with that.
I agree also.
Yeah, I agree. And I think also I didn't see evidence of a tree stump being the cause of anything as well. I think I'll point out that I saw no evidence of that. I believe was also a point that was made.
And I'll add to that, Greg, that the tree stumps aren't supposed to be removed. On top of that, that's another violation.
And Greg, I think you already touched on this, but yeah, you did, about the location of the normal high water line and whether the dispute about its location affects your findings at all. I think you said same reasoning as you have before. The margin of error is so small here that it wouldn't affect your findings.
Well, with the normal high water line on this particular issue, it's about where the so it's about where the enlargement or expansion occurred, right? So I'm not sure if there's a measurement that was debated, at least in this particular instance, other than with it being within inside a certain distance to the water line, maybe. But
okay.
Maybe I'm not understanding the.
No, I think I think I understand what you're saying is that I guess how I would phrase it is that where the normal high water line is or is not really relevant here as to what's key is to whether the boat launch was expanded or enlarged, and you feel the evidence clearly establishes that. And so that finding's not altered by the debate about the accuracy of the measurements used.
Yeah, I can clarify. I can clear that up in my own words if that is helpful. But that's a fair summary. I think that there's the water line can move up and down within a certain band, and if no matter where the water line was, it looked like the expansion would have still fallen within the sorry, it would have still fallen in violation.
Okay.
So that there's no issue of a tolerance that would have moved it outside of the violation, I guess.
That's clear. Thank you.
Yeah, and I don't. Yeah, okay. I'll stop there.
So those findings support a conclusion by the board that the violation site of the ordinance cited in fact occurred. Is that right?
Yes.
Yeah, I agree.
Okay, then based on those findings and conclusions, I would suggest a motion to deny the appeal as it pertains to this issue and uphold violation 4, right? 4.
So moved.
Second.
David Murch, yes.
Wait, no.
Lockwood, yes.
Tom Hennessy, yes.
Fred Miller, yes.
So that was unanimous, but I think actually it is violation 3. Sorry.
Oh, I'm sorry. Yeah, you're right.
Let's do that again, but in violation 3. Sorry.
So moved.
Yeah.
Seconded.
All those in favor? David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
All right, thank you. Sorry about that. So now 5th issue, which pertains to notice of violation 4. I'll turn it over to the chair.
So piers, docks, wharves, bridges, boat launches, and other structures and uses extending over or above the normal high water line or within a wetland without a permit from the planning board. This is specific to the shoreline. Shoreline has been enlarged and expanded without a permit from the planning board. Looking at shoreline zoning provisions, section 14, table of land uses, item number 17B. Permanent piers, docks, wharves, bridges, boat launches, and other structures and uses extending over or below the normal high water line or within a wetland require approval from the planning board within the RP, SP, LRR1, and LRR2 districts. So this is definitely in the LRR2 district. I guess the question that I have is shoreline. Is that, do we view that as a structure? Do we view it as other uses? Or does it not fit either one of those categories?
I think when Alex was speaking, that he was saying that the riprap that was put into there was increasing to the shoreline or the structure, enlarging that where there didn't seem to be any erosion there, so that there was no reason to have had to build up onto that area.
Yeah, I think this is with the acid that cuts in, and there's been fill to kind of straighten it out, expanding the shoreline. My understanding is that the threshold is 0, and it certainly looks like that was exceeded by a substantial amount.
So can I actually walk it back a little bit to where I think it was Chairman Murch began this with what I think is one of the legal arguments that was raised of a shoreline is not a structure, so an enlargement or modification of the shoreline could not violate this section of the ordinance. So I think the board should address that first, and then if it concludes that an enlargement of a shoreline can violate this section of the ordinance because a shoreline is a structure for purposes of these ordinance sections, then we get to the factual question of was it enlarged or was it modified?
Yeah, that's fair. So I think it's a use is what we were interpreting as that part of the ordinance. And in particular, I believe it's a boat launch.
No, we're looking, actually, boat launch was addressed in number 3. The shoreline is we're looking at for number 4, essentially the exact same item in the shoreline zoning provisions, but this is specific to shoreline.
Expansion. Yeah, but
yeah.
Wasn't that cut in at the boat launch? Wasn't that S that we're talking about?
I do believe so, yeah.
So the use, I'm saying this, in this particular case, it's not just a random piece of shoreline. It's a use of the shoreline, and that for better or for worse, that's what the ordinance says, right? Like it says use.
I don't know.
Open to other comment critique of that, but
I'm trying to remember, but I believe, didn't we hear that was actually that riprap was considered a structure?
That's what I believe as well. Fred, I want to say I thought I heard Alex refer to a retaining wall and that construe as a shoreline. So that's the definition they were using, if I remember correctly.
The structure, correct.
I see.
So the question is, do we agree with that definition?
That riprap is a structure?
That shoreline ultimately is a structure.
I think if you use the shoreline as a boat ramp, it's a structure. Like if you put something on the shore to launch a boat, like previously would have been considered a structure with pallets. Is that like, so I mean, that seems like a structure.
Yeah, well, I would agree, but this is part of.
We can't hear you, Dave.
So if you go back on this, it mentions boat launches separately. So boat launches and other structures. So I understand what you're saying, Greg, but if we review to that portion as boat launch, then we've already addressed that as part of number 3. Did you kind of see what I'm saying?
Oh, are you saying that they could be duplicates?
Well, because if we use the argument that the shoreline well, I guess you're saying it's a use. I guess I have a hard time because we're looking at this as a use for the boat launch, but boat launch was already addressed. So then it seems like that doesn't. I mean, we already talked about that part of it.
That's a fair point. I mean, I think the strongest argument there is that it's a structure and it's a boat launch, it's a boat ramp. And then if that's the case, then it's already covered by 3.
Right. Anything you want to add to this?
I'll just comment. I think that the basic premise is adding fill to the lake to increase your property line is as simple as you could put it. If you continue to add more and more fill or riprap or whatever, eventually you'll get a jetty protruding into the lake. And I think that's what we're discussing here. Was there additional material put in the lake to extend you can call it the property line, but whatever. So that would be my point on this.
Again, I don't disagree with that, but Can we use that as a definition of a structure?
Well, not if it's clearly itemized as a boat launch. I don't think so. I think it's a boat launch. Like the other structures would be if we were interpreting some other nebulous thing, but given that I think the ordinance states boat launch.
So maybe it makes sense to, why don't we take a look at the ordinance? So I think we're dealing with section 14, line 17B.
Yep.
It seems to me that we're trying to define what the other structures are. And it definitely looks to me like the riprap that was added between the boat launch and the stairs above the beach is additional structure.
And is a structure? Or are you looking at it as structure in association to the boat launch, or structure in association to what?
Beyond the boat launch. It looks at from the pictures that Alex provided, this significant riprap added beyond the boat launch towards the stairs above the beach.
So let me just gonna provide some things for it's your decision to make. I just want to provide you some, additional guidance. So just, page 65 of the ordinance has a definition section. So the board could consider definition to be discussed, the definitions of structure in there, and both parties did on that to make their arguments for why a shoreline was or was not a structure. And also remind you that the town relied on the arguments that it made and suggested that the board should make its decision consistent with its decision on 18 Fernwood. So if you look back at your decision on 18 Fernwood, I believe it was violation 5 pertained to the expansion of shoreline, and the board concluded that the shoreline was expanded and that violated this section. So I think implicit in that finding is that the shoreline is a structure. I acknowledge, however, on the other side is that we're talking about two different shorelines. So there are entirely different facts. So I'm just putting those additional pieces of information out there to help the board wrestle with this threshold question as to whether the expansion of the entire shoreline there can be a violation of line 17B.
So I still believe it's a structure, Dave, that Alex brought up, that is a structure. It has, as Tom said, it is added, structural to the property front of the property there by the water. I still feel that, it is a structural piece of the property.
So our definition of structure is anything temporarily or permanently located, built, constructed, or erected for the support, shelter, or enclosure of persons, animals, goods, or property of any kind. Which I don't think that matches, but I think it says together with anything constructed or erected on or in the ground. The term includes structures temporarily or permanently located, such as decks, patios, and satellite dishes. Structure does not include fences, poles, or wiring with their aerial equipment normally associated with service drops, including guy wires and guy anchors. Subsurface waste disposal systems as defined in Title 30A, geothermal heat exchange wells or other wells. So, but here structure, I can see anything constructed on or erected on or in the ground. I could potentially see something And as Tom had said, it's been built up. I think Pete was alluding to that as well. So has something been constructed there beyond a boat launch?
I mean, if we look at Exhibit 3, Exhibit C and Exhibit 3, which I think is on page 56, it almost looks like there's a wall that's been added there.
Yeah, and I think that's was part of Alex's comments.
It looks like a full wall that's been built. I mean, it's definitely a structure. I believe that's on page 56. There's a before and after. It's actually for the beach. It's showing the beach, not the riprap. But if you look at them two pictures, there's definitely a wall been added there.
And I'm pretty sure, based on my recollection, that is consistent with what Alex had been talking about.
But isn't that part of the boat launch?
No, I think that's a separate structure, Greg.
Okay.
It's closer over to.
Well, I guess it would be. It's near there though. No, I don't. I think you could add another picture. You can add one more picture. No, you're right. We're over farther. You're correct.
Right. Definitely over further.
No, you're correct.
So let me ask this question, which I think is what we're getting at, but I'm not quite following. Do we think there has been enlargement of the shoreline in any area besides the boat launch?
Yes, I think so.
Yes.
You do. Okay. So I'm going to throw this out there and I just want the board to consider it. So I have notes in my, from here that during the CEO's testimony, I think during Attorney Rachen's questioning, he was saying that the only part of the shoreline that was expanded was with respect to the boat launch and nowhere else. So I don't know if the board agrees with that. Do you think there was different testimony? I just wanted to throw out there that I took note of that.
I have the same note actually, and I'm also not able to locate where, if it is where it would be, but admittedly, maybe I'm looking at the wrong page 56. I think Fred, you said page 56, but
right.
I'm not sure if I mean, unless we did disagree with the testimony was. I mean, I believe that was his testimony. So I'm not even sure if Alex would refute the fact that we should be focusing on the boat launch.
Correct. Which has nothing to do with a page 56. I was over too far.
Yeah.
So I think I'll throw this out there that if you find that the only shoreline that was expanded for 28 whitetail is the boat launch, then I think that leads you to the argument that this is duplicative and there's not an independent violation for an expansion of a shoreline, because the only expansion here was the boat launch, and so that's covered by violation 3.
Yeah, I'm gonna have to go with that. I don't have enough evidence before me to say otherwise. I think it got expanded a little bit beyond the boat launch, but I can't. I won't hang my hat on that one.
Yeah, I think I'm going back to the town's points on why trying to interpret them and see if they could be separate. I believe one is for the construction of a boat launch requires planning board approval and a permit for a boat launch, and then there's some allowances of whether or not it was a consideration. I guess you need to take into fact of whether or not it was a existing structure there. But I think you still need a permit. And then 4 is for because you could basically construct a boat launch, but not, contrary to what some of the perhaps other duplicative issues, like I think you can uniquely violate these. You could construct a boat launch and not expand the shoreline, and you could expand the shoreline and not construct a boat launch. So my understanding is that they are addressing unique aspects of the same activity, but fall under different ordinances. I'm open and to feedback on that, but.
So just, I'm just weighing, I think that's a very good summary of the town's response to that testimony. And so that's sort of the counterpoint there.
So is it fair to throw out there as a proposal that it's a boat launch and it was expanded and they're not duplicates? I think that's
sure
where I'm thinking is that the boat launch seems like it is captured in both violations. They seem to address different aspects of it. I think the town's provided sufficient evidence of it. And to address the measurements, I do not think that the issue is within any tolerance of error that has been presented by the appellant. That's my take.
I agree with Greg, I think.
And is it fair to, if that's the board's finding, is it fair to say that that's how you get around that issue of is the shoreline a structure? Because you're saying, look, it's a boat launch area, and that, I guess you still do need to, let me, I'm sorry, not inserting myself. What do you, does that reasoning, I mean, can you articulate where we are on this issue of the shoreline itself can constitute a structure such that an expansion of the shoreline, whether it's part of the boat launch or not part of the boat launch, is a violation?
Well, I believe the ordinance requires a permit for expansion of the shoreline for boat launches as well. I don't think you have to use the interpretation that it's a structure. I think you can say it's a boat launch that was expanded, and that's the violation.
Okay, I follow that.
And if somebody wants to pull up and read that section of what's covered in that ordinance, we can really drill down on it. But I think we did.
I think you did. No, I do think I understand it. So I think that your reasoning is, well, as I understand it, you're essentially saying that the violation should be upheld because the expansion of the boat launch is also an expansion of the shoreline, and that violates 17B because no permit was obtained.
Right.
Okay. Does anybody disagree with that? Okay, then I would suggest a motion to deny the appeal on this issue, uphold, get it right this time, violation 4.
It's so moved.
I'll second.
Second.
In favor, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
Okay. So the next issue pertains to violation 5, and so I'll turn it over to the chair to summarize that.
Sure. Construction of a beach without a permit. A beach has been constructed without a permit, referring to shoreline zoning provisions, section 15, land use standards, item O. Beach construction. Beach construction on any great pond shall require a permit from the Department of Environmental Protection. Beach construction on any river, stream, or brook capable of floating watercraft shall require approval from the Department of Environmental Protection. So my item here that is this actually been a construction of a beach? I have a hard time with that. I mean, I think there's a pre-existent beach. Perhaps there was some work done on it, but I don't, whatever work that may have done, I kind of look at it more as if there was something done, it doesn't necessarily, and that was a violation. It doesn't fall under this particular violation. I just have a hard time looking at this as beach construction when a beach was already there. I don't think you can maintain something, but I don't think you can consider this a newly constructed beach, but that's kind of my take on it.
The thing that I have under this is, again, I'll go back to that page 56, is where it shows the before and after, where you do see the rocks and they're gone. But what was more interesting was the picture that was shown to us yesterday as the rocks were back as of the day before. So I guess one of two things had to happen. Either the rocks were removed and put back, or the rocks were still there and were covered with sand. And as they brought up into the testimony yesterday, there's not enough sand in front of where the beach is to have the water wash that sand in.
Yeah.
So I mean, something, you know, at some point, you know, that became a rockless beach that, you know, you definitely walk on a lot better than you can before. So one of two things I feel had to happen. Either the rocks were removed or we had sand put over the top of them.
So can I chime in?
Are you saying that any sort of maintenance of the beach you would consider as beach construction?
Well, I mean, obviously, I don't say obviously, but the area appears to be, you know, cleaner and larger in the after picture than it does in the before. I mean, if I hadn't seen the picture yesterday with the rocks being back there, then I might have had a little bit harder time.
I don't disagree with you on those, but do you view this as beach construction?
If nothing else, it's beach maintenance.
Right.
And I believe in order to do beach maintenance, I believe it needs a permit, right?
Well, I think that doesn't really matter at this point because what was cited by Alex was section 15, which I just read, which is not specific to beach construction.
Yeah, can I say a couple things, David?
Of course, yeah, please.
Yeah. Yeah, I think unlike a lot of the other issues, like this is a little bit more of a it's not a binary issue. It's not like the tree was either cut down or was not cut down. You know, beaches are very dynamic things, and you can capture them at different points in time. There's not a great definition for a beach anyway, and it's something that has been brought up. I think that there's a little bit of a higher threshold here, and I tend to think that the argument's pretty compelling that beaches change, I haven't seen a very strong indication that it's changed so much to think that it was constructed or even really maintained for that matter. I mean, I know there's lots of things that can move sand, waves, ice, storms, you know, like they do change. And so I find it fairly compelling that this was not the construction of the beach, and that you know, I'm more in favor of interpreting this as that it was not a violation.
Yeah, I'm inclined to agree with Fred in that it's kind of confusing when you look at Alex's presentation. There's a significant difference between the before and the after, and then the more recent pictures that are part of the PDF. It looks like it's starting to return back to the before picture, but it's still, I don't believe, as rocky as what the original pictures in Alex's presentation show. So there's definitely something dynamic happening there. And I don't think it's just Mother Nature. I think that somebody's working that beach.
So I think we've got a division on the board here. So what I'm going to suggest is that we have a motion, and then once you know that motion passes or fails, I'm going to have the majority articulate their findings so that I can reflect the findings of the majority on this. So about a motion to grant the appeal in part and vacate violation 5.
So moved.
Okay, so everybody's clear. A yes vote is in favor of the appellants here.
To sort of reiterate, is that what you think, Attorney Wagner?
Sorry, I didn't catch the first part of what you said.
Sorry, are you looking for Greg and I to reiterate our points? at this
No, I'm
point?
looking actually, let's take a vote on this.
We need a second.
Yeah.
I seconded. You might not have
Okay.
heard it.
No, we didn't, David, or at least I did.
Okay, yep.
So let's take a roll call on this.
All those in favor of vacating, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Mullin, no.
Lockwood, no.
Okay, so we had 3-2 in favor of vacating that. So can I have the majority here articulate again the reasons for that? And this is what I'll include in the decision.
Explained it, Greg, so I'm have
You
you,
are-
if you don't
yeah,
mind.
I can
That was good.
feel free to supplement if you feel like I'm missing it, but I think our point of view is that the beaches are inherently dynamic. There's kind of not enough substantial evidence presented to indicate that a beach was constructed, and I think that's probably enough. I don't know if we need to add more, but I don't want to embellish it. But
No, I think not enough evidence that a beach was constructed, and 15.0 specifically is what was cited, and that requires beach construction. Therefore, there was no violation.
correct.
So that is sufficiently clear to me. So I will write that up. So I think we can move on from here.
So item 7.6 in the notice of violation, removal of vegetation less than 3 feet in height. All existing vegetation less than 3 feet in height, including shrubs and ground cover, has been removed within the 100 feet of the normal high water line of Sebago Lake for a majority of the lot's shorefront. Remove vegetation was stabilizing the segment of the shoreline and protecting water control. Shoreline zoning provisions, section 15, land use standards. Item Q, clearing or removal of vegetation activities other than for timber harvesting, section C, in order to protect water quality and wildlife habitat, existing vegetation under 3 feet in height and other ground cover, including leaf litter and forest duff layer, shall not be cut, covered, or removed, except to provide for a footpath or other permitted uses as described in section 15Q, paragraphs 2 and 2A above. Well, I would say, based on evidence provided, that there was vegetation less than 3 feet in height removed. And for clarity, Alex did indicate that his wording of all existing vegetation was not correct. It was not all, but that all was not specific, didn't have to be all to fall under this shoreline zoning provision.
Yeah, there's no, like, it's not like removing some would have been okay. That's my understanding. I also will add that I think that there was pictures of growth from, I guess, as recent as like this week. I think that I interpret that evidence provided by the appellant to just indicate that because the operations was stopped, it regrew and kind of the code enforcement did its job. I mean, you can cut down vegetation and it can regrow, but it doesn't mean you can cut it down. So I think that there was a teaser picture that the appellant provided. And I think that's how I interpret that, at least.
I agree with Greg.
Yeah, I would agree as well.
Any evidence that a permit was obtained? No permits.
Do we want to address the duplicative nature of 6 and 7 now, or we wait till we get to 7, or what's the right way? Because
you can address it now.
Because actually, this is one where I've asked, and I get to really have a convincing example of how this isn't 6 and 7 are duplicates. I don't think you can uniquely violate them. And I think even when I posed my question to Alex, the best example he gave is you could exceed the allowed, what you have permitted for, but that would just mean that you didn't have a permit for what you removed. And I kind of keep going around in circles of how you can uniquely violate these two. I know that in the kind of towns presentation, they say that they're unique, but if somebody can't articulate examples of how they're unique, such as canopy coverage versus points, those are unique to me. Erosion control versus moving a quantity of earth, those are unique to me, but this all just seems to be the same activity, and just kind of come out from two different directions. This is kind of where I'm at. I'm happy to discuss that, but the duplication of this one I actually find most compelling.
Just to be clear, Greg, I'll read violation 7, removal of vegetation less than 3 feet in height without a permit. All existing vegetation less than 3 feet in height, including shrubs and general ground cover, has been removed within 100 feet of the normal high water line of Sebago Lake for much of the lot's shorefront without a permit from the code enforcement officer, referencing shoreline zoning provisions, section 14, table of land uses, item number 5, clearing or removal of vegetation for activities other than timber harvesting. I will say, Greg, that sort of this new round of questioning and clarification, I'm more in line now with you on this one. I don't see how they can be. I recognize that they are two separate items in the ordinance, and I do understand how understanding of Alex saying that as they go through the ordinance and looking for violations, these are two separate sections that could be cited. But I would agree with you that how can you do one without the other? So ultimately, I do fall more, I'm seeing these more as duplicative, that you really can't have one without the other. So, but they are two separate items. So kind of, I guess I feel like I'm on the fence now, but you've brought me closer to your side. Tom, Fred, or Pete,
I guess for consistency, if you, what would be the difference? I'll ask Greg. If cutting down trees and cutting down trees without a permit, how is vegetation different than that?
Well, there's a certain, I mean, I'm not the code enforcement officer, so I'm not sure if my examples matter. When I asked Alex if there was, and I've asked him multiple times, if there was a good example, I feel like he would have readily put it forth. I can give you my best interpretation of the question you've asked, which would be, I think you can cut down trees and you can do it and you can maintain the points that you're required to maintain, and you can maintain the canopy coverage that you're required to maintain, but you might have still had to have a permit to cut that tree down because of its location. And therefore, the only thing you'd be in violation of is cutting down a tree. Now, you could cut down a lot of trees, violate the point system, not have a permit for those trees, and remove the canopy. And those are all kind of unique aspects, unique violations of what you did, which goes to the, I think, speak to the egregiousness of what act you did. In this particular case, I'm not sure that one's a modifier of the other. I feel like they're the same issue. That's kind of what I'm proposing.
That's a tough one. I mean, because you're looking at vegetation that's actually inside the riprap, which is right close to the water. So, I mean, it's obviously going to affect the runoff of possibly coming down over, the riprap. Plus, as you go up by the stairways, on the sides of that, that has been removed too. And, multiple areas. So, I mean, it was definitely removed, and I believe there's no proof of a permit anywhere.
So, yeah, Greg, I appreciate that you said the word qualifier there. I know under Alex's write-up, he's saying removal of vegetation less than 3 feet in height, and then removal of vegetation less than 3 feet in height without a permit. That's his write-up. The shoreline zoning provisions, though, for number 6, talks about clearing or removal of vegetation activities other than for timber harvesting. And then further section C talks about existing vegetation under 3 feet in height or other ground cover. Whereas the item referenced for permitting is item number 5, clearing or removal of vegetation for activities other than timber harvesting. So there is no qualifier there in regards to 3 feet in height. So there is the difference. So in Alex's write-up, his items reference 3 feet in height on both. However, the zoning or the ordinances one references specifically 3 feet in height, and the permitting one just references clearing of vegetation just in general. So there is the qualifier.
Sure, I think there's a qualifier, but I don't think you can uniquely violate one without the other. So it's a redundant qualifier. I can add removing green vegetation would also be a qualifier, perhaps, and that's not no one's that wouldn't make sense. And I think that we all know that the ordinances are fairly tricky, and we always try to interpret the best we can. But I do feel like this is being a little opportunistic in saying, hey, I can get you from both directions on essentially the same act. So I don't know. I mean, I'm not going to belabor the point. I think of that just sharing that's my thoughts on how I view these.
Anyone else?
I mean,
Go ahead, Fred.
I mean, I still feel that, there's, again, you're removing less than 3 feet, and you actually, looks like removing even more than 3 feet in height, stuff without a permit. And I believe that, the town was in writing issuing, both violations. And just looking at the pictures shows shows that. I mean, that's there to protect the land and to protect it, from eroding.
I don't think Greg and I are disagreeing that, it's either one, both are valid. They just appear potentially duplicative.
Can we get to a motion handling duplicate, no, whatever, the duplication? Word something to that and at least resolve whether it's one or two violations.
Makes sense.
Motion. Anybody want to try articulating a motion for
that? You do such a good job. Who would go after the?
So how about a motion to grant the appeal in part and consolidate violations 7 and 8 into a single violation of failing to obtain a permit to cut vegetation less than 3 feet tall.
Are we on?
I think it's violation 6 and 7, I think.
Oh, I'm sorry. Yeah, I'm reading from the prior decision where this issue was raised. So yes, revise my motion to read 6 and 7.
Seconded.
Okay, so just to be clear, a yes vote on this would, I guess we can sort of phrase it as like effectively vacating 6 and 7 and then modifying the CEO's notice of violation to read one single violation. A yes vote here would be in favor of the appellant and would have the effect of consolidating this violation, and then we would take a separate vote as to whether this single violation occurred. Okay.
So all those in favor, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, no.
Fred Miller, no.
Lockwood, yes.
Okay, so that carries 3-2. So essentially 6 and 7 are vacated and consolidated into a single violation. And I'll call that, I think it's fair for me to say that the violation here is, we're considering both of the statutory sites. So the table of uses as well as 15 QC. Okay, I'm seeing head nods. So now let's take a vote as to whether this new consolidated violation should be upheld. So the question here would be whether there was in fact cutting without a permit.
Yeah. Do we need to? I believe that we already articulated our points on that. Should we re?
Yeah, I don't need you to articulate again.
Okay. All right.
And a motion here. So
okay. I moved up uphold essentially the combined result of 6 and 7.
Okay.
So moved. Yeah, sorry, seconded. I'm sorry, all those in favor, David Murch, yes.
Greg Dean, yes.
Lockwood, yes.
Fred Mullen, no.
I hate to ask, could you reword that or repeat the motion? I'm not sure what we're talking the same subject anymore.
That's fair. That's fair.
I'm kind of the same way, but
if there's confusion, we should clarify. Okay. I'm sorry. I told you I shouldn't have tried to make a motion. Let's let the lawyer that we've.
I actually think you were clear, but let me repeat it. So the motion would be to deny the appeal as to this argument and uphold the combined violation 6 and 7. So
we're removing one of the violations that the town.
So that's already happened. So
right.
These have been consolidated. So
okay.
Now pretend we're looking at one motion that says the MCL violated 15 QC and 14 line 5.
Under one.
Right. So
under one violation.
Right. So a yes vote is to deny.
I understand now. I understand.
I thought both you and I, Fred, were maybe on the same page, confused.
Right. Yes.
Okay.
So can we just take a revote? Is that how we do it?
Yeah. So why don't we just consider that other motion rescinded and let's have a so moved on what I had just articulated.
So moved. So moved.
Okay. Second. Yeah. Roll call.
David Murch, yes. Favor.
Tom Hennessy, yes.
Lockwood, yes.
Fred Miller, yes.
Okay.
Get a vote for Greg.
Oh, I'm sorry. I must have been on mute. I would say yes. Greg Dean, yes. I apologize.
Okay. So next issue is violation 8. No, hold on.
That's correct.
Item 9, violation 8.
Well, this is the 9 and 8. Yeah.
So unpermitted shoreland stabilization, no permit. Stabilization of the shorefront was completed from the land without a permit from the planning board or code enforcement office, referring to shoreland zoning provisions, section 15, land use standards, section C, piers, dock, wharves, bridges, and other structures and uses extending above or below the normal high water line of a water body or within a wetland. Further, section 12, vegetation may be removed in excess of the standards of the standards in section 15Q of this ordinance in order to conduct shoreland stabilization of an eroding shoreline, provided that a permit is obtained from the planning board. Construction equipment must access the shoreline by barge when feasible as determined by the planning board. When necessary, the removal of trees and other vegetation to allow for construction equipment access to the stabilization site via land must be limited to no more than 12 feet in width. When the stabilization project is complete, the construction equipment access way must be restored. Revegetation must occur in accordance with section 15T.
Sorry, are you reading? Are we on? Sorry, I've lost the thread here. Are we on violation 8 or 9?
Violation 8, but they read the same.
Okay.
So I just have before we comment on this, can I ask a clarifying question? Because I was actually confused during the testimonies, and I think there was a procedural question that was brought up around whether or not 8 was being considered for appeal. And
yeah,
I know that we entertained evidence as it pertained to 8, and I think it was more of an omnibus approach to viewing everything under 8, or at least 8 and 9 together. But I don't know if 8 has actually been appealed. So can somebody just clarify whether or not it has been appealed? from a legal perspective.
So I think you're right to raise that point. So the board previously on a 4-1 motion allowed questions pertaining to violation 8. But I think you're right to draw a distinction that the motion there was pertaining to whether or not that line of question and that evidence should be allowed. So I think the board needs to make a determination now as to whether the argument that violation 8 should be vacated was raised.
So the way you've worded that, just to clarify a little bit more, that there's two things here. Is it in the appeal as it was written to the town? And then was there an argument made that it should be appealed in the line of questioning that was kind of made during this the session yesterday? So I think that they're different answers maybe, and I want to understand if it matters.
Yeah, I guess so. What I'm saying is, so yesterday it was about whether the line of questioning should be allowed. So I really viewed that as a evidentiary issue. And
okay.
I think I even advised you to allow that in. But that ruling that the board made, I don't think, in my opinion, it doesn't mean that the board concluded that the appellant in fact did raise violation 8. And so I think the board needs to make that determination. Should it consider the arguments pertaining to violation 8? So the town objected and said that, I think when made the arguments, I think I can fairly characterize here, was that it was not fairly raised. It was, there was an argument about duplication, but there was never an independent argument in the notice of violation pertaining to 8. So it would not be appropriate for the board to weigh in on violation 8. The appellant, on the other hand, argued, the standard here should be analogous to a pleading standard in litigation, and that is a very, very low burden. And so the town was on sufficient notice that violation 8 would be challenged and was effectively denied by management controls.
Well, I believe the appeal goes 6, 7, 9. I don't know if we can even address something that wasn't appealed, even though there was questioning surrounding it. It may come into consideration when we talk about perhaps duplication with violation 9. But unless I'm mistaken, I open to anybody else. I just kind of look at the appeal, and then I look at the town's kind of response, and I don't really see that it was really on the table for actually being appealed.
Yeah, and I would agree, Greg. And to clarify, this is specific to no permit. Unpermitted shoreland stabilization, specifically no permit. And I would agree. It wasn't in the written appeal to be addressed. So. It was helpful, as you said, in looking in combination of 8 and 9, but I don't see, there was no request to vacate 8 that I could see. So
do we even need to entertain, like there's no motion to make?
No, I don't need a motion. I just need a sense of the board. You can even take a vote if you want, but it's not going to be an emotion or a finding that I'm not going to. Basically, if the majority of the board decides that's not an issue we have to address, it's just not going to appear in your written decision, we'll move on. So why don't you just give me a show of hands, who thinks that we should move on and not consider arguments related to violation 8.
Yeah,
So I'm seeing four hands. So
I'll be okay with that.
okay, so I see unanimous on that point. So I suggest that we go right to violation 9, right?
Shoreline stabilization, no barge. Stabilization on the shorefront was completed from the land when it could have been completed from the barge, which the contractor Rob Durant owns. This is the exact same shoreline zoning provisions that I had previously indicated. Kind of specifically it. Let's see. Trying to find the barge part. So under section C12, it does say construction equipment must access the shoreline by barge when feasible as determined by the planning board. And it was indicated, during testimony that, barge work, Rob Durant did say that barge work was feasible, at least in terms of like a restoration project. Problem is it never made it to the planning board, which it was supposed to have. And the planning board's really the ones that determination. Unfortunately, they weren't able to make that determination, so it was never brought to them. I'm fine just to keep this one in place and not vacate it. It never was brought to the planning board, so never an actual determination of feasibility wasn't even able to be determined. However, you do have someone subsequently saying, Rob Durant, who owns the barge, saying that it would be feasible, at least for the reconstruction project at the time of year which they were doing it. So I just throw that out there.
Yeah, I tend to agree.
Right. I agree.
I agree.
I agree.
Okay, how about a motion to deny the appeal in part on the basis that violation 9 should be vacated and uphold violation 9. So motion to uphold violation 9.
So
moved.
Seconded.
All those in favor? David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Mello, yes.
Lockwood, yes.
Okay. So
Just a, okay, no, go ahead.
no, you go right ahead.
I do believe there was an argument made that we may have overlooked that we might want to address in the, even though we've skipped 8, there was an argument made that 9 was duplicate to 8, and I feel like that should at least be considered. So, because it's possible that we could still consolidate 8 and 9 and not address 8 in its specific instance. So
I agree with you. That's what I was trying to pull up was the notice of appeal. I think you did summarize that accurately.
So should we?
I guess it'd be a motion to consolidate those violations.
So yeah, so moved. I'll make that motion. Or do we need to discuss first?
So we can second it and then discuss it and then vote on it. So I'll go ahead and second it. So one was for no permit. The other one was for not using the barge. If I look at our ordinances, stabilization, looking at 8, stabilization of shorefront was completed but from the land without a permit from the planning board or code enforcement. Does talk about section 15C12, vegetation may be removed in excess of the standards of section 15Q of this ordinance in order to conduct shoreline stabilization of an eroding shoreline, provided that a permit is obtained from the planning board. And then the second sentence to that same section is construction equipment must access the shoreline by barge when feasible as determined by the planning board. So 2 separate items for the planning board. One, the feasibility of a barge use. The second is providing a permit for the stabilization of an eroding shoreline. So I do see these as 2 separate items, both requiring separate actions from the planning board. So I don't see them as one and the same or can be combined.
And fair to say that the same reasoning the board used, you would agree with the same reasoning that the board used when it dismissed unanimously this argument when it was brought up as to Fernwood applies here? Yeah. Got it. Any further discussion? I would call the vote.
Sorry. All those, I forget, what did we motion?
So this was actually a motion to, I guess, grant the appeal and consolidate these. So a yes vote would be in favor of the applicant, a no vote would be in favor of the town.
So I will say David Marsh voting no.
Greg Dean, no.
Tom Hennessy, no.
Pete Lockwood, no.
Fred Miller, no.
Okay.
Unpermitted tree removal within 100 feet of Sebago Lake. Multiple trees have been removed within 100 feet of the normal high water line of Sebago Lake, creating an illegal opening in excess of 250 square feet. While the ordinance does allow for normal hazard removal of hazard trees as defined, this is only allowed after inspection by the code enforcement officer as described in shoreline zoning provisions. Section 15R1, hazard trees in the shoreline zone may be removed without a permit after consultation with the CEO if the following requirements are met. Requirement A, within the shoreline buffer, if the removal of the hazard tree results in cleared opening in the tree canopy greater than 250 square feet, replacement with native tree species is required. Unless there is new tree growth already present, new tree growth must be near as practical to where the hazard was removed and must be at least 2 inches in diameter, measured at 4 1/2 feet above the ground level. If new growth is not present, then replacement trees shall consist of native species and be at least 4 feet in height, shall be no less than 2 inches in diameter. Stumps may not be removed. Provisions, section 15, land use standards, Q, clearing or removal of vegetation or activities other than timber harvesting. Number 2, except in areas described in paragraph 1 above within a strip of land extending 100 square feet, horizontal distance inland from the normal high water line of a great pond or river flowing to a great pond or within a strip extending 100 feet, horizontal distance from any other water body, tributary stream, or upland edge of a wetland or buffer. A buffer strip of vegetation will be preserved as follows. There shall be no cleared opening greater than 250 feet in the forest canopy or existing woody vegetation if a forested canopy is not present, as measured from the outer limits of the tree or shrub crown. However, a footpath not to exceed 6 feet in width as measured between the tree trunks and or shrub stems is allowed for accessing the shoreline provided that a cleared line of sight to the water through the buffer strip is not created. So
just to be clear here, we're talking about violations 10, 11, and 12.
number 10,
Yeah, that's 10.
Okay, so let me just say from how the appeal was framed and addressed, these were sort of treated collectively. So we could take them one by one if you'd like.
Yeah, I think so it's just my understanding of the appeal is that there's was definitely an argument made individually as it pertained to the individual ordinances, and then there was an argument made that they were duplicative. I'm not sure procedurally what we should do, but at least they seem to address different arguments made by the appellant, and then kind of one argument made that they're duplicates.
All right, so why don't we address the duplication argument first? So I'd suggest a motion to consolidate 10, 11, and 12.
So moved.
I'll go ahead second. So I know 10, 11, and 12 all are referencing separate sections of the land of the shoreline zoning provisions. Unpermitted tree removal with 100 feet of Sebago Lake. And then vegetation removal in excess of what is allowed by the point system. That's number 11. And number 12 is just removal of vegetation without a permit.
Just a clarification is the same. So 12 is the same ordinance as 7 that's being cited.
That's it. Yeah. That.
Yeah. I mean, I think 10 and 11 are pretty unique. I'm not convinced that 12 is a new violation. Yeah.
So let me ask Attorney Wagner if.
Hey, David, we can't really hear you, or at least I can't.
Yeah, sorry, something's going on here. I have a question for Attorney Wagner. I mean, Greg and I, and perhaps the others, picked up on the fact that 7 and 12 are referencing the same ordinance item, but it was not brought up in the actual appeal. So do we address that any further, or? I mean, can we come up with stuff on our own like this? I'm guessing, I don't know if we can or can't.
Yeah, you can do this on your own, though. Actually, I do think during arguments that Attorney Rachel made this point, and I'm seeing her nodding her head. Yeah, so I do think it's raised, and even if it wasn't, it's fair game.
That's why I brought it up as well. I have it in my notes as something that was brought up. So.
Yeah. Well, just in general, I would think 12 should be. I don't know. Do we say we roll 12 into what was it, 6 and 7?
Yeah, I mean that would be what I would propose. I mean we've already kind of consolidated 6 and 7. So whatever the. It's just gonna see how you can do 6, how you can do 6 or 7 and 12, and that doesn't.
Yeah. That would be my thought.
So we could, maybe Tom could withdraw his motion, and then someone make a motion to, how about vacate 12 on the basis that it's duplicative of 7?
I'm in favor of doing that.
I'll need to officially say some words to say I remove or vacate or withdraw my motion. You have to do that.
I withdraw my motion.
I will make a motion to vacate violation 12 as it is duplicative of item violation 7, which was rolled into 6 and 7.
Ask a question, Dave.
Yeah.
On 6 and 7, I believe I voted no on that, right?
The consolidation you did, yes. Yep. But then they were upheld. It was upheld.
Right.
I think you know.
Right.
Yeah.
Yeah.
And so what now we're trying to add into there that the permit will be removed from this violation, and we'll just attach it to 6 and 7.
Well, what it would do is vacate notice violation 12. So it would grant the appeal in part and vacate notice of violation 12 based on the reasoning that this is duplicative of violation 6/7.
So we're not really, we're just basically taking 12 away and not really adding anything, because what you're saying, they've already been
yeah, it functionally it's the same as, I know we've done it before as a consolidation motion, but functionally it's the same thing in my opinion. So I think here, by voting for this, you'd be voting for the appellant's position and vacating number 12.
maybe that's based more on the trees.
This particular motion would be based on the idea that it's duplicative.
With the vegetation too.
With number 7, right?
It's a reference spread to the exact same shoreline zoning provision item, and we address that exact same item under 6/7.
So the only difference I see between the two, though, is one is no permit for removal of vegetation and one is no permit for removal of trees. Those still considered the same?
Well, the shoreline, the table of land uses is clearing or removal of vegetation for activities other than timber harvesting. So clearly, if they include timber harvesting, the vegetation could include trees, or vegetation is 3 feet or less.
In 6 and 7, there was none for no permit for trees, correct?
Well, 6 and 7 pertain to cutting a vegetation less than
Correct.
3. Right.
And this one pertains to cutting a tree without a permit.
It pertains to vegetation generally, so that I think what you're getting at is that would include both vegetation and
the trees that were cut in that area.
or at least I'll let 12 speak for itself, which is vegetation has been removed.
So it's just saying that the vegetation is removed, but it was not for timber harvesting. So in other words, they didn't remove it because of tree removal.
Well, I think all we're saying, maybe to help clarify, is that I was proposing that 12 and 7 are identical, and 7 and 6 have already been combined. So it's almost by definition redundant to address 12 at this point. And that was that was what I was proposing, and that we just vacate 12 and address 10 and 11 as unique violations that need to be addressed.
I think what you what you can potentially get hung up on is the labeling that Alex used. I mean, 7 says removal of vegetation less than 3 feet in height without a permit. And then 12 says removal of vegetation without a permit, but they both refer back to the exact same shoreline zoning provision, which is clearing or removal of vegetation for activities other than timber harvesting. So when you refer back to that particular ordinance item, there is no qualifier of height there. This is simply removal of vegetation.
Which was different than what Alex has, right?
In terms of his labeling, 12 and 7 are labeled different, but they refer back to the exact same ordinance item, and that ordinance item has no height qualifier.
So just to be clear, if we vacate violation 12 because of whatever reasoning, it's saying that that it's the only one that deals with permits, right? So
I think 6, 10, and 11 all require permits.
yeah, but does 11 say permit, or does it say it they took more trees than they should have?
See what you're saying.
I guess what I'm saying is 10, 11, and 12 say 3 different things. 3 individual things. They're not. So at the moment, I'm not in favor of consolidating.
Are you thinking that we're consolidating 10, 11, and 12, Tom?
No, I think what Tom's saying is that if you were to take out 12, then none of the other violations would cover the removal of trees without a permit. Is that
exactly what I'm saying?
Right.
Yes.
Exactly.
I agree.
So I don't know that we need to have a motion, or we just proceed with 10, 11, and 12.
Well, we do have a motion on the table to vacate 12 on the basis that it's duplicative of 7/6. So I think we do need to have a vote on that. And then I have clear direction depending on which way that vote goes as to what the findings are. So.
Had that been seconded?
I'll second it.
I believe it has, yeah.
So I know David made the motion after Tom withdrew his, but I did not hear a second on that.
Well, Tom just seconded now, so.
Yes, exactly. Thank you.
Let's move to voting.
No, I appreciate you keeping a clear record. I rely on your minutes greatly. So yeah, unless there's any further discussion, why don't we have a vote on this?
So the motion was to vacate. So David Merchant in favor of vacating.
Greg Dean in favor.
Tom Hennessy, no.
Fred Miller, no.
Pete Lockwood, no.
Okay, so the motion fails. So I think what that brings us back to is let's start with 10. Oh, actually, sorry. Before we do that, I do have a direct message here from Attorney Wilson, and he's raising what I think is a very fair point, and I feel his pain having been in his shoes before. Which is so his message was, am I correct in suspecting our appeal won't be reached tonight? Well, rather than read his message, I'll just turn it over to Attorney Wilson. Do you want to just, I think he has some concerns about if his item will be reached or not tonight. And it's just his client's having to pay for his time. So if we can try to provide some idea of if we think we're getting to that item or not.
And no rush, honestly, and I didn't mean to, I didn't want to delay where the board was going in this case. It's just, I noticed that I think there's the rest of this homeowners and then followed up by the appeal by the construction company. And I didn't know how large that secondary part was. And if there if there was any hint of reaching us tonight, I'm happy to stick around. I just, I didn't want to bill my client, obviously, if they're, you know, for sitting around if I didn't have to. But I'm happy to wait if there's, if the board does think we're going to get reached tonight.
Yeah, so our bylaws state that we don't take up any new items after 10 p.m. So if we are able to complete this particular topic, which we're currently on, we could potentially move on to our next item, but unfortunately you're the item after that. And I know that we will not be able to complete our next item before 10 p.m.
No, understood, and that's what I expected. I appreciate you taking me out of turn just to hear this. I would say this is our second here, and again, no rush. I think that our issue, as far as I'm concerned, and I don't know if you even glanced at it yet, and Alice can back this up, there's no dispute about what happened. I don't think that the recitation and argument would be overly long. I don't know if it makes, if it would help you all to maybe set it specially or hear it at the beginning of a meeting at one point to help move sort of the docket forward. Whatever works for you all, I'm happy to do. Just let me know the best way to sort of squeeze this in and maybe get something off your plate. But again, it doesn't have to be today, obviously. My clients are very patient.
Understood. I know Sandy helps us to formulate the agendas, so I will.
Greg, we're having a hard time hearing you.
Can you hear me?
No.
Hey, David, try this. Get close to your screen and talk. Now try. Oh, now it's not working.
I heard you. I think you had said that Sandy has a lot of input on how to set the agendas, and I'm gonna, like I said, my clients are really patient, and they're gonna go with whatever you guys think works. I just don't. I only feel badly because I've been here a couple of times on their dime, and I also just want to make sure it's convenient for you. So whatever works, Sandy. You know, just email me however you want to fit me in best, and we'll make it work. But I appreciate you letting me go a little early this evening. And if for any reason you reach us, Sandy, I believe, has my cell phone, and feel free to reach out.
Will do. Thank you.
Thank you, everyone.
Good night.
So, violation 10.
Anybody hear me?
Yep.
Okay. So if I cut out terribly, Greg, I'm just going to ask Greg Dean, I'm going to ask you to sort of take over, and potentially if it gets super bad, I'll work towards calling in. Okay. So anyways, item 10, which we have just read.
Yep.
Unpermitted tree removal within 100 feet of Sebago Lake.
We've lost you, Greg.
Yeah, so Greg, do you think you can take over on this one?
I mean, David.
Yeah, sure. He just read 10, right? So
Yeah, I don't think we need to reread it. Again, I suggest, for example, we could take a look at I know you've been following along with the proposed findings of fact and law, and we could use that as a guide for starting the discussion, or however you want to lead it.
yeah, so I mean, this is basically for the let's see, the excess of 250 square feet. I think, where are we procedurally? Just is it we want to have a discussion?
Yeah, let's have a discussion first. We get a sense of where the board's at, you know, or you could, you know, propose a motion and have a second and have discussion based off of that.
Sure. I mean, I'll propose a motion to uphold violation 10 on the basis that, well, I don't know if I need to include my basis in the motion. We can discuss it after, but I'd propose.
I'll second that.
Can you guys hear me now?
Yeah.
Okay. The dogs are all taken care of, so I'm not gonna worry about dogs barking.
Man, what'd you do to them?
Well, my wife came home, she took care of them.
Wasn't worth it. Did you want to? You can take over.
No,
again.
why don't you continue this particular
Yeah.
item, Greg?
So yeah, I think we had Fred second it, and so now we'll do a roll call vote.
Why don't you do discussion on this? Yeah.
Oh yeah, discussion. I mean, I'll start the discussion and then I'd like to hear feedback from fellow members. But yeah, I find the evidence pretty substantial in towards of that the threshold has been covered based off of the visual evidence. In terms of the issues raised around the potential inaccuracies, I think they fall well outside of a tolerance that would move it underneath the threshold of 250 square feet. One section alone was estimated to be 1,500 square feet. One tree was 320 square feet. I think it's pretty compelling evidence brought forth by the town, and my proposal would be to uphold 10 for those reasons.
I would agree.
I agree with you too, Greg. I know there's been a lot of talk and discussion about, how this was measured and whatnot. And, how accurate that was. Again, I also remember that Alex said that, the appeal wasn't written off and the violation wasn't written off in the day that he used his tool, but, they had other measurements. But again, just from the visual of the pictures that we were looking at, and what Alex did show us in that last presentation when he was being asked questions, it did show that, that one tree was, definitely over the 250 foot violation. So I feel that they've met their burden to prove that it's over the 250 feet.
I would agree.
I agree.
Pete, anything to add?
I agree.
Okay, so we'll do a roll call vote. Greg Dean, yes.
David Murch, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Lockwood, yes.
Okay. Unanimous on that. Violation 10 is upheld. So I will leave it all to you to tackle the next one. I need to go run and find a charger for my laptop. If my video goes blank, I will be calling in.
Okay. David, you want to take over or you want me to keep reading 11?
Yeah, why don't you go ahead, Greg?
Sure. So the next item would be violation 11. This is for the removal of vegetation in excess of what is allowed by the point system. I'm not going to read the actual 15Q2B on page 45. I would like to make a motion to uphold violation 12. Does anybody want to second that?
Second that.
So we'll have a discussion. For reasons similar to 11, I found the visual evidence compelling. I did not find the issues brought up with measurement to indicate that there were areas that all areas satisfied the point system of the numerous areas that had trees removed from. So for that reasons, I would recommend upholding violation 12.
I just want to make sure you said
sorry,
for
11.
violation of 11, you meant violation 10, right?
No, I'm on 11 now. Sorry, I
Right, but
misspoke
when
and
you
said.
thought I said for the same reasons of violation 11. Maybe I misunderstood.
Yeah, sorry. Yeah. For the same reasons with of 10, the visual evidence provided by the town, and I did not find the argument that the measuring methodology was inadequate enough to bring below the threshold of the requirement, the point requirement.
Correct. And I agree in the same way for the same reasons that I said for violation 10.
Tom, Pete, David?
I agree. Ready to vote.
Yep.
I agree.
Okay, so I think the next thing we'll do is a roll call vote. Greg Dean, yes.
David Murch, yes.
Tom Hennessy, yes.
Fred Miller, yes.
Pete Lockwood, yes.
So that passes unanimously. So violation 11 is upheld. The next item would be violation 12. This is for violating the ordinance prohibiting the removal of vegetation without a permit. This is the shoreline zoning section 14, line 5 on page 13. I guess I'll make a motion to uphold 12 as well.
Seconded.
Discussion. I have a potential concern around my thinking that it's duplicative, but that's not really it's not really what we're voting on right now. So I mean, the facts seem to indicate that in isolation this ordinance was violated. However, I do feel like it's duplicative, so I'm not sure.
So I think I can help you out here. I think you thinking that it's duplicative is a valid reason to vote to vacate it.
Okay. Okay. So then, for reasons I mentioned when we addressed 12, consolidation of 12 with violation 7, I would recommend vacating 12. Anybody else?
Yeah, I'm 100% behind you on that one. I see this as no difference and recommend it be vacated as well.
So you have both be no votes on this.
Yeah, I'm gonna go back on what we talked about when we were having a discussion that, there were trees being removed with no permit. And, if we remove this, then they will remove trees that they were not authorized to remove. So I feel that, that they did work without a permit and that they should have filed for a permit for the trees and vegetation.
Well, there would have been only one, but it would have been only one permit because it's, well, I mean,
no permit for the trees now. So if we vacate this, then there's no charge to them for the trees.
no, but
They remove trees.
the ordinance says you get a permit for clearing or removal of vegetation for activities other than timber harvesting. So it doesn't matter if it's vegetation 3 feet or less or trees. It's the same overall category.
Just also to point out, Fred, I understand your comment. I just want to clarify that what we're not considering is whether or not there's the fines associated with this. So I think like whether or not 12 results in a no fine or a large fine, or it's kind of not in consideration for whether.
I'm not basing on the fine. I'm basing on the work that was done.
Okay.
I mean, it's like you build a house and you're not supposed to. I mean, it's not what you're going to charge them for. It's just the work was done.
Okay. Yep.
I'm in full agreement with Fred. No permit for cutting down a lot of trees. And it already we showed that it violated the canopy and it violated the points count. So I'm right behind Fred.
And I agree. I see it as two separate things as well.
Okay.
Did sort of majority here that believes the violation should be upheld. Can I ask you to weigh in on whether any of the evidence pertaining to the means of measuring the tree canopy and the accuracy of that, how you address that?
What and when Alex was having questions answered to him, And when he brought up the grass, and he actually used that area, showing it that just that one tree alone, you know, was more than that. Plus they took trees from the other side and going back towards the porch area of the house. I mean, that vegetation was all removed.
Okay, so you found Alex's testimony that
It was, I felt that he had enough evidence and his measurements were credible enough for me to believe that his measurements were correct.
Pete and Tom, do you agree with that?
I fully agree with Fred. It's the measurements, no matter what accuracy you wanted to throw in at this thing, we're grossly over the limit.
Right, and I agree with that.
Okay, so I think we're ready for a roll call.
Okay, so roll call vote. Greg Dean, no.
David Murch, no.
Can you repeat the motion? Because I think we had two different motions, one to upheld and one to vacate.
So this is a motion to deny the appeal in part and uphold violation 12.
So we're going to keep the violation.
Right, so a yes
vote would keep it.
Yes vote is in favor of the town, no vote is in favor of the appellant.
I vote yes.
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 Okay, so that carries 3-2.
Yeah.
Okay.
So can I ask a question of Attorney Rachin? Did we miss any of your duplication arguments?
I don't believe you missed them. I just.
I know you don't like them.
Sorry. Yeah, no, you did not miss them. Thanks for asking. I appreciate it.
Does anybody on the board feel that there are any other arguments that need to be addressed? Okay, then I would entertain.
Actually, let me do clarify one thing. I did want to, just for the record, specify that if you'll recall, one of the arguments is that violation 8 would have subsumed all of many of those many of the alleged violations, like tree removal, earth filling, what else? Tree removal, the removal of, or earth filling and moving of 10 cubic yards. So basically the argument was 8, had they gotten that permit under 8, that all of those other things would have been subsumed. So I want to make sure that that's also addressed.
Okay. So is that essentially, should the board vacate 8 on the basis that it's duplicative?
Actually, no, it's the converse. That should they basically strike all of those others that I had mentioned, because 8 would have subsumed those had they gotten their shoreline permit. That's what I was arguing, and that argument has certainly been made.
Right, but hasn't the board here? The board has determined that 8 was not challenged. So if
on the substance, yes, but certainly not on the dupe. And I think I heard many of the board members say that I think even Attorney Wyckoff agreed that yes, on the substance of the on the substance of whether or not violation 8 was appealed on the substance, that was not preserved. Of course, I don't agree with that, but that was the finding. But I think I heard folks, and maybe I may have misheard, but I thought that it was a very separate and distinct issue as to whether the duplication of 8 was also on the table. That was a very different thing. The substance of 8, whether or not that was substantively discussed or raised, but not the duplication. I think it's very clear if you look at the appeal itself that 8, its duplicative nature was raised.
So can I ask, And I'll let, sorry, the other attorneys weigh in, but how about Attorney Rich, could you suggest a motion for the board then to help frame the discussion on this?
Sure. Get my notes. If you would just, can you bear with me one sec?
Yep.
Okay. So as I had argued last night that, and I'm just going to frame it up and then I'll try to articulate a motion if I can. All right. So we talked about how had the applicant sought and received a stabilization permit, which was the violation under 8, it would have covered many of the other purportedly single violations violations 1 and 2, which were the earth moving and filling without a permit. Violation 4, which is the expansion of the shoreline. Violation 5, beach construction. Violation 6 and 7, which is removal of vegetation and removal of vegetation without permit. 9, use of the barge, and 10 through 12. So what I'm saying is that the motion would be to strike violations 1, 2, 4, 5, 6, 7, 9, 10, 11, and 12 because they were subsumed under violation number 8. I hope that, I know it's getting late. I hope that makes sense.
Nope, I follow that. So the motion is to strike 1, 2, 4, 5, 6, 7, 9, 10, and 11 on the basis, and 12 on the basis that those would be subsumed in violation 8. So I want to give Attorney Wyckoff a chance to weigh in on this, if he wants to.
Yeah, I do. I mean, I'll be very quick and concise. The only issue for appeal that was raised relating to violation 8 was that it was the same violation as violation 9. Period. That's it. That the other violations are subsumed within it wasn't raised in the application for an appeal.
Okay. So board, someone want to say a so moved Attorney Rachen's motion?
Just a quick question, if before we make a motion, or we can make a motion and then vote, I guess. But I'm not sure. I mean, we did vote on whether 8 and 9 were duplicative. So if we were to make the motion as you proposed, it's kind of. I'm not like. Do you still want us to do that? Like, given that
I want to put it up for a motion just so that I'm clear. You know, I think we should reflect this discussion here, but I get what you're getting at. Is that we've already effectively decided this issue. So when I make my decision, I can make that part clear. But let's just cue that motion.
Okay, so I'll move as Attorney Rachen had suggested to vacate. I guess all 3 and 8 as they're subsumed by 8. I think it's a fair.
It's to motion to strike 1, 2, 4, 5, 6, 7, 9, 10, 11, and 12 as being duplicative of 8.
Okay, so moved.
Seconded.
Any further discussion? All right, roll call on that.
Greg Dean, no.
David Birch, no.
Tom Hennessy, no.
Fred Mello, no.
Lockwood, no.
Okay. So I think that addresses everything. Seeing nobody disagreeing, so I would suggest, as we have before, that everything that we've taken is a sort of tentative vote, and that you make a motion to instruct me to prepare a written decision for the board to consider at its next regularly scheduled meeting.
So moved.
Seconded.
All those in favor, David Murch, yes.
Greg Dean, yes.
Tom Hennessy, yes.
Fred Mello, yes.
Lockwood, yes.
Okay. Not gonna lie, I'm a little bit disappointed to see that it's 9:56. and not 10 o'clock, but I'll defer it to the chair as to whether we want to proceed to the next matter on the agenda.
Yeah, and I'll bring it to my board members as it's just as important for them. So our bylaws say we do not take up any new items of business after 10 p.m. We're 5 minutes before that, so we do have the ability to take on a new item. I just need to know how you guys feel about that.
I'm strongly opposed to taking the next item up.
I am in full agreement with no.
I agree with that.
I'm okay with that.
Yeah, I would, given that this is our second night, I'm a little fried. And I'd rather be able to give this next appeal better attention than what I believe I can.
Mr. Chair, if I may just interject or argue
Of
against
course.
that.
Yep, no, go ahead.
All right. So I would just say, and potentially maybe the board would consider a cap of 10:45 or 11. I just hate the idea of having to come back and do this yet again. We're really close to resolving this or getting these done. These violations are identical, right? They are carbon copy. I participated in the presentation and consideration of the evidence on the last. Quite frankly, I think were the board to rule differently than it just did on substantially all of these, that would be more questionable, right? Than significant changes, right? Than to this. So I don't foresee making a lot of argument. I don't foresee spending a lot of time with it. There are a few points that I think I need to make, but primarily it's going to relate to who actually did the work as it relates to the tree removal on 10, 11, and 12. And so I don't know what Attorney Wyckoff's position, or if you're even just going to say, "No, Braun, we're packing it in." But I just hate the idea of having to come back and doing this yet again.
Yeah, well, I think all parties need to have a voice in this. So Attorney Wyckoff, what is your thoughts?
I'm not in favor of starting it if we can't finish it. But I mean, I deferred to the board. I mean, I heard you say that. I mean, it's your call. I heard you say you don't feel fresh, and that it's your call.
Understood. I guess I'll put it out there one more time to the board members, given what we've heard. Again, what are your final thoughts on this?
I still think that we should stop, because I really don't think even 45 minutes or an hour that we would get through this, and do a good job of doing what we're here to do.
Yeah, I mean, we're at this point less than 120 seconds, but from a statutory requirement to vote to do it, I think we're just kind of. I mean, can I propose that we take a 2-minute bathroom break and then we can just vote on it? I think you're kind of threading the needle, to be honest.
I gotcha.
No one wants to come back and do it, but I feel like that's the best work we can do would be to come back and do it with a fresh, back rather than try to extend it from back-to-back nights.
Yeah, I kind of agree with that. I would, I hear what you're saying, Attorney Braun, but I want to give you and the people that you're representing our best, no matter what. So I'm not convinced we can give you our best tonight. So I will make a motion to table administrative appeal re-notice violation issue 310/2022 for applicant Gregory P. Braun on behalf of Big Lake Marine LLC. Robert Durant, member and manager, location 28 Whitetail Lane. Do I have a second on that?
I'll second that.
All those in favor of tabling, David Murch, yes.
I'm going to say yes.
Peter Lockwood, yes.
Okay, so we will look for next time.
I blame Jeff Wilson.
He did kind of get you.
Yeah, right. Disclosure, he's my former law partner. So I say that with, friendly thoughts. And I've already shared threats towards him via text. But are we going to do this just at the next regularly scheduled hearing date then?
That's what I'm looking at, unless I hear something different from the town or the fellow board members. Our next one's October 25th.
So the attorneys could conference again, and I can try to see if we can propose something. Of course, last time we did that, the best we got was this double header in September. So
yeah, I will say that I'm in as much as it matters. I know that there's a lot of schedules involved, but I would be in favor in trying to do it sooner, just to move the process along. But that's, for whatever that's worth, that's mine.
Yeah, and I have no issue. I agree with Greg. I wouldn't mind if we can attack,
Okay. While I have the board here, do you mind? Is there any dates in the next couple of weeks that don't work for the board members? I'll deal with the attorneys afterwards, because our schedules are obnoxious, as I'm sure all of yours are. But it's easier if I can get the board to weigh in now rather than chase you all down.
Yeah, October 25th is my 49th wedding anniversary.
Okay, we're crossing that off.
That's the normal meeting.
That's the regular meeting.
All right. You're clear either way.
I'm done, yeah. Extra roses that day.
Congratulations, by the way.
Thanks.
Yeah. I have
Greg.
I'm free whenever you guys need me.
For me, David Murch, Thursday evenings are any Thursday evening I am unavailable. But outside of that, I also have floating holiday on the 10th for Columbus Day. But outside of that,
I have various preferences, but nothing's a hard no. And so I would sort of defer to everybody's schedule, and if there's an option, I'll try to take a preference.
And the thing that everyone needs to remember is what dates you can give me that may work. I still have to make sure that the broadcast is available.
Yep, understood.
I'm out of town until after October 11th.
Okay, so between now and October 11th is no good for you?
Correct.
Okay.
This is Tom Hennessy. I may be unavailable for most of October, depending on what the hurricane does in Florida.
Okay, so do you think you could get back to me as soon as you have an idea if there's anything, if you have any availability?
I'll should be able to give you an update within a few days.
Okay, thank you. Okay, so for now, it's tabled to the next regular meeting, but I will confer with the other attorneys and Sandy and Chairman Murch to see if we can come up with a special meeting in the interim, which would also save Mr. Wilson.
sounds good. Okay, so Greg Dean, thank you very much for filling in as needed, and I will make a motion to adjourn.
Seconded.
All those in favor, David Murch, yes.
Greg Dean, yes.
I'm gonna say yes.
Ed Miller, yes.
Be Lockwood, yes.
All right, thank you, everyone, and good night.
Good night.
Thank you for your time.
You're welcome.
Good evening. I'm going to call to order the Comprehensive Plan Update Committee for October 5th, 2022. First order of business is to approve the minutes of the previous meeting. Can I ask, are there any corrections or additions? Seeing none, I'll take a motion to approve.
So moved.
It's been moved and seconded. Any discussion on the meeting minutes? No? All in favor of approval? Opposed?
I have to
You
abstain.
abstain, you weren't,
Yep.
yes.
I wasn't here.
Yeah, okay. And just for the record, did we get Brad?
No, he seems to have stepped away.
Okay, all right. So, old business is 3 on the agenda, review of the Comprehensive Plan Committee top 3 items of importance. And just to refresh everyone's memory, at the last meeting, what we did is brought a list of what we consider to be the top 3 questions or issues that we felt existed personally on as far as the update on the comprehensive plan was concerned. And I think, if I'm not mistaken, that was also going to be used primarily to give us some idea of forming quite a questionnaire, citizen questionnaire, a short one, to try and hit the November elections. And while it seemed like at the time there was plenty of time to do that, I think that that's something that we have to determine today if we're going to actually make it happen. So based on that, I'll just open it up for discussion.
I don't know if you can hear me or not, but I'm not hearing any audio at all.
Okay.
Okay, Sean, do you know why Brad on Zoom wouldn't be hearing audio?
No, but I'm going to look into it right now.
Okay. Brad, can you hear me at all?
Hi there. I can hear you.
Okay, Tom can hear.
Okay, you can. Can you hear anyone at the meeting?
If I speak, Tom, can you hear
Okay,
me?
we're all muted.
Okay.
There you go. There's one.
I can hear you. Okay.
You're at home though, right?
I am.
Yeah. I can't see anything of the meeting.
No, you won't
I
be
can't
able.
hear anything of it.
You won't be able to see anything.
Maybe you
He's
should
not hearing.
turn up his
Can you
computer
guys
possibly.
see the meeting at all?
No. No, you won't be able to see it.
If they're getting
there we
audio, that would suggest that it's going out, right?
Okay, if
Can
I
they hear you now?
unmute me, does that get, can you now? No, that's gonna cause feedback.
And just to, if you would, this is Brad McCurtain. We just now came into the meeting. We've been waiting since before 6:30, so I don't know what's gone on here. But can you, if anything's been voted upon, can you re-vote it or?
Sure. Well, Brad, what we did so far is just approve the minutes of the last meeting. I don't believe we got your vote on that.
Yeah, I actually had a question on the minutes, so.
Okay. So I would move to basically reopen minutes so Brad can have his say. Okay, Brad, if you just tell us what your additions or corrections are.
Well, it's a question on the minutes themselves. I didn't see in the minutes any reference to, I think it was Kayla who brought up about doodling. And instead I saw in there that that Sue was waiting for all of us to get back to her with dates on the trip on the lake. And I just was really confused by that because I thought that Kayla said, hey, I'll send out a doodle to everybody. And it was either on today's meeting, which I didn't get, or on that, which I didn't get either. So I'm just trying to figure out what I missed in the minutes or the meeting that didn't show up in the minutes. So can someone clarify that?
I think we mentioned maybe doodle, but we settled on everybody contacting Sue since it was such a short turnaround, or we expected it to be a short turnaround, with our available times, and then she would determine if that worked. But I think we were unable to get enough responses, and then I think the weather's turned.
Well, I have another two other dates now but they're probably a last ditch for this fall, I would think, because it's going to get a bit nippy.
Okay, so getting back to the minutes, as far as the clarification, do you have some addition you'd like to have, Brad, admitted to the minutes, and then we can arrange that, and then we can vote it?
I don't know how to put the addition in. I mean, I heard doodle, and I was pretty sure Kayla said, I will send out a doodle, as opposed to maybe we can send out a doodle. It's not a big thing, except that, you know, when I brought it up, and I think someone else brought it up here also, that we were expecting doodles, and then the word was, well, we were waiting for everybody to get back, and then Sue, you know, I'm more on procedures than I am on the minutes, but if you could play back those minutes at some point and see what was said, it certainly would be clarification, and just as a going forward, try to keep this in frame it in a positive sense. Sue, if there's something where we're supposed to get back to you, if you could send that out, because I sure.
Sure, but Brad, if I could just.
I sure didn't. Yeah.
If I could interject it, I think the understanding at the first meeting, and my understanding of the town meetings basically is, it's actually the video that is the formal record of the meeting. And therefore, the minutes that I've seen primarily are relatively brief. Because it's just a general outline of what transpired at the meeting. The official minutes that we're really voting on is the electronic record. Is that correct?
Yes.
Yeah, okay.
Yeah, the minutes are a guideline, so if I have to go back and
Brad,
find
if you don't want to offer a change to the minutes, then I guess we can let the vote stand, and you have the option to add that vote. So I'll recall that vote. So. Are there any other additions or omissions on the minutes? Seeing none, I'd ask all in favor of approving the minutes as written, raise your hand. Okay. Those the noes, one, and one
opposed, because I think that was critical and should have been in the minutes.
I understand, and now they will be. And then we have one abstention. And that's because Greg wasn't here at the last meeting.
Right.
Correct?
Yes.
So I think, you know, for the purposes of process, we did everything right. Okay. So under old business, review of the comprehensive plan's top 3 items. As I started to say, we did discuss it at the last meeting and offered our 3. We made a listing of those. And so I'd open the board up to discussion on those 3, or on the discussion regarding the 3 most important to each individual on the board. Just not to editorialize, but basically my sense with this is it'll give us a good sense after looking at what we selected as a board, how that mirrors, let's say, a brief survey at town meeting, so we can get a sense very quickly, you know, are we on board with at least the individuals that are willing to stop and fill out a survey or put a sticker on a board for us? So that would help to validate it. But I'd open this up to discussion on those items of most importance. I can tell you I'm kind of a numbers guy, so yeah. I kind of went through and probably we have at one point and kind of looked at all of the answers, including those from the municipal side. I included in it. And this is what I got. The number 1 was to preserve natural resources and water quality. Surprise, surprise. And that represented 8 responses out of the 12, and that was 66%. That was tied with town services, as far as also having 8 out of the 13 votes and the 12 votes, and that was also 66% of our opinions. Housing was, there were 7 individuals that mentioned it specifically. That was 58%. Land use, there were 4 individuals that mentioned it specifically. That was 33%. that was tied with transportation, which was 4 individuals, spoke to it directly at 33%. And then lastly, recreation, 3, and that was at 25%. Now I listed these, and I only listed those areas where there was more than 1. So if there were 2 or more, then I listed it. So obviously that's why it doesn't add up to the total. But that's, this is a very crude way of doing it, but it gives us some sense as to, what maybe we might put on the community survey at election. And it also, like I say, will help to possibly validate, where's this committee's head, at least initially.
2 or more, Peter, of anywhere in a person's ranking?
Sure.
Is that that's how
Sure.
you count it? Yeah.
Yeah, 2 or more.
Good.
And there were, I think, 6. If I was to add anything to it, I guess I would say that I'd probably add property taxes and climate preparedness. Those were also mentioned. They were only ones, which surprises me. It really surprises me. I'm just going to hand this out real quick. Thank you. Just shoot those down. This is on the website. As Sue mentioned, there's a wealth of information that's on there. These are rather large documents, so you can obtain the whole thing on the website if you just search it. This is the 2014 Town of Raymond Citizen Survey that Dawn alluded to it at I think the last meeting. Wow. When I look at the demographic, I believe you said something in the over 10,000 range in order to do this.
Yeah, it was the bids, if you will, range from about 12,000 thereabouts to almost 20,000.
Yeah.
And then I was charged with negotiating it down to 10, which I did.
Yeah, good for you. Yeah. But this is obviously, when I read it anyway, I've seen a lot of documents, and this is a pretty class survey. Also, 2 things that's interesting in this survey that I read were that at least Pan Atlantic, which is the group that conducted it, said that Raymond was, especially for its size, this was an exceptional endeavor, that there aren't a lot of towns that had actually dug this deep into a formal scientific survey of the citizens' feelings. And so that struck me. And the second thing was, I believe I saw that it was above average return. There were over 500 returns. That being said, there were 2 surveys to every household, right? One that was online and one that was paper. So, it was a pretty good outreach as well to try and survey the community. So this is dated information. I would certainly encourage everyone to go to the website. I don't know if you have to send these. They're on the website and they're all very accessible. I found it no problem. And it would be well worth your while just to look at it a little bit. But if you look at the second page, some interesting things as far as what can change and what stays the same over less than a decade. And so number 1, what's number 1 on the survey?
Taxes.
There you go.
What was interesting to me was that people wanted to keep taxes low, but wanted to expand services and improve the levels of government and do a lot of other interesting stuff. But they valued the low tax rate as well. So that's somewhat of a dilemma. But it's manageable though. You'd have to do things in a phased way, in an incremental way. But I was struck by that.
Struck by number 3, leaving the RSU. Things have a way of changing in a relatively short period of time. I mean, I'm not going to get into a discussion tonight about it. It's just that a lot of things happened between the 2 towns as far as interactions over that period of time. But an interesting one. Any other thoughts as we kind of scan this real quick?
Just natural resources landing in the top 5.
Yep.
And we're seeing that tonight.
Correct. I agree.
It's a good point. But yeah, the taxes is the big one that didn't even register on our little board survey, right?
No, absolutely not.
number 8 is interesting because we talk about housing. Number 8 is talking about attracting younger families to provide opportunities for young people. And I think that goes a lot with what we were saying, which was in our top 3 as well. So it's
Housing.
hasn't changed since 2014, still important people.
No, and I agree with that. You know, as I was looking at this and I'm saying, gee, where is housing? I mean, we were all identifying right up in front as, you know, we've got to really attend to housing in the community. But I think that's really buried right in there. It took me a minute to
Housing is the
uncover it.
root cause, I think.
Any other thoughts?
Number 6 is interesting in the context of having the middle school available and how it seems like such a feasible option at
Absolutely.
this stage now that we've got a physical location available.
Sure, and that kind of ties in with number 9, I would say, as well.
Mhm.
So,
I'm struck also by the number of things on here that actually happened. You know, the infrastructure was improved. We defeated milfoil. You know, so let's see, open space, you know, the Pismire Mountain Preserve, not town, but some additional hundreds of acres and additions to the Morgan Meadows. So yeah, that all happened, and attracting young families, not so much. Controlling growth, I don't know about that either, but there are many things that I think happened, and so it's not, maybe some of those things are not as urgent as they were then. I mean, certainly the infrastructure, the road system has come a long way.
I would agree with
We
that.
put a lot of money in that.
Absolutely, and it was high on the list as far as the review.
And we've kept taxes low, relatively speaking.
Correct, which I guess says
You achieve number 1.
You can achieve these things.
I should say that, because that always seems to be the top goal.
So if there's no other discussion, I'd just say that this might be something of a document that when you look at it, it gives you some idea, or it gave me a great idea of just what's involved in a comprehensive survey. I don't know that we'll be commissioning something to this degree unless it was something that would, you know, it's part of the town, so, you know, if it's something that is expensive to do.
Yeah, on that score, I mean, it's something you could request. I mean, you're going to have to build a budget and decide what you want to do. And this was something I wanted to do for a long time, and I think Pat Murphy did a great job on it.
Yeah.
It was really a bridge between a 10-year-old comp plan in 2014 and an update for it. A pretty cost-effective one, an informative one. There's still good data in there.
So you could look at what was happening in '04. Normally, comp plans are done on a 10-year cycle. So here's 10 years.
Yeah.
And now you're almost 10 years again. So I think, you know, Peter's right. It's instructive. It would tell you what people were thinking 10 years after the original plan.
And how things change.
And you look at the original plan, right?
Yeah. It seems like I've been thinking about the town meeting board sticker, or, you know, stop for an opinion. I'm not saying it's not a good idea, and there's probably a version of it that would be effective in guiding us. But, you know, given the content and the amount of material in a comprehensive survey, it might be hard to get anything really meaningful at town meeting, you know, that was brief enough to have folks participate in, and you know, simple enough to understand and achieve it as folks are walking out. It would be a relatively small sample, fair to say. How many folks coming through at voting?
Probably about 2,000.
2,000 coming through, half the voters, maybe a little more than that. And so we might see 10% of them stop.
I'm not sure.
Not half.
What did you see for the blacksmith shop?
We had about 20.
Yeah.
20%.
Mm-hmm.
We went after them though.
And I believe recycling committee did something similar at election, and I believe there was something like 40 or 50 signatures to sign up for recycling barrels. So absolutely, I think all of these attempts, short of you know, this type of a thing, is not going to be totally comprehensive. I was thinking, in part, just looking at this, that a lot of the demographic data we're going to be acquiring anyway. we're gonna be acquiring it for the plan. So that at some point, marrying the two somehow would be expedient a little bit, maybe a little cost effective since we're doing it. To collect all that demographic data that we are going to do for this comprehensive plan, if we let it sit 3 or 4 or 5 years, then it's not relevant anymore.
Right.
So, and then lastly, my sense was, and correct me if I'm wrong, this is kind of, we were looking at this as the opening salvo. This was, hey, we're here, I know we're gonna do it in other ways, we're gonna put it on electric signs, we're gonna have handouts at the town hall and other things that I believe we're gonna discuss. We might have jumped a little ahead in the agenda, but we were gonna do these things in order to get that initial salvo up, to kind of engage people. I believe as Brad was talking about at the last meeting, we want this to be a community committee. You know, it's got to be more than we're going to get a cursory input from them. What we want to do is really know what the community wants, and by that, I guess it means, you know, a sampling of it. Hopefully, the larger the sampling, the better. But that's all we're going to get. Everybody that can vote in this community doesn't vote, so that's just the way it is. Anyway, so if there's no further discussion on basically just this item as far as the survey is concerned, how about what if we were to put together a quick 8 or 10 items for the November elections, where we had something that was really quick, and this is where between now and then we would have to, you know, put in a certain amount of work in designing it, because certainly we don't want to try and design it tonight. But basically, if there's a subcommittee or something that wants to get together to look at something in the next couple of weeks that could be put together, I personally like the idea of the quick sticker thing. And but what we need to know, and also I believe what was mentioned was that there would be some sort of a notice along with it saying, you know, this is just the beginning, folks. This is Raymond's future, folks. Get engaged, expect more from us. We're going to be reaching out to you. So it's a quick, even if they don't stop to put a sticker on a board, if they just see something, a board that's printed with that message, then it's, oh, you know, it's just another form of getting the word out.
It would help frame the, perhaps inform the RFP too, assuming that the RFP isn't going to go out before then, which I would be surprised if we did.
Yeah, I'd be surprised if it would.
Yeah. So if you had all 15 of these items on the board and everyone gets 3, you know, a red, a green, and a yellow sticker, or something like that, and they put them under, they vote their money. They vote their stickers.
I was kind of, because I was thinking, how are we going to do this? And some of what we think are our priorities are sort of more exact, and we need to kind of think on a whole level. So I was thinking just the same idea where we have like a 1, 2, and 3. So your first priority is maybe green and, you know, whatever color. And we have broad categories, and I was maybe thinking of sticking with what the comprehensive plan laid them out. Wasn't that like natural resources was one of the major categories, just to get a general idea of where people are falling.
Yeah,
I'm trying to think of the other, I can't think of off the top of my head right now, but it was like what, municipal services or
yeah, I believe we've done that. Like I say, I believe we've done that.
Yeah.
We captured 6, and I just suggested 2 more, taxation and
The challenge is going to be to get something that is simple enough and quick enough for people to do, because they come out of there fairly quickly. And, you know, I like the idea of the stickers, but I don't know if that's going to be logistically, you know, you're there, you're thinking, you're putting stickers on. You know, I don't know if that works or not. I'd ask Sue, you know, but the flow and go of people is at times going to be, you know, fairly
significant. Drop something in a jar.
And then alternatives, like you could hand something that would be easy enough to do, and an alternative to, you know, drop it off at the town office or something, so if people didn't have the time. And then I think there also has to be a category, I mean, as well as we've, I guess, presaged what might be the issues for other, something we don't have. Those are just my general thoughts. So it has to be simple to do, and it has to give them an opportunity for something else beyond what we have, I think.
And with the flow, if you're going to have them, like Don said, standing there kind of deciding, oh, do I want to put it here, do I want to put it there? You might almost need one on either side of the aisle going out, so that more than one person can be doing it,
Yeah.
so that you aren't. you
So
don't
I
end up with a
read
queue.
down the basically the categories I used in order to calculate what this committee was saying. Housing, town services, water quality, natural resources, land use, transportation, recreation. I mean, I read that in less than 30 seconds, I'm sure. So I'm just wondering, is that too general? I'd like some feedback. Is that too general if you were doing an exit thing? And you said, I think it's, my top three are housing, transportation, and recreation.
No, I think that's perfect because it's not quick if you're having to read through 20 different options.
Sure. I guess I have a hard time letting go of the fact that what I'd really like to get personally is some feedback from the community early on as to, are we even on the right base or not? I'm probably pretty convinced we are, given those very general, and certainly it's got to go with a disclaimer. It's clear that, this is just the preliminary survey, and, we're going to get a more comprehensive survey to you.
Brad had his hands.
Yes. Sorry, Brad.
Yeah, just a quick question for Don or Sue. Do we have a community email like complan@raymond.org or anything that we could, if we don't have one, could we set something up that's relatively simple that can go to the committee co-chairs or someone?
Yes.
Yes, we can do that easily.
Okay, just something that's easy to remember, easy to spell for people who can't, whatever. Something really simple, and if we can get that out with this survey, then the people who can't take time, look, just take this with you, take a look at it. You can email back to us or questions, but I think it would be great to start publicizing that.
Any other thoughts? I guess what I'd ask Sue is this, because I'm just estimating. If we were to do something at the next election, how much forenotice does the town need to do that?
Since I don't have any staff that can do anything with it, you can just walk in that morning and be fine as long as you have people to do it.
All right, so we're not up against a deadline as far as the town's concerned?
No, not at all.
Right, okay.
It would be nice to know a little bit early, and I set up the night before. We go into the gym at 3 o'clock to set up. So it'd be nice to know how big your stuff is. I already have 2 or 3 petitioners that are going to be there. So I'd need to know, do you need a table? Do you need some chairs? That kind of logistical stuff is all I would need.
Okay, thank you.
Yeah, and the other thing that I've made myself a note for, I'm going to put a link to the 2014 survey on the comp plan page, so you can go there and get it.
Terrific, thank you. Okay, so where would the board like to go with this? As far as, I guess I'd define it to the election.
I like the list that you had created. I'd be interested to see if we could just add one more, though. I'm curious about how people feel about developing the business district. Do people want to see more business in Raymond, or do they want to keep that out of Raymond? I'd be interested to know what the consensus on that is.
Sure.
Can I interject here from Zoom? I'm wondering too if we, I imagine that there may be a handful of voters that would want to stop and talk with us a little bit more about what's going on and what we're doing. And I wonder if there's maybe include a detailed page or a printout or something that we can hand out, and we can chat and have a conversation with those that actually want to stop and talk about it with us.
Okay, thank you.
You were surprised on the sustainability. I was surprised on broadband. We're working really hard, and I know that's your thing too.
Absolutely.
And I think that's essential for the future.
Absolutely.
And but I don't know how to get at that. It wasn't something that the committee thought, I guess, was as high. And we really need to, I think, demonstrate if we're going to get grant funding that it's an important thing to the community somehow.
I agree, Don. And I think when I reviewed basically answers from the committee, I saw a lot of that probably in either infrastructure or public services.
Okay.
That sort of a thing. So it's in there. It's just, like I say, sometimes you get extracted from it because there's such broad categories. And I was looking at it as an eye as far as keeping it as small and quick as possible.
Yeah, I mean, it might be helpful if we have whatever, there's 10 chapters in the 2004 plan. And there's, would you have, Peter, 7, 6?
I think, well, you know, it's up to about 8 or 9 now.
I've got 8,
So,
but
so
I
maybe
need
you
this
have,
one.
maybe you have broad categories.
Couple bullets
Underneath,
under.
you have a little
Good
more
description.
detail.
Yeah, but
Sure.
what each one kind of covers in
Includes, you know, one
Yeah.
word. Services includes broadband.
Yep.
And
Or
other things.
infrastructure would also include that.
Or maybe it better fits better under infrastructure, yeah.
So how would the committee like to go? Is this something that we would look at a subcommittee kind of getting together and just putting something like that together?
I think that makes the most sense.
Okay. Can I ask for some volunteers? All right, Frank?
What are the volunteers for?
It would be for a subcommittee to draft.
Oh.
Yeah?
Yep.
So 3, would that do?
Sure.
Okay. And I guess your charge would be to get together, certainly electronically would be the easiest way. Look at I would say, look at the meeting minutes and what we've discussed and, you know, decide, you know, what format you'd want to present it to, or I think I've heard several formats. There would be a handout and there would also be possibly a board for scoring. Terrific.
Format and content.
Yeah.
One of the things we did at with Pat Murphy and Pan Atlantic was to make it available in different ways. So that's something I remember as well.
Absolutely.
Yeah, and one of the options could be to put it on our website because Kevin
Sure.
can create the same type of survey there if you wanted to give them.
I feel like we would want to do something more comprehensive at a later time, though.
Oh, yeah.
I think maybe the purpose of this is just an initial snapshot.
First brush. Yeah.
It is.
Yeah.
It is.
Yeah.
I think what I saw is that one of the previous minutes, Sue, what you had included was a preliminary community survey at the election, on the town website, in the October Roadrunner, at town office, and advertise on the Facebook page and the electronic sign.
Yes, so we can do all of those things. Whether you want to with this first go or not is really up to you.
So I throw that to the subcommittee as well, if you're working on it.
And I'm sorry, I missed the members of the subcommittee. So I got Brad and who?
Danielle and Frank.
And, okay, thank you.
Could I suggest maybe one of the co-chairs be there also on that?
I'll be
Just to
there
keep
for you,
us
Fred.
straight?
I'll be there for you.
Terrific. Very good. So if there's no further discussion on that.
Mr. Chair?
Yes.
If I could, and I'm not sure if you want to do this, but it is a suggestion. We do have 2 people here that are joining us one from the state, one from St. Joseph's College. And in the interest of not having them sit through some of our tediousness.
Absolutely, absolutely. So, unanimous consent to change the order of the agenda without exception.
Agreed.
Yeah, okay. So, who do we have?
We have Tom, and I'm sorry, Tom, I know I will mess your surname up if I try it.
Maraglianolo.
That's fine. Tom M. That's fine. That works.
Well, thanks for joining us tonight.
Yeah, no problem. I don't know. I guess I'll just kind of spiel for a minute here, and then I guess the best thing is just open it up for questions. I don't know what order you'd like to take things. Typically, normally what I'm doing now, I just want to make sure, is there anyone from GPCOG in the meeting now or no?
The town of Raymond is not a member of GPCOG.
I understand that.
Okay.
So we pay GPCOG $45,000 a year to do this. And so they're typically the contact, whether you pay dues or you're a member or not. And an example, that's very common for everyone doesn't pay dues to their regional council. That's common, but we fund the regional councils. GPCOG does tend to be less active. I understand that. And other councils are much more active. But just letting you know, it is a resource out there, for you. It's supposed to be there for you. And so this is the type of, they've been working on Long Island's plan for years. I don't even think Long Island gave them a penny. Years, it's now in my hands, but that's a resource. So anyway, so I just wanted to double check to see sort of where they are. I was looking at your last, Sue, the material you just sent me a few minutes ago, the PDF that had, the agenda and stuff. I just scrolled through it while you guys were talking. And I just saw like Rich wrote on the last plan and stuff, and it just, it was good to see some of those names were in the mix. Just hoping, I didn't know if maybe they were back this time, that's all. So just a quick background. Again, Tom Mariola from DACF, Department of Agriculture, Conservation and Forestry. I've been around doing this in one form or another for 23 years or so. And I was at the State Planning Office in sort of the Evan Rickert days back in the King administration. I've been the sole reviewer of comp plans for a few years now. So I review plans for the statewide. I'm just trying to think what we want to cover. So I also do the data sets. So when I say I do the data sets, so what that is, and I've done that on and off pretty much in 2006 or 5 or so. The intent of the comp plan review criteria rule. So I noticed in the minutes that I got from Sue, towards the back there was the statute, a portion of the Growth Management Act, which is great and helpful. It might be a little high level for the committee. I usually say, when I talk to a chair, I say, the chair needs to know that, right? or the CEO or something, right? Town manager. But one step below the statute is the comp plan review criteria rule. And I apologize, you may have gone over some of this. That's chapter 208. And so that is the rule that the state that I use to review comp plans. And so that's what you're going to want to have sort of in your pocket as you're drafting this. It also lays out the process, sort of like what do I do when, what do you do when, that type of thing. How do you appeal it? That kind of thing. And then one step, and then I don't even think the committee even needs the rule. I mean, it's good to know it's there and get a copy of it. But I think when you start actually writing the comp plan and reviewing sections, the checklist, which I'm assuming most of you have seen, that is a copy and paste from the rule. Sort of, I call it the cliff notes. It's kind of like the cliff notes of the rule, and it boils it down to something less than 20 pages. And it's what I use. I keep a stack of them right next to me here. I was using one this morning. That's what I use when I review a plan. So it's just running through a list of what's required. I don't want to get too in the weeds. Just tell me how deep you want to get here. But when it comes to requirements, there are, the way the rules are written is like a black and white. There's, this is what's required, and that's it, right? Well, after doing this for some time, there always is this sort of in-between gray area. You have to use some judgment. No plan, almost no plan, ever covers every one of those. I mean, there's 20 pages. It's probably, I never counted, 250 items, right, that I look for. And so some of those things just aren't going to matter. The word cargo port, how big is your cargo port, right? It's just not, it's not something that's going to apply. Maybe a train terminal, or, it's just things that may not apply to most accounts. And they're pretty obvious when you come across them. And then there'll be items where maybe they're not statutorily required, because some of those items are statutorily required. If they're statutorily required, I'm going to kick them back to you. So I was reviewing Rockland this morning. I think I found 3 things. I found 4 total things, 3 of which word statute that they must be in the comp plan. It's found consistent. So try to focus on those. So there's not many 1 or 2 or 3 or 4 things that are probably going to hang you up, but there are sort of like more important ones. And that's where an experience might come in with a consultant. And you have the checklist right on our website, and you can do your own review. And I'd say 2/3 of the plans I get, they've already completed that checklist to the best they can, and which makes a good case for a consistent plan. I'm sure I'm forgetting things. You guys want to talk about timelines, or where would you like to take this?
Tom, I've got a question in the agenda later on. What we're going to be doing is looking at the town draft of an RFP for a contract planner. And so we'll be looking at the elements. They look pretty comprehensive to me, but we'll be reviewing that. So we definitely are planning on engaging a contract planner.
Okay, I quickly looked at that just as you guys were talking about minutes, I think.
Yeah.
And the only thing that jumped out that is very commonly forgotten, to me it kind of always I see it sometimes in burn towns in the end, is if I was to spend public funds to hire someone to do a job, no matter what, I don't care if you're plowing roads or cutting trees or doing a comp plan, I would want them to have done one before, right? And so, I mean, and you can sort that out when they come in, obviously, you can look at their experience, but I would want someone that has done a plan in Maine in the last, say, 12 years, something like that. I only say in Maine, and I'll give an example. I think this will hit home. If you looked at our website now, you'll see Kennebunkport is on my list. I don't know, it's probably 4th in line to get reviewed. And so Kennebunkport went out to bid, and they hired a consultant for a $360,000 contract. And mind you, when they hired him, this is 2019, the average comprehensive plan contract for a consultant was probably in the 23 to 35,000 range, on average. There were some higher and some lower. It wasn't unheard of to get an $18,000 contract on a comp plan, right? I mean, it doesn't happen anymore, but and so when you see a 360, it just blows your mind. It was just over the top. I mean, entire counties combined are at that amount. And so when I didn't even know one was selected yet. I just knew the RFP was out there. I knew it was a big budget. I don't follow that closely. And then I get a call from that consultant. And the question is, okay, now what do I do, right? Never done a plan in Maine, right? I mean, mind you, the plan has come in. I haven't reviewed it yet, but I looked at it. It's $360,000. It's a phenomenal plan. But I haven't read it yet, but it's over the top. And our minimum criteria is pretty low. It's a low bar. I think in most people's opinions, it's a pretty low bar. But when you hire someone that has never done a comp plan before, you want them to have done a comp plan that is in line with the intent, which would be to meet the minimum requirements, the low bar. And so you might get someone that's done a plan in another state, and they might come in with the same understanding of the criteria, but I don't know what other states' criteria is, but I guarantee it's not the same. So I will seek consultants that'll come in, they'll do a nice plan. It just doesn't. There was never any intent to meet that minimum criteria. So they find themselves having spent a lot of time, 2 years and 50 grand, and they have something that's not close. And I was on a phone call with Newcastle this morning. They did exactly that. They've now hired their regional counsel, and the regional counsel just connected with me today to let me know they've been hired and make that connection. But they're on a cleanup mission, basically, after they'd hired a consultant that had never done a comp plan.
Yeah. We're not going to spend $300,000, and we're going to get somebody who has experience. I've been doing this for a while. I hired Evan Rickert when he first got into the business, so we're going to be okay on that point.
And that's the town manager.
Okay, good.
Yeah, we know what we're doing.
Good, gotcha.
Tom, could you answer this for me? In reviewing the RFP and the statute as well, and it sounds like this checklist would help a lot as far as looking at, as you allude to, what is and what is not statute. But I came across something I was unsure about. In the RFP, it states, in our draft RFP, it states that the consultant's work will result in the plan consistent with Growth Management Act of the state of Maine. That being said, further down, it has kind of one of the tasks of the contract planner is to basically the consultant will assess how the consistency with state statute might support or hinder the proposed goals and policies of the town. So it seemed to me those were kind of in conflict, unless you can describe to me, is it in the growth management plan where there's the section on addressing conflicts, where the town planner and the committee actually state their case for, let's say, why we aren't able to do 10% affordable housing in all new projects?
Yeah. In some cases, possibly. The example you use about 10% affordable housing, that's in statute. That has to be in a plan no matter what. So that's like probably the biggest red light, just because it's specific in statute. But in other cases, let's say, I think I heard the question right. Let's say there's something I sometimes will get will be like forestry, forestry. And this was in Scarborough, and the plan was silent on forestry in Scarborough. And so Scarborough has commercial forests in there, and they have timber harvest data, and we provided as part of our data sets, the data sets that we compile, we provided their harvest data. So it showed how many acres of softwood, hardwood, were harvested in town. And so it was like, well, you can't be silent on it. It is existing. There is that activity going on. You had more harvesting than a lot of other towns had, a lot of smaller towns, honestly. But and so, I think that's what you're saying. Like, a consultant can certainly, any comp plan can make a case for why a particular criteria doesn't apply to them. So there is something not applicable. Like that is something that exists. So you certainly can do that. Is that what you were getting at?
Yeah, I believe that's what was described in the draft RFP that I read.
Yeah.
Was the fact that would be the responsibility of the contract planner to basically look at what we're saying or what we're asking for, and then providing guidance as far as, well, that's not really something that the town is in line with the town's goals.
Yeah, and if it's kind of touching on the same thing, which I thought you might have said when you first started the question, I thought you were going, was if it's important to the town that it be consistent with the Growth Management Act, if this is an ultimate goal, then I would write right in the contract. It may not have to be in the RFP necessarily, but usually RFPs mimic the contract, or vice versa. The contract mimics the RFP, but you might want them to complete the checklist before you pay them that last payment. Again, this experience, this is the town of Georgetown. They made final payment, and the consultant had never considered the criteria as being reviewed under. And I'd done that list of 250 items, and there was 150 missing, right? And they'd already paid, and the consultant was out of their hair, right? I mean, it was paid. So a final task may be something like when it's getting ready to get submitted to the state, that they complete that checklist for your own use, just so you know that if that's the intent, is that the town wants to meet the minimum criteria, then I would think they would be able to do that. I don't think that's asking too much. I mean, especially when you're reviewing a chapter, some chapters have 15 things that we're looking for, right? And most of them they're going to catch just by accident. I mean, honestly, they're kind of like, I call them like mom and apple pie things, where it's like things that you're just gonna talk about traffic, you're gonna talk about the lakes or water quality. They're just things you're gonna catch anyway. So sometimes those consultants catch them by accident, and they didn't do it purposely, which is fine. But sometimes when you're not looking at the whole criteria, you miss some. So.
Other questions from the committee for Tom?
Great info.
I could talk about just the process real quick. I mean, it's really
Sure.
quick. So
I think
when
Brad has a question. Brad?
Oops, you're muted, Brad.
You're muted.
Just wondering, your experience is wonderful, and you're not here to sell us anything, which is even better. Can you give us a timeline of what goes into the different timelines that it takes different communities? For example, would a city like Portland take longer than Raymond because it has more to do, or would it be sooner because it has more resources to do all of that? What goes into what takes, and how long should a plan for a community like Raymond take us?
Yeah, I would have a goal of having it complete in 18 months. That'd be a goal. I say that kind of for two reasons. One, if you have a consultant, it's expensive. So if you drag this out, it's just going to get more expensive. And having a consultant can hurry things up for that reason. So the consultant wants to get done, and they want to move on to their next project. So that, no question, can help. And if you have volunteer committees and they're dragging over in that 18-month range, they're going to burn out. The turnover might increase. I usually encourage towns to start with more volunteers than you think you need. If you want 8, if you want 6, start with 8 or 10, and then expect attrition to happen. You might find yourselves in 18 months bringing on 4 new members that don't like the direction, or what's a comp plan, or why are we doing this, and then you kind of find yourself repeating things. And then you lose the more experienced volunteers, then fall off because here we are again, right? That'd be so 18 months would be the goal I would shoot for. If I was to write a contract, ideally it would be in that range. It has been done quicker by volunteer committees that usually are purpose-built. These are committees that when projects come to town and they want to organize. Maybe they're a Lupsy town, they're not an organized town, and they want to organize. One of the things of organizing is doing your own enforcement, having your own. There's a process. So I've seen them come in and they'll do a comp plan in 6 months, right? I mean, there's the case I'm thinking of. There's 26 residents of the town, so they just did it themselves quickly. Does that get at it? Brad?
Just one follow-up here is, tell me what 18 months is. Is that having approval from the town, or is it ready to go to the town, or?
It's all over. So I mean, I could use the cases of my own town. I was the chair of my planning board, and I had my own town. I mean, ours went closer to, well, maybe a little closer to 2 years, but probably the slowest part of my town's process was the state review. So, and not necessarily blaming myself, but the last 2 times my town has submitted a plan, or I've submitted a plan to myself, I would have to go find somebody else that never reviews comp plans to review it, right? Just so there wasn't a conflict of interest. And so they don't know how to do it. They get confused, and then I end up doing a draft for them, giving it to them, and then they disagree with what I thought of my own plan. And so so it's going to be all over the place. It's just sort of the time for me. I think that's kind of a given. No one's going to think 3 years out. No one's going to think 6 months out, I don't think. So it's kind of a safe ground. It's a goal. Once you have a contractor on board, it's looked like on your schedule, you're talking about early spring, late winter, having a contractor potentially. And so if you set that contract at something, I don't know, it kind of depends where you stand, and if you, where you are, and who's doing the mapping, and if your public outreach is complete or almost complete, or if you're going to do but I don't know. That contract could be 16 months. I don't know. It doesn't really matter. Once the town has a complete copy, and you're happy with it, depending on the way your ordinances are set up, and the planning board may have to look at it, the select board. But we typically, there's a submittal form. You'll have the chief elected official sign it. You'll have the chair of the comprehensive planning committee sign it. You'll submit to the state one PDF of the whole plan. You'll submit 1 hard copy. And then when it lands on my desk on a typical year, and this year has not been typical, But every year prior has been, for 20 plus years, we don't miss deadlines normally, though I did look in 2004, there was a delay in your review, it looks like, 2 months or something. But typically it comes in, once it comes into our desk, I send out the public comment, I send out notification to all your budding communities, I send out notification to about 11 state agencies for public comment, and your regional council gets CC'd on everything, and then it goes out, there's 25 business days for me to receive public comment. I typically don't get any public comments. I'll typically just get comments from the state agencies, which are technically our public comments. And then after that 25 days, I then have 10 days to review it for completeness. That is basically saying every part of the plan is consistent with the up to and not including the future land use plan. I review that. I have 10 days to review that. And then assuming the future land use plan, assuming that is all consistent, then I move on. I have 10 additional days to review the future land use plan. Typically, I squish that down into the 25 plus 10, so it's 35 business days. So what's that, 7-8 weeks? So you're looking at like a 2-month state review. Like I said, this year is not typical. I think I have something like 10 in the pipeline on my desk now. I usually have 2 or something. So there is a wait. I'm probably almost 2 months behind right now on reviews.
At what point, Tom, does the town have to adopt it? I would assume after you've approved it.
So it can happen either way. Either way. So it's almost 50-50, but I'll tell you, no question about it, it's much easier to have it reviewed by me than to, if you send it to me first, it's me. It's a guy sitting in his dining room reviewing your plan. It's simple, me and you, right? And it's not a bureaucracy. It's just me and where you are in line. So it's very easy. If there's something missing, a typical review is like I did with Rockland. I kick back 4 things, these 4 things. I bet they'll respond this week on those 4 items. So it's very easy and flexible. I don't know what the word I'm looking for, but it's easy to work with me. We can just, okay, these 4 are missing. I just got an email from the chair, and here he has the 4, or he's saying he will put them on page 55, and then I can write that consistency letter, and you can vote on it. If you do it the other way, you're going to have the statutorily required public hearing. So you're going to have a public hearing on the vote, right? And 30 days prior, and then you're going to have the public hearing. You're going to have the vote. The notifications, right? You see where I'm going, right? It's going to go out, it's going to get voted on. Maybe you're standing up, the chair's up in the gym talking about how great the plan is and trying to get the votes at the town meeting, and then it gets approved, and then 2 months later you're like, ah, crap, it's missing 3 things, right? And it would have taken 10 minutes to just insert those things, right? Just an example, right? And so it's a lot, that way you kind of have egg on your face, and here we are 6 months later going back to November election or something on the comp plan when the town just voted on it. Now they have to vote on it again because you changed something, right? Does that make sense?
Yes.
Okay.
Well, the other side of that is, what if the town votes down sections of it after you've approved it?
No, we'll vote it as a whole.
Doesn't happen.
Yeah.
Doesn't happen.
Yeah, you could. You could come back after the vote with you can come back again and again and again. I can't stop you from bringing different drafts to me.
It just seems to me, my recollection is we had some challenges, Sue, last time around, and when we came to the town. Is that your recollection, John?
Yeah, but it passed. I mean, we didn't have to make revisions, or perhaps we did, but it passed the one time it came to town meeting for a vote, was my recollection.
That's what the minutes show, yes.
Yeah.
The town meeting was a different thing then, too. Presumably, if you have enough public hearings and enough opportunity for people who are interested to have input, they're going to know about it, they're going to have an opinion about it, you will have addressed somehow the concerns. We don't get hundreds of people at town meeting anymore. It's a different environment. It's a different population. I think it'll be completely different than the 2004, which passed, as I recall, pretty easily.
Other committee questions for Tom? Tom, very informative, thank you.
Okay, thank you.
I get the sense that this won't be the last time we're talking to you, but we do appreciate you
No
being
problem, and I'm available for questions. Sue has my email. Just zip questions all the time. That's fine.
Great,
Very
thank you
good.
so much.
Thank you.
Yeah, no problem. Thank you, guys.
Excellent.
And the other person we have is McKenna Smith from St. Joseph College. And she was asked to talk about what interns might be able to do for us, or what possibilities there may be there.
Excellent, excellent. Love to hear from you.
Thank you for having me. I apologize if I talk fast. I'm from the South, but the one northern thing about me is I talk really fast. So you are welcome to ask me to slow down. My name is McKenna Smith. I'm the new graduate assistant for the Mercy Center here at St. Joe's. And one of my duties is to hire student workers who work with different organizations in the community who help run service projects. One of those things that we were talking about that could happen with that is we could hire them to be an intern for you guys. So that way, if you need help with your office, they would come in about 4 hours a week and do what you need. You would use them for how you would need them, but they would be hired through our office.
Great.
Very good. I didn't think you talked too fast. The only thing I didn't catch was your first name?
McKenna Smith. Well, my first name is McKenna.
McKenna, okay. Questions for McKenna?
So McKenna, would presumably, if we got a planner on board and made some note of it in our RFP to the planner that we hired, and they had a bunch of natural resource information to collect from the state of Maine or whatever traffic information from DOT, your intern could assist with that if our planner was agreeable?
Yeah. The way that we see the program working is however the organizations need the students to be used, and as long as that work can be done within 4 hours a week, that's totally fine with us. It's to create community involvement with our students.
Don?
I think it's a great idea. The question that I have, though, is I'm unfamiliar with the curriculum offerings of St. Joseph's. I know my alma mater no longer has public administration due to lack of interest, I guess. But I'm wondering if you have congruent, fields of study majors that would, dovetail what we're doing. Because it would be important to have someone not only for their own experience, but, for efficiency and added value for us, someone who is studying something pretty directly related to what we're doing.
Yeah, absolutely. So St. Joe's just created a new major, and let me find it so I can make sure I get the name of the program right. I believe it's Leadership and Sustainability, and there are 4 different tracks with it. And those tracks include politics, which I think would fit right in with what you guys do. There's one that's a science route. There's a public health course as well. So I think there are options and ways that we could recruit from.
That sounds good. Thank you.
Excellent. Other questions for McKenna?
Would it be possible to have more than one intern if we had, seeing that we have 8 to 10 chapters to cover in our upcoming comp plan? It might well be that we need more than one intern to have the expertise that would line up with that chapter.
Yeah, I would need to double check with my boss on that one. I don't see that being an issue. It's more of the issue of can I hire the students, because unfortunately our students are stretched thin as it is, so I want to make sure I can get you at least one.
Can you go over the 4 hours? I kind of missed what you said. 4 hours a week is the maximum we could use a student for?
Yes, so out of our office, about 4 hours is what we're able to pay per student.
So this is different. Normally, when I interned in Cape Elizabeth, Scarborough 40 odd years ago, the town paid. So you're saying you pay?
Yes, sir.
That's
so
interesting.
Our office does a work-study program, and so work-study students apply through our office for these positions.
How can we say no? I think it's a great deal, and I don't know how it worked out. I hooked you up with Sharon. Are you working with us on the beautification committee?
Yes.
Great.
I have my student worker either started today or tomorrow. I need to follow up and see how that went.
I think it's great.
Yes.
Would it be possible to hire the intern for more hours on our dime?
I can double check. I don't see that being an issue, but I'm also new and I want to make sure I get approval before I tell you yes to anything.
Okay, thank you.
All right, well, McKenna, we thank you very much. What would the next steps be for this committee? Do we need to formally request, or do you get in touch with Sue?
I can stay in touch with Sue and I will make sure, I'm continuing the hiring process on my end. So I will make sure that our students know that you guys are an option for them to apply to.
Terrific.
Excellent. Thank you.
Thank you very much.
I would like to make one comment about St. Joseph's while I have you. You know, the integration between St. Joseph's and the communities is really exceptional on a lot of levels, and so I want to call that out and thank the college. I've never seen anything like it, actually. It's really, really something. So appreciate it. Very appreciated, and you know, we have a lot of connections. We work together on the broadband. We work together on a lot of local issues. So it's a very good relationship.
Thank you. I hope that continues.
Very good. Okay.
Have a wonderful night. Thank you for having me.
Thank you. Thank you. Anyone else?
Oh, that was it.
That was it, okay. All right, so real quickly under an update on the boat and bus tour. If you could, Sue, just update us and maybe we can clarify it for all the members right now, what and if we can do as far as either of those tours.
There we are. What I have is a note from Public Safety, and there are 2 dates that they could do. One is next Thursday in the morning, so that's October 13th, or if that wouldn't work, possibly Saturday the 15th. If we go too much after that, it's getting a little bit cold.
And this is the boat?
This is the boat.
I want to share as well that my offer to captain a boat is no longer available. The boat club is shut down after the 1st of October. So.
Sure.
Oh, okay.
Well, thank you for the offer anyway, Jackie. Appreciate it.
Will we still need to be able, if we all went on one day, would everybody still be able to go on one day, or would we still have to possibly split it up between 2 days?
Well, I mean, just speaking for myself, neither of those dates work for me, so there's one other spot on the boat. I mean, I just think that it's possible that not all of us could attend anyway, but getting an idea of who could attend would let us know that.
We could probably do both dates, but I think it would be better to do the one date. So pick out the date that works the best, and you know, that's the one I would do. You know, I can't do I have a commitment on the weekend of the 15th, but I don't need to. I don't actually need to do it. I think it's the committee that needs to do it.
The capacity including crew?
10.
10.
So I think if you want Saturday, that's fine. If you want Thursday, that's fine. I mean, if we have an overwhelming interest, maybe we could do 2. Or we could get an additional boat or a bigger boat somehow. We need a bigger boat.
Yeah. I'd be available for both, but just to put my availability at 13th, so Thursday would be just fine with me.
You said the 13th?
Yeah, I would be able to do both, but if I were to pick one.
How does that work for everybody else?
I think I can do it.
Possible. Maybe a show of hands, we just get a count. So
Yeah.
1, 2.
What time are we talking on Thursday?
In the morning.
11 o'clock or 9 o'clock or?
We don't have it that nailed down.
As early as you want to go.
Yeah.
Between 6 and noon.
Okay.
And it looks like we'd be under the capacity, just with a show of hands here. 2 crew.
2 crew.
Yeah.
2 crew.
Okay. So should we just follow up with Sue, or Sue, will you follow up with us as far as the time, and we'll go for the 13th?
Yes.
Okay.
Awesome.
Good.
So that I will.
Very good. New business. I think Tom covered a lot of what we would talk about as far as reviewing elements of the growth management plan, Title 38. Sounds like Kayla and I are the only persons that need to understand that. I don't know if I necessarily agree with that. You know, sometimes, you know, citizen volunteers get short shift in this. You know, as I look around, I see a pretty astute group here. So, yes, Frank.
Are we still talking about the bus tour?
Oh, I'm sorry, you're right.
Oh.
Can we go back to bus tour?
And the bus tour, Joe had said he could pretty much do it in October at any time. So that's more when you folks are available, but no one sent me any availability, so.
The concern I have about that is also one of, you know, how many people are going to go. We have the large school bus, which would not be optimal. I would seek a minibus or something from the school, the RSU. So how many people want to go is important.
And Joe did say he might be able to get a smaller bus from not Raymond Rec, that's us.
Wyndham Rec, so that's another opportunity, but I think a smaller bus is going to be much better.
So can I just get a show of hands, just at first, interest in going on the bus tour?
Interested.
1, 2,
That's
3,
everything.
4, 5, 6,
Got a really good
7,
tour
8.
already.
Yeah.
Okay, so that would be 8 that would say they would be
Right,
interested.
so we'll work on getting a minibus, and do we have did we get the day?
You'd have to decide on a
Yeah.
day.
Yeah.
Hopefully that wouldn't be a whole day driving around.
No, it'd be a morning or in the afternoon, a couple
Couple
I would
hours,
think
maybe.
hours, you
Couple
probably do a
hours,
lot.
yeah, that'd be good.
Is it, I don't know if everyone has the calendars with them right now. If not, we could,
Maybe email me your availability and I'll see what there is for commonality.
Or we could shoot out some dates, is that what we want to do? Do you want to pick the dates now?
Is Joe the one that's going to be driving said bus?
He said it doesn't
Yes.
matter to him.
And he said
Oh,
he had.
he's completely open on whatever day and
He'll
whatever
make it
time.
happen.
He'll
Yeah,
make it happen.
He'll make it happen.
so how do we want to go about nailing down the date? Do we want to try and figure it out now?
Pick a date now, we're all here.
All right.
Save the electronic.
Yeah, about that following Thursday on the 20th.
Yeah, I think so, yeah. Yeah, we'd be, oh,
You're talking morning again? Yeah, I get it.
Yeah.
Morning.
I just want to make sure they know.
Preferred, but
They can have their tour guide.
well, it's better for me.
We're
Yeah,
talking
I
about
think.
20th AM, right?
Yep. Not a hat.
you were talking about who's going to lead the tour. I was thinking, you know, probably Chris more than Don. He's out in the town all the time. And knows-
Yes.
And on the lake.
I know that.
And on the lake.
By experience, yes, I know that,
Yeah.
absolutely. So we're looking at the 20th in the morning?
That's good.
Yeah.
Yeah.
That sound good for everyone? I will not be available for that, but having been 20 plus years on the zoning board of appeals, I've seen a lot of what Chris has seen. Very good. All right, let's get that nailed down. Everybody's all set?
I don't know if
Brad, are
Brad
you all
and
set?
Jackie heard, yeah.
Well, Brad.
Yeah, I
he
thought
raised his
part of
hand.
it.
Yeah, you
Are we saying morning of the 20th, Thursday the 20th?
for the bus.
Yes.
Yeah, that works.
Are there any alternate dates we could, that's, I have something on the 13th that blocks out the day, but I'll move that, but I need to move it to the 20th. So,
Murphy's Law.
is there another day? I mean, is a Saturday a possibility for something like that, or for that?
How about the 21st? That's a Friday.
It's the day before that Thursday is preparation till after midnight for something in the morning on the 21st. I still work for a living. I don't know about the rest of everybody here.
Yeah,
but
I was looking for a reason to skip work in the morning. And
Me too.
Does the 21st pose a problem?
I think
You
that
said that does work for me.
It does for you.
Oh, it does for him? Oh, okay.
How about 19 before we bump into the weekend?
I'm in
I
Boston.
might
I think.
propose.
I mean, this isn't like on the
I might
lake.
propose actually the 18th. The when? Sorry, go ahead, Brad.
I was just gonna say, this isn't like going out of the lake, so we could put this off, you know, till the leaves come down. I think anyway, like maybe the last week in October or first week in November or something?
It's up to you.
Yeah, I'd be okay with the last full week of October.
27, Thursday?
That works for me.
26 would be.
Thanksgiving.
Yeah, that's going to be.
No, that's November.
That's November, right?
Don't rush it yet.
Just waiting for that turkey.
I think maybe we need to ask you, Brad, what's your day?
27th works for me. I've got a big thing on the 26th, and that would be a great R&R after.
I'd be good for the 27th.
27 Thursday?
If it's in the morning.
Morning of the 27th.
What are we talking roughly? 3 hours here, or?
Ooh,
2 to 3, yeah.
Okay.
on the 2 side of 3.
So how does everyone feel about the 27th in the morning?
Well, good here.
Good.
Good here.
I may not be able to make it, but I may be able to make it, so just have to check.
Thank you. All right, then why don't we go with that, the 27th in the morning for the bus trip.
Good.
Okay.
This is going back to Tom, when he talks about 18 months. I think that's probably reasonable when you talk about the consultant time. It's totally unreasonable when you talk about all due municipal speed and trying to get this thing done. I've never seen one done in 18 months that includes the ramp up, which we're in now, and then some of the closure stuff.
Sure.
So I think the 2 to 3 years that we're talking about is more realistic, frankly.
Yeah. I was kind of having those same thoughts myself.
I've never seen one happen that quickly, soup to nuts. Maybe his part, maybe the consultant part, not the whole thing.
Should we add something to the RFP as a goal or not?
Well, I think for the consultant, that's a reasonable amount of time.
Yeah,
But
once we have
we're going to spend
a
6 months before we can get there, probably.
But we do have in there that it's a fixed amount, right?
Yeah,
So
but
that's
I don't understand that Kennebunk. That is completely out there. I've never heard anything like that, ever.
I'm going to be applying for Kennebunk.
So I guess what, we can talk about this a little bit more. We're going to talk about the draft RFP and certainly incorporate some of Tom's recommendations or observations as well. But I guess reviewing the growth management plan really quickly, although, as I said, it was a situation where, it may not be that everyone needs to be able to digest every word. And, whether or not you're comfortable with legalese or reading state statute or whatever, I can certainly appreciate Tom's observation there. But that being said, I did prepare a quick, I guess, cheat sheet or synopsis of the growth synopsis, a synopsis of the growth management program elements. And I think when you distill it down, the document down to one page, and you look at it, and you just look at the general part of it, at least for me, it gave me an idea of what elements are necessary in a comprehensive plan, which seemed to mirror a lot of what was in the 2004 approved comprehensive plan. So just really quickly, and I know everyone can read, but there's 4 subchapters. There's inventory and analysis, policy development, implementation strategy, and regional coordination program. And they're very detailed as far as each and every element is concerned, and you can get really bogged down in them. But as far as the inventory analysis, I think this committee's now looked at enough as far as plans to understand that a lot of it is demographic and economic information. That they want to hear about your clean water and what your plans are, what significant and critical natural resources there are, the commercial, forestry, and agricultural land, existing recreation, existing transportation, current housing stock, historical and archaeological resources, current and projected development patterns, and assessment of public services to protect health, safety, and welfare. So if you would use that, we would use that as a general outline as to what the state is looking for in a comprehensive plan. I am sure that a contract consultant is going to be much more detailed in this. But I believe for our level, we need to at least have this working framework to understand what the elements the state expects in a comprehensive plan. The second one, policy development, is basically just saying that you're going to look at the inventory and the analysis of that inventory and formulate policies that promote what you've identified as important issues for the town. Implementation strategy, and that really is, we're looking at this commitment of probably 2 to 3 years. That does not include the implementation. What the plan has in it is requirement is that you have a plan for implementation and what your strategies are.
Normally, there's an implementation committee that follows the comprehensive plan committee.
And then lastly, regional coordination program, I think something that's close to Don's heart, is a state requirement that what we do is at least attempt and say what we're willing to do and with our surrounding communities. Right. And I think that if I'm looking at things, especially public health, safety, and welfare, I don't see how communities like us are going to be able to go forward without huge amounts of investment in order to do that in the future. We're talking about the next 10 years. So certainly an important part. I just got this as a quick and dirty type of an outline for us to kind of work from. Any other? Yes.
I wanted to point out that right now in the regional coordination piece, the county is using some of their ARPA money to study that very thing, and there'll be a report completed shortly that'll talk about it by sub-region. So we'll be grouped with the towns that we would work with normally, and so that'll be a big help.
And does the state reach out to you, Don, as far as getting, or does the state reach out to individual municipalities and ask what you've been doing and what your plans are?
On regionalization?
Yeah.
They do not.
They don't.
This is the county that's doing this, but we've been pushing for this for a long time. The problem has been that the towns that we naturally interact with, except Wyndham, which we do interact with very closely, really weren't there in terms of their desire to do that. I'm talking the towns to the west of us. So I think that's changed, though. It's changed a lot. We're closer now in maybe the way that we do business and culture and so forth. And so I think that the report the county does is going to be very instructive on strategies and directions that we can work together that will benefit us all. So I'm really excited about that one. And they're paying for it with their ARPA money, so that's nice. We did do a study, by the way, about 10 or maybe 15 years ago. We studied that too. With the town of Casco was eligible to get a CDBG grant. They got that. We looked at consolidating public safety. We were all in. Casco and Naples were not all in. So even though that was their Casco study, Naples were not all in. So even though that was their Casco study, but so it never happened. But I still believe it should happen, and will happen. Has to happen. We don't have the resources otherwise.
Agreed. Any other observations as far as the growth management plan, the elements? All right.
I just have one question.
Sure.
The checklist with the 200 to 250 points, is that supplemental to this and a link somewhere, or because it's?
I thought he said, if I got.
Because I read through this, I didn't see 200.
No,
he said it was on their website.
It's
I
on the
plan on.
Okay, so it is a separate document.
I'll be finding it and making a link on their page.
I just looked at it a minute ago. It's on the link.
It is. Great.
It won't be a picnic to get one that they like.
Well, I mean, if we hire Tom to do it as well. No, no, I'm sorry. We won't be doing that.
It's a process.
Okay. Discuss in the draft RFP for the contract consultant planner. Thoughts, observations?
I thought it was a very good draft.
Yep. Good start.
My only major comment is that section 4, the proposal submission expectations, I thought mirrored a lot of section 8. Because it's essentially expectations and then requirements. And I didn't know whether we could just combine the two sections.
Can you tell them a little bit about what you did there, Sue? I think you combined some things already.
I plagiarized is what I did. I took York's. They seemed to be the most concise. And thought it would be better to start small and add to rather than start large and start cutting away.
Yeah.
So, but I didn't really look at it with that in mind so much.
I thought you had cut and paste. You didn't do that at all?
No, I took
Just
all
York?
of York's.
All of York's.
Yeah,
And
all
none
of
of
York's.
Kennebunk's.
None of Kennebunk's.
Just for fun though, York is the second most valuable community in the state of Maine. Did you know that? Behind Portland.
I did not.
That's right.
And I thought that they,
York.
on size-wise and
valuation
whatnot, I thought they probably lined up a little better with us than some of the others too. That was another reason I chose theirs. So, but we'll certainly look at those two sections. I didn't really look at it from that point of view.
Yeah, I thought it was really good. I mean, I thought it was nice and brief, which, you know, I think is helpful. You know, getting a really long RFP is more tedious when you kind of filter through those requirements through sort of the interview process and some of that kind of exchange. So.
Along the line of getting somebody experienced, the RFP, they're going to have seen this one, they're going to have seen, you know, others, the people that we want to consider, and the field is going to be a lot smaller than it was in '04. But the point about it, getting somebody well experienced in doing these plans is right on. And you know, I won't say the RFP is not, you know, that huge a deal, but it's really not that huge a deal. I mean, you're going to be interviewing these people, you're going to be looking at the experience, you're going to be telling them what to do once you hire them.
Sure.
So.
And I believe what was discussed earlier is that there may be a subcommittee of this committee that actually will do the interviews. So
exactly.
It won't require all of us to be doing that. So as we get closer, we'll be making.
And these people, they want to. He did make the point that they want to get in and out and get this done. If they've done this before, they're going to know what to do.
Yeah.
They're going to know what that checklist is.
Exactly.
Yes.
They're going to know Rule 208 inside and out.
Yeah.
In state statute.
This is a bit of a formality, something you have to do, obviously, to have a good process, but and to make sure that you're fair and open, transparent, all that stuff.
Absolutely.
And that's what this is about. Yeah. But what's going to be important is that interview and selecting the person that fits us.
Sure. And I think, you know, certainly Tom's observations are helpful. I guess what I would say is in looking at the policy that the town has. I mean, as far as when you go in for it's not just an interview with this committee, but they're going to actually go in with HR and have an interview. And so there's also going to be contractual and requirements that'll be there that incumbent on the applicants.
Yeah. You absolutely want to submit the plan before you have it voted on. You absolutely don't want to pay them their final payment until the thing gets approved.
Yes.
Sure. Sure. So any of the comments that Tom had, do we think that those might need to be included in the draft? I think he was talking about some sort of time frame for
I took some notes on that, and I thought if I put those in and then send the draft out to all of you folks for next meeting, possibly.
Does that work for everyone?
Yeah. The only thought I had on the RFP was that it will get 3 or 4, 2 or 3, not more than one. Probably less than 5, and they'll each be somewhat unique in the proposer's approach, and then costing and fee statements for those services. So it won't be as easy to compare apples and apples if you had a matrix of, you know, and cost per meeting or whatever, and cost to you know, do the inventory. And some of the other stuff obviously couldn't be because it might go in different directions, but and I think that's fine. We just have to be ready to review those qualitatively different proposals with probably different pricing arrangements, and they'll each be individual, and we won't be able to really compare apples to apples so much other than looking at the whole picture. It'll require us to do a thoughtful review of the proposal, so that's good.
Yeah, exactly. And you know, I look at it like you're hiring an employee. You'll want to have a standardized set of questions. You'll want to have like you say, you'll want to be able to have some sort of a spreadsheet or something that will delineate all those factors and compare them so that you can do that in a handy format. And so, you know, absolutely. Yeah.
Yeah, I kind of agree. I think they're all going to be, they're organizations, so it's not going to be one person. It's going to be an organization of staff. They're going to have, it'd be like interviewing for a law firm to represent the town. You got big town lawyers, and you've got little town lawyers, and all the ones in between. And I think that they're not going to be apples and apples. Right. It's going to be a mixed bag, and we're going to have to pick the right fit. And I think that, the subcommittee and then report back, I think that'll work really well. And obviously, the town staff will be involved in that, and we'll have the town attorney review the RFPs, and before we sign a contract, it'll all be reviewed, and we'll be good to go.
Good.
Now, I don't know if you want to do this or not, but normally when you go for architectural services, you do it cost blind, so you do your interviews, and you have a separate envelope for the pricing, and they're very sensitive about that. I found out years ago building a new town office, so, I mean, you don't actually have to select, the person who has, I guess, the lowest cost, and I guess the bias would be that, maybe the best fit may not be the person with the lowest cost, so you consider the cost and the quality of the proposal separately, I guess, is the qualification-based search sort of way of doing it. I don't know if you like that or not, but typically we always look at the cost here, and then they say, now go negotiate a better deal. So you tell me what you like, I'll do it either way.
Well, and I think where the apples to apples can come in is once you have an RFP, you can, with their proposal, go through, okay, number one, did they answer that question? What was their answer? Number two, and have some apples to apples that way, just based on what they get back. And that's what I've done in the past with some.
But I guess that's a ways away. You can talk about that when you get ready to do a lot of this when you get ready to do interviewing.
Yes.
I don't know if I probably could have asked the question better to Tom, but maybe the municipal side or the legal side can help me understand this a little bit. So it seems as I read the management plan, and it talks about statute. And I believe right in the first, as far as the draft RFP, I found in the introduction, page 1, what made me feel comfortable, which was it states that the work will result in a plan consistent with the Growth Management Act of the state of Maine. So it's almost kind of as Chris and Don are observing, it's they're gonna basically do what they do. We're not gonna hire someone who has not had this experience from the legal vantage as well as every other situation.
Yeah. It's almost impossible to believe that a town would spend $300,000 and hire somebody who had never done a plan. That's almost impossible.
I know, it's like they didn't look at the resumes.
Yeah.
Well, towns are different. It's I'll call it a Falmouth solution. Years ago, they couldn't decide between the two top planners, so they hired them both. So that's kind of what you have with Kennebunkport.
Along with that, make that feel good that right in the RFP, they're going to have to comply with state. Yeah, the growth management plan, which kind of then covers everything.
Yeah, I actually really appreciated Tom's comments on the way in which this is interpreted, because one of the questions that you're always wondering when looking at legal statutes is how strictly do they follow these statutes? And sometimes, and he mentioned Chapter 208, which is my next stop. So it sounds like there's much more reliance on that in the checklist than what's necessarily built in here, because you can interpret a lot of these words in a lot of different ways, which gives you wiggle room to do or to create a plan that works with your municipality, which goes back to the finding the best fit for what our town actually is.
Well said, Danielle. And that's kind of where I have this little conundrum, because on as I read to Tom, on page 6, the consultant will assess how consistency with the state statute might support or hinder the proposed goals and policies of the town. That almost seems, it's kind of in conflict. If I guess my question is, does the amendment to the state constitution regarding home rule cover any of this?
Well, and then my next question to you is, what does consistent mean? And so there's a,
sure.
I don't know the answer to your question. So it's having an opinion like that as to what they hold in priority is really important to us, because that that gives us our perspective on how we want to interpret this.
Sure. And the sense I got was that Tom will know
Yes.
the consistency
Right.
definition.
Exactly.
What I heard, it was black and white, but.
Exactly. It's clear as mud.
I mean, to melt it right down, that's what I heard.
Absolutely. And so I guess ultimately I think that the draft very closely followed the policy I read that the town has for RFPs, which I'm glad we have that. And you know, I'd ask, are there any more? Because one element that was in the growth management plan was a section that said addressing conflicts. And it seemed to me in reading it that it meant that in the plan, if you're not going to be consistent, because it's not in the town's best interest, then you at least have to provide some sort of explanation as to why. I mean, it'd be simple if it's one of the elements is the harbor front. Well, that wouldn't be hard for Raymond to necessarily deal with as far as explaining. You know, if you live in the desert, forestry probably wouldn't be something that's going to come up a lot. So you'd be exempt from that simply by saying, we don't have any trees. We don't have a waterfront.
Right, right.
But then others, as I said, and I hate to keep harping on this, but when the state says that 10% of all new construction needs to be affordable housing, and over the last decade and a half, I have asked that of select board members and municipal officials, has the town of Maine ever reached that? The answer is no.
Not even close.
So we've been non-compliant with that portion of it, which Tom seemed to think is kind of a real hot button. But I guess getting back to Danielle's observation, I don't see Dawn getting hauled away. You know, I don't see a lien on my house from the state. So I guess that would be my question.
They're still gonna take our tax money.
Well, they are.
And given there's no, as I understand it, no requirement now, I mean, we're doing this for us.
Yeah.
I mean, we need to be compliant with the, I guess, the strictures, the law, whatever, as it may still exist, but to me, this is for us.
And I think
if every plan was the same, you know, I mean.
They just hand it out.
Just hand it out. And I had to laugh about my hometown of Scarborough. I mean, of course they wouldn't think of forests. There's very few forests left. When I grew up there, it was a dairy town. I mean, that's not where they're at today.
Yeah.
I think something we can think about too is finding a candidate who is well versed in what these changes are and these hot topics are, because we've had legal changes that will impact this since this has been published in November of 2021.
Sure.
So these aren't, what we're reading isn't necessarily up to date because it hasn't been amended yet specifically. So I think the hot topics will guide discussion to a certain extent, whether that's ours or our communities. And so finding someone who has a tab on that will be important as we're looking at this, in the sense that this is specifically for the next 10 years, and we're really trying to make sure we abide by what we want to do for the next 10 years.
Yeah.
I have only one other suggestion. You know, be popular, maybe popular, I don't know. Under page 3 of the RFP, project area, I think the third paragraph down, it starts to describe the history of the town of Raymond. And I would like to add 2 lines and make 1 word change. The 2 lines would be that paragraph starts with, today Raymond residents live on traditional land of the Wabanaki Confederacy. The Algonquin word for Waban-Aki is most often translated into Dawn Land. And then the next sentence, if we could just insert the word European, the first European settlers, and that would be my only other addition. I know it's just an RFP, but I would think at least for this committee, if we're going to be looking at land acknowledgement, then all the documents that come out of this should really have some sort of land acknowledgement if it's getting into describing our history.
I agree. It's to have that, I guess, delineated for us is helpful. something that we have, we talked about that before, but I think Sue just probably pulled this out of, something.
Oh, sure.
Yeah,
Something we had at hand was standardized, but I absolutely agree.
I stole it from the previous.
It's all from the previous. Yeah, so no, I'm with you. I'm with you.
The biggest city in this state is just getting around to adding acknowledgements into their.
That's that paragraph that starts with the first.
Right.
The first row of settlers.
Yes.
And I'll make those changes.
Well, maybe as far as all of these suggestions for revision or changes, I guess for motion to accept them. Second. Any other discussion? All in favor? Oh. Yeah.
So I'll incorporate them and have them sent to, or send them out with the next meeting so you can look at it.
Then when they do the next plan, that plan.
That'll be in there.
It'll be there.
Once you get it in there, that's it lasts forever.
That's the first thing you're
Planning.
There'll be a little footnote.
Yeah. That's what Brad is. Yeah. Brad.
No, I just asked Sue, did you get my abstention on that vote?
Oh, no, I didn't.
I did.
Okay.
I did. Saw it.
I will when I watch the tape, yes.
All right.
Okay, thank you. And I abstain just because I'd like to have more time for us to discuss that. And I don't like committees where somebody proposes something and we, and we vote on it without discussing it and dwelling on it. So that's why I abstain.
Yeah, and I apologize, Brad. I'm new to this electronic meeting type thing, so I should be looking up there more. I'll try and make that effort in the future so I can see you when you get your hand raised. Okay. I think we took care of new business. Is there any public comment?
Well, I'm not the public, but if I could, Mr. Chair, to get to Brad's point as far as the RFP goes, while you did just vote for me to incorporate those into the RFP, you haven't actually voted on the entire document and whether that's finished.
Good point.
So given that it really can be changed later, we aren't anywhere near to the point of having that set.
If you want to, you can have a subcommittee to look at it and report back.
Yes.
Yeah. Is anybody in favor of Don's suggestion?
You can do whatever you want. We'll make it, it's like Burger King, and you're the Burger King. However you like it.
So for now, I hope at least the committee members realize it's set in Jell-O.
Yeah.
Yeah, we'll do whatever you like. We're just trying to help move it along.
Sure. I'm all in favor of that. Okay, is there any public other than Sue I mentioned?
I don't think you have any public.
Okay, I'll close. Oh, yes,
I don't know if this is public or staff comment,
Yeah.
but I heard when Tom was talking, he talked about a contact at GPCOG.
Yes.
Would you like one of us to reach out to GPCOG?
Ooh, I think that's excellent.
I did.
I know a guy.
Good.
Here's my experience. I mean, he may know a guy, but $45,000 for whatever it is, the number of municipalities in Cumberland County. They're a transportation, in my view, organization these days. That's where the money is. We can reach out to them, but and maybe get some sort of guidance from them. But to me, the contract planner, the person that we hire, is going to have that expertise. That's who we're going to use. And I don't even know who they have planning there now. But
And
one of the
I
reasons
was told they didn't have any.
use them, and we ended up going a different direction. That was to hire our own contract planner, as you know, from Sebago Technics. And but before that, we had Hugh Cox, and we had Bob Ponce. So we've always had a contract planner.
But we did work with Carol in Paris there.
Yeah, 'cause they told me they no longer do planning.
No longer do planning.
I
Is
don't
what
know. I wasn't
that was like
bringing
a
it
month
up for
ago.
that. Worked with in the past.
But if you can
I'm
find
in
someone.
having Chris. Chris, I'm in favor of having you reach out, just see what's out there.
It's an easy phone call.
Yep, how's the committee feel? Brad's in favor.
What harm's it going to do?
Maybe just relative to transportation, if that's their specialty. It's absolutely a topic on our comp plan.
Maybe that's all we'll get.
Maybe that's all we,
But
then that might be a worthwhile phone call to learn.
I think you have to be very clear when you talk to them that you're talking about that this, area of planning that's financed by the state of Maine, because we're not a member, and anything we do with them as a non-member is by
from him. But I
No, I'm saying you make sure that get the
Make that
person
clear.
who they're financing at $45,000.
Right.
The other services are by the hour. So if you call up and make sure they understand what the context of what you're asking
We're working against the 45K tab
for the whole county.
for the whole county, yeah.
Okay. And just a quick question, because you mentioned it, Dawn, as far as our contract planner, they would not be applying for this RFP because of a conflict of interest, right? They're already contracted with the town?
I don't know if they would apply. I don't know, as I would say, they're qualified. You know, they're more an engineering firm, technical analysis, that sort of thing. This is much broader. I don't think they could answer the question, we've done a comp plan.
Yeah, okay.
But I don't know that.
There'd probably be a meeting or two that they might well participate in. Jim,
Yeah.
Seymour.
He's very good.
Having trouble. Jim, not that you wouldn't be able to, Chris, but it might be helpful to have him for a meeting or have a meeting or something.
Well, I'm sure he'd be willing to do that.
Yeah.
We should call on anybody and everybody who can help us. I'm all for it.
I'm all for that.
And I like the intern idea, by the way, really a lot.
Excellent, absolutely. Yeah, and a great thought as far as being, if necessary, if we. All right, as far as committee comments, any observations or comments?
On the schedule, if he started in March of 23, June of 25, attrition risk. And I think it's just inherent on us to stay focused as best we can and get through the chapters. And a good planner will hopefully help us do that. But I think that schedule shouldn't be out of reach, a 2025 June town meeting to get a vote on the final plan. If there's some kind of check marks along the way, see how we're doing in terms of scope, schedule, and budget.
Any other committee comments? Jackie, Brad? Yes, Brad.
I do. A couple. First off, it would really be helpful for me and perhaps other committee members if, before we conclude our meetings, if there are bullet points that whoever's chairing the meeting can just reiterate, okay, here's what we're going to do. We formed a committee of, for the election day survey, whatever. Here's who's on it. We've got boat tours on this day. We've got bus tour on this day. Here's who's going to coordinate the bus tour. If it's Sue, it probably ought to be somebody. And then, Sue, if I can ask this of either you or of Kayla or keep wanting to call you Charlie, I'm sorry. But if we could ask, one of you who are in leadership to get that right out to us so we don't have miscommunication issues like we had on the previous tour. So again, what I'm asking is a summary of bullet points before we close the meeting, when our next meeting is included in that, and then if Sue or somebody could get this out to all the committee members.
Yeah, I think my only thought at this point is, I'm one of those types of people that really likes to see a roadmap laid out and general time frame for what we're working towards in the next meeting or in the next couple meetings. And I'm just wondering if we want to kind of, maybe not tonight, but at the next meeting, talk about kind of a general time that's per quarter. What is our goal in this next 3 months, and how are we going to achieve that, and what are the steps that we can take to make that happen. I know Sue does a lot of the work behind the scenes.
And what I would ask is that most of that information should be contained in the minutes, and definitely we can look at having that on the next agenda to look at some sort of a rough timeline for different elements. I think that's what I'm hearing. What element are we going to look at? Are we going to look at water? Are we going to look at housing? That type of a thing. Thank you, Jackie. I love electronics. Okay, a motion to adjourn?
So
did my action points get anywhere?
They're going to be in the minutes.
But nobody summarized them at all for, I mean, when...
Was everyone clear on?
Yeah, I mean, it seems a little bit duplicative, Brad, I will say that. I mean, Sue, you generally, I thought you've done an excellent job at the minutes.
Oh, thank you.
And I know I wouldn't come clear to do it, Brad, it would be a mess. And your minutes are generally out in...
I try to get them out within a week.
In a week.
Tell you for this week. What I can do if you would like me to co-chairs is to go through what we have a subcommittee that's been formed to draft what's going to be presented at the election on June 8th, the upcoming boat tour on October 13th. I'll be sending out a time to the committees, and hopefully I'll do that within the next day or two. On October 27th in the morning, there'll be if you see anything that you'd like to change, like some of your verbiage, for instance, with the history as an example, because it's still a draft document, the committee members could just send them to me and I could include them before first Wednesday. So that would put us at the 2nd of November.
Beforehand, and I think it's wonderful. It just is, I realize there's an awful lot on your plate, and this isn't the primary responsibility you have. And when there are action flows smoothly, and that's why I brought it up. So,
all right.
Now, one question can I ask? Are we firm then the first Wednesday of every month until otherwise we can put on our calendars for meeting at 6:30?
I believe the discussion was that it's at least through to the December.
Yes.
That's when the calendar meetings would be.
Okay.
So that's the first Wednesday of the month.
November 2, December 7. That's as far as we've gone.
Yeah. Yes. Okay. Thank you.
Certainly. There's a motion to adjourn in a second. All in. Good night.
Okay, welcome to the Town of Raymond Special Town Meeting. Greetings. In the name of the state of Maine, I am hereby required to notify and warn the inhabitants of the town of Raymond qualified by law to vote in town affairs to meet at the broadcast studio at 423 Webbs Mills Road in said town on Tuesday, August 9th, 2022 at 6 p.m., then and there to act on Articles 1 and 2 set out below. Article 1, to elect a moderator to preside at said meeting. I'll entertain a motion.
I'll move Joe Bruno for moderator.
Second.
Okay.
You guys all set?
Joe Bruno.
Okay.
Thank you.
Which Brendan?
Huh?
Joe Bruno.
Need help spelling that? How do you spell that?
Maybe you don't.
It is unanimous, sir?
Okay. I need a piece of one.
Yes. Hope I can remember.
I will.
I, Joe Bruno, swear that I will perform to the best of my abilities.
All right, welcome everyone.
It is in the beginning of your package.
Yeah. All right. Thank you. We're here to vote fund balance, the surplus, the sum of $23,200 to help circa 1820 to the Raymond Casco Historical Society campus. The select board recommends Article. Second. Any? Nope. Step up to the microphone. Make it hard, Joe. So.
Hi, is this on? Yeah. My name's Alan Stone, and I live up on Spiller Hill Road. In 1971, the Maine State Legislature stated that it is the policy of the state to preserve the architecture benefits of these resources. I'm just going to gives a community its unique character. Historic preservation provides a link to the roots of the community and its people. Overall, historic preservation, culturally, a community is richer for having the tangible presence of past eras and historic styles. Economically, a community benefits when the community is attractive to visitors seeking heritage tourism opportunities. Socially, a community benefits when citizens take pride in its history and mutual demolished and disposed of in the community landfill of the past and the resultant cultural respect by its citizens. Historic preservation is an important investment in Raymond's present and future. Thank you.
Okay, thank you. Anybody else? Step right up.
Marilyn Westcott, 172 AI Road. I just wanted to ask a question. It's my understanding the town of Casco has committed $25,000.
For the major, if you pass it, yeah.
Okay. Anybody else? Do I have a motion to adjourn?
So moved.
Buddy, we get a little cool weather. I think you'd rather be sitting on your decks or in your backyard, but the Historical Society thanks you for this support. You don't know what this does for us, to know that people really care. Thank you so much. And come and see the blacksmith shop.
Okay, thank you. So before taxing program for freezing your property taxes through the state, if you are 65 and over, hopefully you can get an application at the town hall, or you can go online and get one. You need to submit it by September 1st. Now, December 1st. But there are some qualifications you need to meet. You have to be a permanent resident and have had the homestead exemption for 10 years. And if you meet those qualifications, your property taxes are frozen. So if you don't know about the program, look it up. Go
Welcome to the Wednesday, get the right date here.
October 12th.
Thanks. October 12th, 2022, Planning Board meeting for the town of Raymond. The board will come to order. We do have a quorum. We'll start with roll call. Mike?
Mike D'Arcangelo. Greg Foster.
Robert O'Neill. Minutes from September 14th. And then for new minutes, a public hearing review of a commercial use in the RR zone and a sketch plan review from Diane Potvin. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or state law. All persons speaking, including representatives of the applicant and members of the public, are asked to stand at the microphone to state their name, address, and affiliation with the application. All persons speaking shall address the chair. Any conversations must be held in abeyance until after the board has formally adjourned. After the board votes on the merits of each application, it will prepare a written notice of decision to the Superior Court, or as otherwise provided to file such an appeal. You must be certain appeal 45 days to Superior Court. Okay, the first order of business is the approval of the minutes for completions. I think we're okay.
Aye.
Right, thank you. And no opposed, and one abstention. Steve. Thanks, Mark. All right. Our next order of business is the public hearing for. Sandy, do you know?
Rob said he was trying to get in, but he was unsuccessful. He was getting meeting in progress.
Nothing showing for anybody waiting.
Rachel's son.
All right. Hey, Kevin.
Yes.
Where the problem might be?
I got in through Zoom, but I did not, so I'm not sure, Sandy, if you have.
Somewhere. Put the link.
So planning board, I'm going to there right now. Let's see, planning board. October. Okay, so planning board, October.
Kevin, what do you have for a meeting ID?
9. Oh, that's the password. Never mind. The ID ends in 8308.
Right.
Okay, and I have password 436517.
I have a password that's a lot longer than that, but it ends in QT09. Be let in?
Yep. Well, they're being told either meeting in progress or they're not letting people in. Is that, ma'am? Is that what you're being told?
Mm-hmm.
Did she go to the link from the town's website?
I don't know what she did, but.
Page of that agenda, there'll be the phone number and the contact and the ID to get in.
Well, you go to, you click on agenda, right, and then you go to where it says October, click on October. When you click on October, that brings you up a PDF which has the link in it.
Click on October.
And when they click on that, all they get is meeting in progress.
Well, we are in progress.
Click on
I know.
Right. Oh, we get it.
Once it's in progress, you can't get in. Go to the second page. And then what?
And then you should, if it's working properly.
It says the host has another meeting in progress.
I mean, I don't, Sandy, I'm not sure. Like I said, I went.
Barry says, me neither. I see a woman in a white skirt and red top.
Oh. What? White skirt and red top.
Oh, wait. Looks like a Zoom promo.
Huh.
But the video, I see a woman in a white skirt and red top, but the video is frozen.
Well, there is no white skirt and red top.
Okay, so
I don't know what to tell you. Maybe she's watching cartoons. I mean, 8, 5,
Run that through again, Kevin.
HG, as in George, 6.
Yep.
the Zoom app on my computer and entered that meeting ID and the passcode, and I got in. Which is different from the invitation link that you usually put up there anyway.
The Zoom app.
Go to Zoom app. I'm pretty sure. I mean, she's been working on the computer for years.
That's the other link is what we use that Sandy sends out.
2 pages of it. Oh, you'd have to ask Bill for that. He has that.
Thank you.
I know.
Oh.
I'm waiting to get.
I'll take that over this.
That's more important.
Yes.
Yeah. That's on the bright side. This is the first time we've had any kind of real problem with Zoom, right?
Yeah.
Barry says if he can't
Yeah.
get in, he'll complain tomorrow. I followed the link right on the town website.
What's he supposed to be doing?
He said,
Did he get the PDF?
I don't know, he just said if I can't get in, lawyer can't get in either. Jesus. I don't know.
I'm going to try opening that one that's on the website, which is different, worked fine.
MS?
Okay.
I have no idea.
I don't know what the M is Barry.
Okay.
Okay.
Right.
No, but she sent me the format or whatever, the link, the little picture.
Normally you just click on the link and you're in.
Mm-hmm.
Okay, so
See, so I just.
Oh, it's you. Oh, it's you. And you're in. And you're in.
Yep. So that works. That information works. Go to zoom.com or download the app and then put in that information and you get in. And it took about a minute to do all that.
Go to Zoom and download the app.
You could go to
Play
whatever.
Store or
What?
If it's on a computer, you go to zoom.com.
there are a number of people I can't get on, including the applicant.
And the lawyer.
Yeah, do we know why?
Edith.
Edith Titleist.
Right.
if you go
For me
to
title list.
the planning board page and click on
Title list to
October,
everyone, yes.
you'll be fine. You'll come up with the right thing. If you click on agenda, you
I mean, that's kind of where I'm headed with this here. We've got two very controversial applications where both the Starrett application and Port Harbor Marine I've been getting calls on all week, or for weeks, really.
Okay.
His lawyer can't get in either.
So then somebody.
be okay, but everybody can't do that because they have to be listening some other way to do it.
Right.
Yeah, if they're watching on the YouTube stream right now, maybe.
Can you get the announcement into the papers again for the next meeting?
For the next meeting, absolutely.
Okay.
Excuse me, guys.
Who's talking?
I'm Edith at Tattles, and I got in because I had to go to zoom.com directly, and then I had to type in the passcodes separately.
Right.
But I could not use.
When's the first you get into the paper?
Well, that's not the only problem, Bob. We have to have a date and make sure that everything else is ready. If we're going to just put it to November, I can send it out next week to get it in.
Oh. Ma'am, no, just don't worry about it. We're just going to.
All right.
Okay, so I am moving on from old business, the public hearing, site plan review for Jordan Bay Marina, Port Harbor Marine. Thanks, Phil.
Thanks, Bill.
Hopefully next month we'll get it.
Okay. Thank you very much.
We don't know what's going on. You're asking about who you emailed?
No, I don't know my email.
Who did you email?
I emailed
year and a half ago to complain about the starets, but yes, everybody, and so just kind of like, so,
Holy problems.
yeah, so I want to introduce myself.
Fortunately, we're not taking any comment.
Oh, I'm aware.
Yeah.
I'm very
But
aware.
please, stop by the town.
There are no complaints about the starets when there actually are complaints about the starets.
But that's for next meeting.
Okay.
Okay.
Yeah.
Thank you.
Thanks,
guys.
You're welcome.
So glad you
There's in Gorham. I'm here for Diane Pot History, and that is including the eastern, what's it called, Eastern Painted Turtle Road. It comes down through her property, and the 28 acres drops down below it, as you see in the outline. In the function of the building the road, we have turnouts and buffers and vegetative soil filters in connection with that road. So all that'll happen on each lot, what we need and what lots are included, and so we come back and properly identify for a subdivision through the preliminary and final. We did get a memo from the fire inspector, pretty straightforward, with the length of road exceeds 1,000 feet, which was amended in 2021, that ordinance. So we will have to provide an additional turnaround for the fire safety component. The proposed houses will include sprinkler systems, and will get involved with the road maintenance agreement. Diane owns this strip. Everyone has an easement across it, but it was part of her 28-acre parcel. So I've got to see what's in place now with the 4 lots down at the end as far as a road maintenance agreement. And then I guess, in Jim's memo, wetlands were not included for the lots. We'll have, through Jim and through the chair.
Lot that you have on here, there's 4 lots.
Cover the chair.
Lot that you have on here, there's 4 lots.
Correct.
That sit out there?
Yep.
Okay. And the road is to the standards for?
Surface, which I think is for the private.
So that would be 22 all.
Yep. They did a nice job. I was pretty pleased with when they built that road. They spared no expense. 9.
And the property developed now was obviously not part of that property?
That's correct. Yep.
So this is a right-of-way through here?
Okay, so the painted Turtle Road provided access to what is now Specialty Finance. I assume Diane Potvin retained rights to utilize.
So normally she would be able to, as part of an illegal subdivision, illegally created subdivision. So it normally would be exempt, and it probably in this case.
Yes. Okay. Kind of assessment though as to the clearing on each lot. Is there a limitation for?
So you're looking at some background.
But we definitely would have to have at least minimum erosion control for the individual
right.
lots.
Okay.
Something of that nature.
And the phosphorus.
Yeah, I think it's just a question of, and that may be just a statement that they're going to limit clearing to, a certain amount. Because we just don't want.
She's not going to build houses. She's just going to sell lots.
She's just
or
sell.
Give them to her family. And they're going to build a house. So.
Yeah, we control plan obviously for the individual lots.
40%. Alex, what was your number?
I thought it was 25, I believe.
For a clearing limit?
Yep, 25.
Yeah.
So that 40% didn't play out. Yep.
Received, so address those comments
the
as
fire
well.
Inspector. Yep, very clear.
I mean, really, it's really the septic systems and the well.
Were originally a part of it. It may be worth showing every single one of those separate.
Would that overall Cullen plan, would that be recorded as well?
It's more of a lotting
it would
plan,
probably, right? Yeah, it would need to be either part of this or a note on this subdivision plan or something, because this parcel comes from one gigantic parcel.
Subdivision plan together, then everybody else can feed off that as we go down the line. So you've got 2.
Yeah, I've got 2 of them, and then the I don't know what was the third project.
The Chase, Brandon Chase.
That
that was just stopped.
And that one, yeah, that one hasn't been you have all the information, so I think it would be easy for you to show all of the lots.
Need a name for this subdivision for town records. Okay.
Yeah. I mean,
the one at the end was named. It may be that because that name
I
goes
believe
away.
It is.
Yeah, it goes away after time.
For road?
Yeah.
Is eligible for open space?
5 would be eligible, I believe, yeah, because it's a. Oh, okay.
Since it's
like that's going to work out. So what I'm going to do for amendments for this year, I'm actually going to use that Word document for our amendments because that will, it's an entirely new format. There's a new table of contents and everything. So we're going to use that for this year just to get us ahead because that's going to likely go into effect in January. As far as amendments goes, I looked through my list today. I've got about 4 things, and it's mostly just cleanup. A few items that DEP had pointed out to us this summer when we sent them our current ordinance. I don't have a lot. I don't know if you guys, I know there was a couple of at now. Otherwise, it looks like it's going to be a much live as quickly as possible. So that's kind of the big thing.
So we would need a public hearing on this.
And Alex, maybe you've chimed in on this, is, you know, where is the town, because I know other communities are starting to adopt the AD.
Is going to change quite a bit before next July. And he didn't want to for June, but it didn't sound like he was expecting us to have to change anything.
Okay.
Instead of an A1.
Oh, okay, I'm sorry, I misunderstood, okay.
Yeah.
2, it might be 1, B, you know.
They codified them, they've reformatted them so that they're easier for referencing for them in the future. And I think, Alex, in the future, to all the records and looked at everything, even there might have been some things that may not have been impressed.
It's a reference to a section. So, you know, they went through it all. We did add on a legal analysis of both.
The ADU, the only other thing that I had on the top of my head, just because I remember getting it from Wayne, is Wayne has made, you know, we really don't have exactly in our ordinance. So I don't know if they're requesting things that we don't have necessarily in like our street standards.
Right.
So do we want to conform the fire standards to the street?
No, where did our stuff come from?
Which ones? The street stuff?
Yeah.
It's just been historical street standards, I think, that have been just modified. There's 2 different codes that could compete against each other. So do we want to sync, how do we want to sync these together is bottom line.
Right.
I think we just want to be careful and look at exactly what do we go against some of the other work we've done.
Yep. Yep.
So my goal for next, and I don't know that I'll have specific amendment language. I might have a couple and then just the entire.
Okay. You know, we
I do not have anything else.
Anything? You have anything?
I have nothing new.
Item 7 is next then.
Is this appropriate for me to ask about an item I'd like to see changed?
Oh, yeah, yes. Yeah, I'm sorry.
I would really add with that, but I just went to a meeting yesterday, and I know that people in that subdivision regarding the...
Oh, yeah, that...
Yeah. Bagel one?
If they don't get noticed, they're going to be really upset. So, both negative and positive. So, and I've been thinking about we say, well, it's just one lot, so it's only going to impact, you know.
Can't imagine the whole development's going to get to it.
Not,
yes, I believe they
like
do that now.
$150 or something.
Why so much?
It's going to be certified, right? No?
No, I don't think it has to be certified. Percolating to subdivide?
You know, I'm not sure. Because
a survey that's going to probably be at the polls in November.
Yeah.
Some kind of a simple survey. We had a list of bullet items.
We're done. You can sign us out.
Town of Raymond Special Town Meeting. Greetings. In the name of the state of Maine, I am hereby required to notify and warn the inhabitants of the town of Raymond. Okay.